Hey, what's up, guys? Welcome to Lost Planning the Interwebs. I'm your very, very late host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. And for that, I apologize. I did one of those blink things where you blink and then it's 30 minutes later. With me today is Mr. Andrew Branca.
Hey, there I am.
Oh, man.
Getting hard.
Hold on one second. I don't have you in the headphones. There we go. Sorry about that. What's up?
Getting hard.
Getting hard. Awesome. Always a good day when you're getting hard. I just missed Nate. Nate was in the green room right when I was starting the thing. And I feel really bad about being late. Okay. Well, that's what we've got. Okay.
So here's what's happening. The defense is presenting the testimony of a forensic pathologist who may be dead. They're presenting it as video testimony previously sworn.
That's amazing.
And you haven't missed anything, so I wouldn't rewind. I would just they just had the Hispanic girl at the defense table, who's apparently an attorney, read his credentials.
Okay. Very good. Let me see.
So he's a forensic and diagnostic radiologist. So I guess he's going to talk about x-rays of Reeves and how frail he is.
Oh, the audio is horrid.
Yeah. And like there are other defense experts, he was ridiculously credentialed.
All right, I'm about to bring it up. God, it's loud.
Basically is a form of invisible light, and it was discovered that if one focuses an X-ray and shoots it through a body part, say with film underneath, it can record images of the human body. So basically, an X-ray shows us bones very well. It allows us to see if there is a fracture or a dislocation, allows us to see if there are arthritic changes of the bones. And it's a common imaging study even today.
He was old.
X-ray does not show certain things, though, like you cannot see the spinal cord on a spine study. You do not see the disc. You do not see the spinal cord or the nerve roots. So if we want to see those types of findings, we need to go to a higher imaging study, which would be an MRI, which stands for magnetic resonance imaging, sometimes referred to as MR, magnetic resonance. And it basically is not an X-ray study. It doesn't use ionizing radiation. It takes advantage of the fact that our body is composed of about 75% water, H2O, and it was discovered that the hydrogen atoms in water, when put into a magnetic field, give off a magnetic resonance, a signal that can be picked up by the MRI scanner. And it can locate each and every one of those signals of the hydrogen atoms in a three-dimensional space and locate them in an X, Y, and Z plane. And so from all of this information, very accurate images can be constructed of the human body. So for the first time, we can accurately see the disc, the spinal cord, the nerve roots, brain tissue, all sorts of things that we couldn't see before on regular X-rays. So as you said, in this particular series of studies, we have X-rays and MRIs to look at.
Okay, and you arranged them in kind of a logical order, is that fair to say?
Yes, sir.
And where will you start?
We'll start right up at the top. I've got them labeled 1 through 11, so we can look at, first of all, the hands.
Let me ask you something before you get there. If you could pull it back a little bit, please. What is this writing we see on the image up on the left and the right-hand side?
Yes. So let me focus in on this. So this is just all the verification that the pictures we're looking at are of the particular patient we're talking about. So in this case, it says the imaging center Rose Radiology where the study was carried out. It says the patient's name, Curtis Reeves. It gives the date of birth, 8/31/42. States the patient is 72 years old. And then over here, this is telling us the date of the study. So this study was performed on 6/8/15, so June 8th, 2015. So most of the images that we're
The
going to
judge
look
was
at
coughing into the mic even back then.
June 8th, 2015, or the MRI studies that we look at were done on June 9th, 2015.
So what are we looking at here?
So these are views of the hands, the right hand and the left hand. And what we can see is arthritic changes of both hands. But I'll focus in on some of the findings so the jury and the judge can appreciate this. This is the thumb right here we're looking at. And all of these are bones of the wrist called carpal bones. If we focus into this area right here, we're looking at what is called the radiocarpal joint space, and this is the first metacarpal bone. One of the things to notice is how close the bone is to one another. So in other words, if we use this as an example here, notice that we see a space between this bone and this bone. That's because cartilage, which cannot be seen on an X-ray, separates the two pieces of bone. When the cartilage is worn down or worn out, we get this bone-on-bone appearance that we see here. So this would be an example of degenerative change of the first carpal metacarpal joint, where we literally have bone-on-bone. Also realize that bone reacts by when it develops degenerative change by trying to thicken up the bone. And the thickening of the bone causes the bone to appear denser on the X-ray, and dense bone will look white. So if we look down here at the radius, so we're right at the wrist, this is the radius, this is the ulna. Notice that the bone is very white here. That is sclerotic bone or thickening of bone. Notice the bone right here and right here is very white. So that is more sclerotic bone. Even note where we have the wearing out of cartilage right here, we also have this white line of sclerosis, which is a sign of degenerative change. As we look at the other bones throughout the body, or throughout the hand here, and this is the right hand, we can see narrowing of the interphalangeal joints. So the interphalangeal joints are the various joints of the fingers. And that narrowing is degenerative change there as well. Like sclerosis is degenerative change. So this patient has degenerative change, particularly at the so-called DIP, distal interphalangeal joints, which are the distal most aspect of the joint spaces of the hand. So, and the left hand has similar findings. If we go over here to the left hand, notice we have narrowing of the various joints of the wrist, narrowing and degenerative change of the first carpal metacarpal joint, and then as we go to the interphalangeal joints, we see
Yeah, but he seemed to be able to pull a trigger.
And narrowing of those joints. So basically, both hand films show degenerative changes, both left-sided and right-sided, involving the carpal bones and also involving the interphalangeal joints.
And so when you say degenerative changes, what are you talking about?
So degenerative change is sort of a broad umbrella term to refer to wearing out of the joint space. So we know as we age, we have been moving our body parts for years and years, and that can lead to those joint spaces and those various body parts to wear out. And that wearing out process is called degenerative change. So an analogy compared to like a tire of a car, if you just put a new set of tires on your car and drove the car for 10 miles and then checked the tread on the tire, it would be fine. Nothing much would be happening after 10 miles. But if you check those tires after 30,000 miles, the tread would be worn down to some degree. So that would be degenerative change in array or wearing out of the tire. Same kind of process is going on inside the human body, where we're slowly wearing out our various body parts over time.
And would you agree or disagree with me that those changes happen over a period of time and not overnight or maybe within the years?
But that's true. I mean, degenerative change in general takes years and years, so it's not something that pops up in 6 months or a year or something like that. It takes many years to get the kind of findings that we're seeing here.
Now, the individual with a similar X-ray, would it be consistent with somebody who, let's say, had trouble opening a jar?
Yes, well, particularly since we noticed that the degenerative change of the joints of the thumb are prominent in this patient. As we can see here, we see another nice demonstration of sclerosis of the bone. So typically, a patient with this kind of degenerative change in this location will have a weakness of hand grip, for instance. And one of the things that people tend to notice when they have that is that the jar, they can't open a jar. You know, you have a jar of pickles or mustard, can't get it open because the whole grip of the hand is not as strong as what it used to be.
And you talked about distal phalange, you talked about the fingertips?
So basically, right, that joint right before you get to the nail of the finger, this is where we're seeing degenerative change as well. So we're even seeing like this little osteophyte that's showing up right here.
What's an osteophyte?
So an osteophyte is basically a bony growth. Osteo means bone and phyte means growth. So the bone, by constant rubbing, bone on bone develops thickening of the bone that eventually turns into these bony osteophytes.
Hey, what's up, Nate?
The X-rays we're looking at concerning the fingers.
Hey, what's going on? What's going on? I was in the back. I'm listening to this too. What's up, guys?
Hey, Nate.
Hey, what's going on, Andrew? How you doing? I was watching you on Uncivil Law the other day. Kim Potter, great stuff, man. 100% right.
Yes, when you have degenerative change in the fingers,
I saw this morning that someone's apparently putting up Branca burns, cutting out my some of my commentary.
Well,
Selected portions.
I'm a racist misogynist now. So
Oh, well.
that's my new handle on Twitter.
Welcome to the party, pal.
F you guys. You forget. We're all racist. This is fucking ridiculous.
That was done on 6/8/15. And so now we can move to the wrists. Take a quick
Oh
look
God,
at
this
that.
audio is
So
brutal.
again, the wrists are this area of the hand. So that all of these carpal bones down here are part of the wrist. This is the
So I presume this guy must have died.
This is the ulna. And again, basically it's showing us.
You'd almost have to for them to play a video of it.
In the hands, just a more focused down view. And then already saw in the hands, just a more focused down view. And it particularly nicely demonstrates the bone-on-bone appearance of the degenerative change of the first carpal metacarpal joint. So there's literally seeing bone-on-bone here with the dense white sclerosis of the bone, particularly involving the region of the thumb of both hands.
Well, at least cross exam will be short.
I don't know, but it's probably on video too.
The next one we're going to do is
Shit.
shoulder. And the left shoulder.
I mean, he's testifying in court. I assume he was subject to cross.
Obviously, the humerus, the long bone in our upper arm.
I wonder if that's where they got the skeleton.
Articulates with the scapula, which commonly layman's term might be considered like a lean bone, but in medical terms, this complex appearing bone, as outlined here, is part of the scapula. And the scapula has a curved cup-like shape called the glenoid. And the humeral head articulates and connects into this glenoid area. This part that we're seeing here is the collarbone, and over here is the acromion, and this area right here. And if we look over here, this is called the AC joint or acromioclavicular joint. And what we're noticing is that the patient has osteophytic changes in this region as well. So this pointed piece of bone here and the pointed piece of bone here is arthritic change of the AC joint. If we move over here, we can again see some more osteophyte here and here. So the important point of seeing the degenerative change of the AC joint is to realize that the rotator cuff, the muscles, and then the tendons come through this region right here and connect to this area of bone called the greater tuberosity. So in this region is sometimes referred to as a critical zone. And so as someone attempts to lift their arm up, this muscle and tendon system works as a pulley to lift the humerus up from this edge, but the tendon tends to get scraped across these osteophytic changes that are right here, which can cause pain in any individual patient and can scrape the tendon to the point that the patient can eventually develop what is called a rotator cuff tear, where the tendon is actually frayed and kind of sawed through that area so that the tendon eventually becomes completely torn.
And what we're looking at, again, the same sort of question in terms of time period. Is this something that's degenerative in nature, that happens over a period of time, and not something that is the result of an acute injury, for instance?
That's true. Again, all these degenerative changes that we're pointing out typically take years to form. This is not something that you get in a relatively short period of time.
Well, apparently he's actually still alive.
So this is the left shoulder.
Oh, no kidding.
If we move over here, that was number 3.
Just must not have been able to make it for whatever
Number 4 would be the
reason.
right shoulder. If we look at this, not surprisingly, we see the same kind of findings. So here is the acromioclavicular joint. This is the clavicle right here. And this is the acromion process of the scapula. The space in between is the so-called AC joint or acromioclavicular joint. Perhaps the judge has heard of AC joint separation. Sometimes football players get this kind of thing where the AC joint is separated. But notice again here, just like on the left shoulder, we're now looking at the right shoulder, we see this bony osteophyte right here. And the critical nature of something like that is, again, the tendon of the rotator cuff passes through here and attaches over here. So with this piece of bone now in the way, it serves as a mechanism where it can scrape away and saw away, if you will, at the tendons of the rotator cuff, and can cause pain, can cause rotator cuff tear, for instance, in any individual patient.
Is an individual who has a X-ray like this, is it consistent with somebody who has difficulty raising their arm?
Well, it is because, realize again, the rotator cuff muscles and then the tendon come through this area and attach over here. I think you see it better on this, where it's the greater tuberosity. So if the muscle has to pull the tendon through this area, this tends to be painful. This often causes limitation in movement of the shoulders. It often causes the person not to use their shoulder so much because of the fact that it hurts when you do it. And so consequently, the muscles of the rotator cuff begin to lose mass and become what is called atrophy or shrink. So the muscles become smaller in size and become weaker. So it is not unusual when we see patients like this that they have limitation in range of motion, they have shoulder pain, the muscles in this region are often atrophied and gotten weaker over time.
And in older patients, we would expect some atrophy, whether or not we had such an acute, is that also called a bone spur?
Yes, a bone spur is the typical layman's term, for instance, for an osteophyte, which is a medical term that simply means osteobone tightening growth.
So my question was then,
If I was a juror, I'd be sleeping my ass off.
Yeah.
Well, I think that's true in almost every.
Sorry about that, boomering myself off the panel.
That's okay.
Shit, I almost fucking faded right now because it's so boring.
Workout and everything, it might help maintain some of the muscle mass, but
according to the chat, it said they said this entire video interview would last an hour and a couple minutes.
Despite our best attempts,
So it should be done before too terribly long.
Whose X-ray looked like this had difficulty in picking up heavy items.
Well, that's true. I mean, anytime you have to use the shoulder, you're going to be affecting this area, and it could be difficult in any particular patient to lift heavy items up, to move the shoulder in general because of the limitations by the AC joint arthritis.
And is there anything else you will see that is of interest, Doctor?
I think those are the main findings on that, the type of degenerative changes that can occur. And so here, just to go through the anatomy a little bit, this is called the femoral head right here. This is called the greater trochanter. This is where tendons attach from the muscles in our thigh. Right here is the hip joint. And notice that we again have this finding of this dense sclerosis along the 11 o'clock, 12 o'clock, 1 o'clock region of the acetabulum. And again, the acetabulum is the cup-like shape of the where the femoral head fits into the pelvis. So, and it makes sense that we would see something like that in this region because as a person is standing, they're putting a lot of pressure on the upper aspect of the acetabulum. And so the bone tries to add additional bone density, which creates a sclerosis, but is also a form of degenerative change. Also notice that one evaluates the vertical height between the femoral head here to there versus the vertical height of the femoral head from here to here. Notice that it's narrower here, and that again is a sign of degenerative change of the hip. Same kind of other finding though, remember we talked about the osteoporosis, how we have some dense bone here, but loosened bone over here, loosened bone over here, loosened bone over here. This is all evidence of osteopenia, osteoporosis of the bone.
Anything else remarkable about the hip we're looking at, Doctor?
I think that's about it for the time being. We can go now to the left knee. And this again,
I just can't wait till this audio's over.
I forgot to ask you.
Oh.
The X-ray of the hip and the degenerative properties that you described, is that something that we would expect to happen over time, as in the other X-rays?
Yes, again, typically degenerative change takes years.
Judge was hacking up a lung even then.
So this is not something that just pops up in a year or two. It generally takes many years. I got, having gray hair, I got related to a person, how long does it take to get gray hair? Many times you're not going to be able to say, my hair went totally gray.
If I was a juror, I'd be screaming not guilty because I had to watch this crap.
Yeah.
Just to hurt the state.
20s or 30, you got a few speckles of gray hair, and your 30s and 40s, you got more gray hair, and now it's going from gray to white, such that by the time you get in your 60s, you have all white hair. So you could look at something like that and feel fairly assured that they didn't go from brown or black hair to gray hair in a matter of a year or two. It typically would take many, many years, whether it's 5 years or 10 years or 20 years, who knows for sure in that individual, but it would take more than just a year or two. And so the same kind of thing with degenerative change inside the body. It doesn't happen in 1 or 2 years. It takes many, many years to get that.
On to the knee.
So we'll go to the left knee now, and this is 6
Going to do every bone in the body.
So I'll show the judge this one first.
Moving on to the morning wood.
So-called standing views of the knees. With the person standing up and the x-ray plate behind their knees and the x-ray shot straight through. So this is the left knee over here. This is the right knee over here. Just to go over some anatomy. This is the femur, which is the long bone of our thigh coming down to form part of the knee joint. This round piece of bone is the kneecap, or medically called a patella, right here and right over here. The two bones that are seen that go from the knee joint downward, the larger bone is called the tibia. Commonly people call this the shin bone.
This judge could definitely drink me under the table. She wakes up to a 24-pack of Budweiser.
This is that major, larger bone. The smaller bone out to the side.
Got a pontoon boat made out of empties.
Calf, both left side and right side. On the outer side is the fibula. And so these are the two bones of the lower knee joint. So the knee joint is actually this part right here, where the femur bone comes together with the joint space, and then the tibia here and the fibula here. And what we're seeing basically in this is that we're seeing the medial knee joint, medial meaning the inside of the knee joint is narrow. It should be wider than this. And if we compare to the lateral knee joint, it should have a nice vertical height like this, but right here, it's narrow both on the right side and on the left side. In addition, we see sclerosis, this white thickening of bone along the tibial plateau. This whole area is called the tibial plateau here. And we've already learned that the buildup or thickening of bone is called sclerosis, a sign of degenerative change, and losing the vertical height of the joint is also a sign of degenerative change.
Is this what the jury's really watching? Because I can't see anything that he's pointing to.
Typical for developing degenerative change in the knee, and that is it's affecting the
I can't imagine why they would be.
the knee joint. And the court may not know that in most people, it's the medial side of the knee joint that wears out first in almost all people, and that's because just the angle of the way the femur comes down when we stand, we put most of our weight on the medial aspect of the knees, and thus we tend to wear out.
So there's no question. This is just a presentation. There just was a question. Give a speech, and then he just started. like.
So it's quite common not only to get the degenerative.
This is just literally a presentation. There's not even no questions being asked.
But
Yeah.
also to get tears of the meniscus, the cartilage that fits in between these two bones. So the court may have heard of medial meniscal tears being discussed in other patients, other cases, and this is the reason why, is this is the area that gets the biggest workout. If we look at the side view or lateral view, and again, we're looking at left knee here, notice that we see this patella from the side, the kneecap, and notice that we see the patella lying very close to the femur, femoral condyle, almost bone on bone. Now realize the bone of the femur is capped by cartilage, and the back of the patella is capped by cartilage. So when one has degenerative change, the cartilage wears out and this bone-on-bone appearance begins to occur. And notice, if you want to see an osteophyte here, this pointed piece of bone right here is an osteophyte.
I wonder if they edited out some of the questions
So when this person is moving or walking
and made it
this
into a
patella would
presentation
be
form.
rubbing bone on bone in this region, and this osteophyte would be scraping on the cartilage and on bone. Kind of finding that we all can get when we get in our 70s, just from the use of our legs and our knees over time. So that was the left knee. If we go to number 8, which is the right knee, again, we already went over this front picture, the standing view, where we see the medial right knee joint narrow. But let's look at the side view for a second. And again, in this view, notice that the patella is high riding. That means we'd like to see this patella down more along this region. In other words, the top of this patella should be sitting down here more. And it's not, so one might question whether the person has had some previous injury to the tendons attaching to the patella. That would be the quadriceps tendon up here, attaching to the patella, and the patellar tendon down here. Nevertheless, we can see this bone-on-bone appearance, just like we saw in the left knee, on the right side, a sign of degenerative change of the meniscus. So basically, we have degenerative change of both knees, involving the medial knee joint and involving both what are called the patellofemoral joint, meaning the patella and the femur are narrowed in that area, that's called the patellofemoral joint.
Would you agree with me that we can't see pain on an X-ray?
That's correct. We can see the anatomy on X-rays and MRIs. We cannot tell what severity of pain the patient may be in at the time, just based on the X-ray or the MRI.
But based on what we're looking at, would it be inconsistent with an individual that complains of knee pain, for instance?
No, not at all. I mean, it's quite common when people have degenerative change in their knees like this that they would have pain.
And you're calling it degenerative changes, so we're talking about these changes happen over a period of time.
Yes, and typically many years. We then go, so at this point, we're going to go from the 6, 8 studies. We've covered all the regular X-ray studies, and now number 9, 10, and 11, we'd be covering the MRI cervical, MRI thoracic, MRI lumbar, done the next day on 6, 9, 15. Should we keep going?
Seriously, this judge
Let's do that.
Okay.
needs to get examined for whatever is causing her emphysemic cough.
How does a radiologist actually look at MRIs? Do they do it just in still images?
Okay, well, I'll show you.
Doctor, could you look at these lung X-rays of the judge?
This still more familiar to explain it about what this side view or sagittal view is and what this axial view. But if you'd like, I can just bring up the whole study so that the court can see how one would analyze a study. Is that okay? So if we open up this study, basically, you can see all the different images that were performed on this exam. We can see that 9 survey images were done, then 15 sagittal images, so-called T2 weighted, which makes the spinal fluid white, 13 sagittal or side view, so-called STII, STIR images, which allows us to see fluid signal particularly well. 13 T1 weighted images where the spinal fluid is back, and then 28 axial images. So to show the court how one might evaluate this, if we press on the sagittal images and make this larger so we can see it, Notice when we first start looking at the side view, and just for orientation, this would be the person's chin here, and this would be the back of the neck over here. We're not really seeing any cervical spine yet, and that's because this initial image is taken off to the side, and then as we move forward, we're beginning to now cut into the cervical spine. Now we're into the mid-cervical spine, where we can see spinal cord, and as we cut through, we're cutting out of the cervical spine, getting to the opposite side of the neck. So just toggling through this, there's certain things that we can see. What we're noticing here, if I zoom this up a little bit, this tall vertebral body in the cervical spine is called C2 or cervical 2. And then from there, once we identify that, we can count down to C3, cervical 4, cervical 5, C6, C7. One of the first things that we can notice is if we look at the back of the disc, we can see some discs are flat, like this disc at E23, and some discs are sticking out, like we see at the C5, 6, C6, 7 levels. So let's go now and look at an axial view.
Let's not.
Is a cross-sectional view. And so if we look at that, we're now seeing, I'm going to bring this down a little bit. We're now seeing both the axial view and the sagittal view. The sagittal is the side view, the axial is the cross-sectional view. And if the court notices there's
Sounds like a fucking tuberculosis ward.
And as I rotate this, the spine moves. So this line is telling us what level.
Our next witness will be Doc Holliday.
Which disc. So if we bring this line down to where the disc is the biggest, right here, and let's bring that over here. And let's adjust it a little bit like that. So what we can see here is that the disc is sticking out, coming very close to the cord, and the disc is sticking out here. Now I have a magnified picture of that so we can see it even better, which would be this view that the court can take a look at. And in this view, we can see that the disc is extending out and herniating out into the spinal canal.
Oh, I can hear the pen
just
clicking.
For orientation, this is the cervical spinal cord, the structure running up and down. The white is spinal fluid wrapping around the cervical spinal cord, and the disc sticking out shouldn't be like that. It should be flat like the disc above. If we want to talk about this disc, we call out the vertebral body above and below. So if I want to talk about this disc, I would say at the C5, 6 level, meaning the disc between C5 and C6, there is a disc sticking out and it's approaching the front surface of the spinal cord there. If we want to look at that in the axial view, we come over here, and in this cross-sectional view, all of this is herniated disc material sticking out into the spinal canal and lying up adjacent to the cord. Realize this entire area here should be white. It should be white spinal fluid. Here's the spinal cord right here. So this disc is sticking out and coming very close to the cervical spinal cord. If we go to the next level down and analyze this from the side view, the sagittal view, notice the disc is sticking out here. It's extending upward and extending downward. So this means that the disc has literally herniated out of the wall of the disc with jelly material extending upward and downward. So that is called a disc extrusion.
Guys, I can't bring it to 2x speed. It's live.
Notice how the cord has like an indent here. That means, and that tells us that as this person flexes their neck forward, the cord bends over these regions and the herniated disc has literally caused an indent into the cord in this region. If we look at it from the axial view perspective, notice how close the herniated disc is to the front of the cervical spinal cord. There's virtually no white.
I wish I would have overslept for another 45 minutes.
Separating the back of the disc to the front of the spinal cord. And so those are the two most important features on the study. However, there's a lot of degenerative findings. For instance, the court may not know that the disc should have a white-looking center like we see here. But notice all these discs are black, 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 black. All of the discs that are black like this mean that they've lost the water content in the disc. So all of these discs should have a grayish white center to them. That loss of water content is a sign of degenerative change of the disc, where fluid has leaked out of the disc over time. And
Why is that important, Doctor?
well, it's just a sign that this person has multi-level degenerative disc disease changes up and down the cervical spine, really sparing the C4-5 disc, but all the rest of the discs are all degenerated. If we want to see a nice example of an osteophyte, here is a bone spur sticking out here, bone spur sticking out at this level, bone spur over here at C6-7 sticking out. And in the back, we have these herniated discs sticking into the spinal canal. So these findings are very significant because in general, it is thought that the cord does not like being touched by anything except spinal fluid. So when you have these findings sticking out into the spinal canal, touching the spinal cord and lying near the spinal cord, this can cause symptomatology for a patient. This can cause weakness of the upper extremities for the patient.
And when you say symptomatology, what do you mean?
Well, symptomatology meaning pain, tingling, numbness, things of that nature. That would be the kind of symptoms one can get.
I'm having pain and tingling right now.
Okay, so we're going from the cervical spine, which was number 9 on my cervical spine. We'll go to the thoracic spine. So the thoracic spine is as the court probably knows, the neck is called the cervical spine. We've got 7 cervical vertebral bodies. The mid-back is the.
I haven't heard one question since I've been here.
Thoracic vertebral body.
I
This is
hear a
just-
couple, but I wonder if they edited most of them out for this
We
video.
have 12 ribs on each side, and we also have 12 thoracic vertebral bodies where the ribs can attach.
This is just give a presentation.
We find in here, so there's lots of disc levels in the thoracic spine because there's one disc between each of the 12 thoracic vertebral bodies. But notice at first glance, all of the discs in the thoracic spine are black, they're darkened. That's called disc desiccation. So every one of these discs are degenerated up and down the thoracic spine. Notice that we have prominent osteophytes at some levels in the thoracic spine. But here's probably one of the more important findings is we have a disc sticking out in the mid-thoracic spine right here at T7-8, and it is immediately abutting the thoracic spinal cord. We can see it right here, and if we go over to this view, we can see it right here. So this disc is sticking out and immediately abutting the thoracic spinal cord. Again, the importance of that is just like in the cervical spine, this can cause symptomatology such as pain, weakness, tingling, numbness. It can also be a source of overall weakness to the person's back because of pressing on the spinal cord at that level.
Now, we're looking at a still picture, a static image. Is that how it works in the body? Is the spinal cord just stays in one place?
Right, well, that's an interesting question. Just like in the cervical spine or thoracic spine, Obviously, we need still images to get clear pictures of the spine and vertebral bodies and the core, spinal cord. But in real life, obviously, the neck flexes back and forth, the thoracic spine flexes and extends back and forth. So what happens is that this spinal cord actually moves and slides up and down within the spinal canal. And so the spinal cord itself can get scraped and roughened up by these discs that stick out. And we saw those two significant discs in the cervical spine and this one disc in the thoracic spine. So the point I think you're raising is that the spine actually moves, and so the spinal cord itself inside is going to be moving and scraping up and down against these discs and spur formation that sticks out.
It's hard to talk over this because the audio is so oppressive.
Problems to the thoracic spinal
You kind of
cord
just have
and
to
cervical
wait.
spinal cord, leading to effects on the nerves that are contained in the spinal cord. So that's the thoracic spine, and then lastly, we have the lumbar spine, number 11. And this was fairly remarkable.
I wish I didn't have a spine after listening to
because of
this.
finding. So here's the lumbar spine. So we covered cervical, where we have 7 cervical vertebral bodies. We've covered the thoracic spine, mid-back, where we have 12 thoracic vertebral bodies. Now we're into the lower back. And for orientation purposes, these are the vertebral bodies. This is the lowest one in the lumbar area. This is called L5, then L4, L3, L2, L1, and then this is thoracic 12 here. So what I put an arrow on is this finding right here. There is a cystic appearing fluid collection in the lowermost tip of the spinal cord. So if we back up a section, probably most folks that aren't medical people do not know that the spinal cord itself ends typically at about the T12 or L1 level. It doesn't run all the way down to the lower part of the spinal canal. So if we look at this patient, here's L5, L4, L3, L2, L1. It's ending in the typical location of many patients, where it's ending at around the L1 level. Some can end as low as T12, others go down to L1. But what we have is we have a fluid collection in the spinal cord. This is not normal. It's not typical. This is called a syrinx. And a syrinx is an abnormal fluid collection within the spinal cord itself. This can cause weakness because it affects the nerves running down the spinal cord. And we see this nicely demonstrated on the lumbar view at the T12 L1 level. And this is the corresponding axial view. And if you look at this for a second, here is the spinal cord. And this round hole, essentially, that we see in the spinal cord is the syrinx. So there literally is a cystic cavity in the spinal cord itself, which in general can cause weakness for patient, sometimes incoordination of the legs, may even cause imbalance for a patient. Also look at the disc. We've learned to look for disc desiccation now. Look at the disc here. It's black, 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 black. These lower two have a small amount of remaining fluid collection in the disc, so this is some residual hydration in the disc. But we have multi-level degenerative discs. These discs are not, even these down here, are not as white as what they should be. They should be comparable to the white spinal fluid, and they're not. So all of the discs have become desiccated to some degree. If we look at one last finding here, we're seeing what is called an annular tear. And the court has probably heard about annular tears before, where the outer wall of the disc called the annulus is torn, and this can be a source of degenerative change and may cause symptoms for some patients. So really, we took sort of a whirlwind tour up and down the cervical, thoracic, and lumbar spine and saw two large herniated discs in the cervical spine. We saw a disc sticking out and touching the cord in the thoracic spine. In the lumbar spine, we saw a cystic cavity in the lower spinal cord called the syrinx. We see multi-level degenerative changes up and down the lumbar spine, and finally we see this annular tear in the lower lumbar spine.
This syrinx, is this a common occurrence?
So it's actually rather rare. They can be produced by trauma, and they can be congenital, but if you lined up 100 people, you wouldn't hardly see it in one or two people of that entire 100-person population. So it's not a very common finding.
From the appearance of the syrinx, is this something that would take time to develop?
Well, it would, even if it's trauma related, it takes time to develop. But something like this likely has been around for many, many years.
Oh, please be done.
Thank you. I don't have any other questions.
Oh,
wow.
thank God.
I feel like we've accomplished something together. We've been to war, gentlemen, and we came out on the other side better for it.
Now, the opinions you've expressed today.
Oh, we're not done. Just done with this presentation. No.
He's like, I got to take a drink after that. I've just been speaking for 5 hours, baby. He even made Andrew take a stretch. Andrew, first time I ever saw you stretch on camera. Damn. You know what he should say? He should sit down and say, "This is MAGA country." But you got to say it with a little bit more flair than that.
Oh.
I'll go back a few minutes to the beginning of your testimony.
I'll go home in a few minutes.
Okay.
Yes.
Did you sign an employee contract with them?
Yeah.
All right. And your hourly rate to be paid in return for your services?
It's $750 an hour.
And up until today, how many hours have you put into this case at $750 an hour?
Andrew, you're muted. You're muted, Andrew. You're speaking into the void.
Talked about before, it adds up to $5,000.
So he's got no real impeachment. He's just asking about his hourly rate.
The films.
He likes doing that.
They're just flat fee charges.
And doctor, your wife's a 25-year-old bikini model. Is that right?
And spent about 30 minutes loading the films on the computer and selecting out the images.
Would you agree or disagree? It's important to be limber.
Yes, sir.
Here's your bill for it.
Take that.
All right. Before we get into the individual
Regina, before we go.
X-rays,
I wonder if Law and Crime has license to play this video of a video.
True.
Oh, these captions are gold.
You sit down with Mr. Reeves and conduct
I think it's describing how we feel more than this, what they're
Just-
saying.
What, when it just says pain?
Yeah.
Judge that as a radiologist, I read films of people, so normally I'm not sitting down, meeting the patient, talking to the patient, examining the patient. Basically, my exam of the patient, as most radiologists, is looking at.
Eating the nation might be viewed.
Reading the films of the patient.
In this particular case, what was the years of the last films that you looked at prior to June of 2015 as far as x-rays of Mr. Reeves' hips, knees, shoulders, and fingers?
Those were all June 8th and June 9th, 2015.
Prior to that, what was the date and years of the x-rays that you used to compare with the x-rays of June 2015?
These were the only films that I had, so I read what I was given.
You have no way to go back, say, on January 13th, 2014, and tell this court whether or not what we saw here in display today was the same, substantially same, or even different than what was taken on June 8th, 2015.
Well, I think that's true to a degree. We know the findings are long-standing, that it takes many, many years to get those findings, but if no one takes an x-ray on a certain day, you can't with 100% certainty say what the film looks like on that particular day.
So what we were presented here today is simply a snapshot and the life of the medical history.
Yeah, all of his degenerative disorders actually have gotten much better
That's true.
since
You
then.
cannot, for any reason, for your medical certainty, go back and tell this court that at the time of this particular incident on January 13, 2014, that Mr. Reeves' vision was exactly the same as it was presented by the x-rays today. You can't do that. To any degree of medical certainty.
No, I would not try to do that because I want to have a film done exactly that day. But I'm not trying to say that the films look exactly the same either. I'm saying those films show degenerative changes that likely took a long time, many, many years. So more likely than not, I could say that these kind of findings pre-existed the date of the incident.
But you cannot say to what extent they existed.
I agree with that.
And along those same
But he wasn't
lines,
old when this happened, was he?
2014. It's just as consistent that the degree of the degenerative, what was the word after that?
Degenerative changes?
Yeah, there's been the degenerative
Changes, that's the word.
That have taken place over the years.
Changes.
On January 13th, 2014, Mr. Reeves was aware of those due to any type of outward manifestations of pain.
Right, as I mentioned to the judge, I'm not trying to testify about what symptoms this patient specifically would have, because in order to find out symptoms, one would have to talk to the patient, interview the patient, and so forth. What my testimony was, based on the degree of degenerative changes, it's common for patients to have pain, but as you say, you could have two people that have the same degree of degenerative change, and one might say they have pain 3 out of 10, and the other person might say they have pain 8 out of 10. So there could be some variability among patients. I'm just saying that more likely than not, these findings pre-existed the date of the incident.
And along those same lines, on January 13th, 2014, you cannot tell the judge as an expert, for any reason free of medical certainty, exactly what Mr. Reeves knew about his physical condition, correct?
Right, I would have no idea. You would have to interview the patient to know that.
And you did not know that,
No, my job is to read what I see on the films.
which were taken in June of 2015.
Yes, sir, that's true.
What I'd like to do is just very generally go through the different.
What I'd like to do is start pulling up pictures of you from a Chippendale dance that you did in 1938.
Okay, I'm going to think about that a second.
Okay?
Oh, God. You guys, I'll get to super chats when there's not... The ambient noise of this video is so awful.
Counsel, Judge.
Yeah, people are making fun of my Twitter wars now because of the whole U.S. soccer thing happened yesterday. So
What do you think of that settlement?
it's bullshit. It's all bullshit. It's how can you settle when you're already paying them more? You settle to pay them even more money on. It's like what?
Insane.
It's good for them though. Good for the women, but it just doesn't. I wish that could happen to me, right? I could go and say I'm being discriminated against. They're paying me more money.
Yep.
But one thing I didn't notice. A couple of the fans realized, told me my video on it is getting more views than all of the mainstream media combined. So that shows you something.
Oh yeah.
I'm expecting to get some cease and desist now.
Hey Nick, maybe your strategic response to law and crime should be to just buy CNN and start your own network. You can probably get it for $100 or so now.
Yeah, CNN is shit.
Okay, yes, sir.
And if you identify any spinal canal stenosis in Mr. Reeves.
I see your copyright strike, and I counter with CNN. The Cup News Network.
When this is sticking out into the spinal canal, the cord is actually being pushed back in the spinal canal. And so that
just call it NNN, Nose News Network.
Hey, wait a minute.
Because the disc is pushing into it, it's never
for short.
The spinal cord can come down, and that tightness is called cervical spinal canal stenosis. So stenosis means a focal narrowing, and there is focal narrowing of the spinal canal.
I'll be back, gentlemen.
At C6-7, and then again at the mid-thoracic spine level, T7-8.
That would cause weakness, tingling.
Yes, sir, that's true.
Subject, just cross on that.
Almost done. It's almost over.
Have any X-rays to compare. You cannot say as an expert to any reasonable degree of medical certainty that on January 13th, 2014, that Mr. Reeves suffered from that condition to the extent that you saw an X-ray that was taken in June of 2015. You have no idea what his condition was.
You have no idea.
I understand what you're saying, and I will agree with you to the degree that without having a film done on that exact day, you can't say what it looked like that exact day, but I can say within a reasonable degree of medical probability that more likely than not, those findings pre-existed the date of the incident. So I would say the person did more likely than not have cervical spinal canal stenosis from the disc abnormalities that are present. But again, partly agreeing with you, because you don't have an exact film on the exact day, I can't say exactly what it looked like on that day.
So to any reasonable degree of medical certainty, you can't quantify to what extent that condition exists.
Well, yes and no on that, because I testified that it takes many, many years to get the kind of finding that we're seeing here. So if the time separation was about a year and a half, something like that.
He developed all of these degenerative disorders that take decades and decades to build up in the body in the week before or the week after this happened.
The patient had similar findings to what we're seeing a year and a half later after the incident, and those findings existed prior to the date of the incident.
And as we discussed before, every individual's pain threshold is different.
I agree with that.
And so an individual who, and I'm just going to use A and B, but without making it's not making it too complicated. If you have a condition A and it gets worse to B, one person could have pain at A, but really another person could have no pain until they get to condition B, correct?
It's a possibility.
All right. And because you conducted no medical history of Mr. Reeves, and you have no comparison X-ray of Mr. Reeves on January 13, 2014, as to exactly how that impacted Mr. Reeves' daily activity and living on January 13th, 2014. Right?
As I said before, I've agreed with you on that point because my job as a radiologist is to say what I see on the films. I did not do any discussion for the court on what kind of symptoms this particular patient had at a specific date and time.
Thank you for your time.
Thank you, sir.
And one thing you can be said, though, is we're looking at individual age.
Yes, sir. That's true.
Oh, thank God. Oh, it's a million times better not having that background fucking white noise. Woo. How you doing, man? Nice to see you.
Talking to me? You talking to
Yes.
me?
Yeah, I can actually talk to you now that horrific sound is gone.
Yeah, that was.
Oh my goodness. What's up, chat? How you doing?
Probably a good time for a break. Let's take 10 minutes, ladies and gentlemen, and remember my instructions during the recess, please. And we'll see you back in a few.
Come back in a few. Let's
That's
be
what she
decisive
said.
there, Judge.
Well, you know, I'm glad we're gonna leave now. Oh God. Holy crap. So yeah, I got up, my alarm went off, and I remember going, okay, time to get up. And then I blinked and it was 30 minutes later. I
You're
had to
fired.
get down. I know. I should be. Honestly should be. After subjecting the chat to that audio for that long, might as well be. God, that was terrible. So there's this phenomena, I don't know what it's called, but when I was a kid, I call it Legoitis. And it was if you had a big bucket or whatever of Legos and you just like run your hand through them and stir them around and make this just giant loud noise, the silence that would follow when you stopped was deafening. And that's what I hear right now. I hear nothing. It's amazing. Oh my gosh. Okay. Let me hit some of these chats that came in before the show started and after the show started, but while that horrendous audio was playing. Shout out there to my people on Rumble and Odyssey as well as on YouTube. I think all three streams are up and running. Everything seems to be going really well on that front. So thank you guys for hanging out with us. All right, let's check this out. Brian Law says he's late, he's gay, and he is here to stay. A mere bike strike can never keep a good whiskey drinking big nose lawyer down. Stay based and unbreaded, brother. Hey, thank you. You too. I can taste fried food says, hey, look, Lawman isn't here, just like his taste. The Dragon's Treasure says, well, Law and Crime failed, so I have to do a sale for Mr. Ricada. Get 10% off your favorite anime-themed tea and your first month of Tea of the Month Club or Dragon's Wings membership. Nick gets a larger than normal cut for every new subscription, so support your favorite small-town law firm in central Minnesota and an anti-woke tea shop at the Dragon's Treasure. You can go to thedragonstreasure.com. I think, if I'm not mistaken, he left out the promo code, which is Law and Crime, all one word. Law and Crime. Check it out. Don Booze says, what are the odds the judge drives a Subaru? Very high. Very high. I think she did say she was married to a man, right? She said my husband early on in this process.
She claims a opposite sex partner. That's true.
Morgan Babcock says, Rackets, you should make an overlay Law and Crime that says courtroom cucks pooled network. we'll think about it. For now, I kind of like the Copyright Cucks logo. Joshua Mihei says, "Can I get a Richards happy 34th birthday?" Yes, you can, Joshua. I hope you enjoy it. Have a good day, buddy. Al Fivra says, "Fun fact about Pasco policing: they have a spot of Minority Report policing program that targets prior records, including teens. They tell them with a letter, quote, 'We are pleased to inform you that you have been selected for ... Oh, that's great. William Andrews in turtle voice. Would you agree or disagree that Taylor Swift doesn't return phone calls because she's very busy?" Oh, God. Peter Watkins, "Can you ask Nate why the women's national team gets paid less for playing?" Just kidding. Just wanted to spurg like he is on Twitter. Lol. Billy Witch Doctor 99 says, "Glad to see your channel didn't get yeeted. Also, 2 more days until Elden Ring." Yeah. Elden Ring's looking very cool. Looking forward to it. Whew. So are you ready for this exciting and riveting day?
I'm mostly focused on my upcoming motorcycle trip.
Wow.
I may have to half-ass it today.
Wow. I can't believe you would come to this this stream with that low of effort. I cannot believe. So you got it. Is it you gonna go next week or something then? Because you were gonna go this
I
week.
think so. Yeah. Well, I was gonna leave. I was gonna leave tomorrow, actually, but it's like 2 degrees here and snowing, so I pushed everything off about a week.
Yeah,
But,
it's negative. It's negative 20 here, I think, today, which is just that's so awful.
But next week it's going to be in the 60s here, so that'll be
Nice.
That'll be good. Yeah.
Well,
And in
I
Amarillo,
hope
it'll be in the 70s, and then down by Austin, it should be even warmer.
Well, I hope you have a good good trip. On that.
I'm going to try to vlog it, so we'll see what happens.
Good. So this is the first guy. I think we've got the guy that they used to recreate the scene coming in today. They actually did come back yesterday after right after basically the outro was finishing. Oh, excuse me.
Oh yeah, they came back on camera.
Yes, they did.
They debated Roy Bedard.
I think that's who it is. This is actually amazing. The prosecution fought against the photos that they're going to introduce. So they went back to the theater. They took photos from inside the theater with the light on or with the lights dimmed, but the screen on to get a photo of the silhouette was the idea. And they took those photos, and the prosecution is objecting to those photos on a Dober basis because a camera lens is not as good as a human eye. So they were objecting to the scientific accuracy of a camera capturing a scene. That was the objection. Shockingly, the prosecution, who probably uses photos in literally every case they would ever bring, did not win on the motion to exclude photos on the basis that a camera lens is not a fair and accurate representation of what is present at a crime scene. So they didn't win on that fact, but they unironically tried. It was amazing. But that's over. Thank God. But I could not believe that was their argument, personally.
Well, they had a bad end of day yesterday.
It's true. It's true. news.
Yeah,
But
if,
yeah,
if my image is pixelated, folks, it's because I'm uploading a bunch of video files to the internet. Sorry about that. I must be using too much bandwidth.
yes, you are. Yeah, the bandwidth police are after you. Bandwidth police, bandwidth police. They'll come get you. Okay. God dang it. Okay. Okay. So we can expect testimony from him today. I don't know what the rest of the motion hearing was about. I couldn't bring myself to sit and keep listening to it. After the prosecution lost on the photo thing, I was like, okay, I'm done. So we'll have to see what they do aside from that. Here we go. Bill Anderson says seems to be alive and still practicing in Tampa in regards to the video guy. So for whatever reason, he must have been unavailable to come in today. Who knows? Caligula says, yo, right on. You're not banned. Nope, I'm not banned. I do have a strike. I have filed a counter notification. It will take 10 to 14 days for that to get processed out. And I do not believe that has occurred yet. So let me check. Let's see. Yeah, nothing has actually happened on that yet, and I don't expect anything will. They basically have 10 to 14 days to sue me now if they want to maintain their copyright strike, and they have to do that. They would have to actually show proof of filing a lawsuit, a federal lawsuit against me, which I find unlikely. It's not impossible that they would do this, but I find it very unlikely that they would try, and they would have a severe problem with trying because they don't have an actual registered copyright at this point, and you basically need one to bring suit. Bringing suit without that would be a colossally stupid move. So since they don't have that, I don't think we're going to see it. That doesn't mean they can't sue me later. They can if they were to get their copyright registration, which could take, it could take a year for that to go through. They could bring suit at a later date. Matthew Self says Curtis Reeves gun unleaded. Brian Schultz, at least that means it probably wasn't COVID. Neighbor 605, I can't tell the difference of old Judge cough and now. Yeah, it's that cough. I mean, that was that's something else. She really needs to get that looked at. And she also just needs to cough not directly into the microphone. In my humble opinion. Neighbor 605 says, oh wait, I just read that. He also says, another super chat from Neighbor. Think we finally found the start of COVID with the judge? Reminder, judge opted for this over movie trailers. Yep. That's true. Oh, that was also what they tried to argue. They tried to analogize the use of the photographs with the movie trailers. And I think, you just try and go with what has won before, what the judge has allowed, but it just seems slimy. The whole argument seemed so fucking dishonest. Shinobi Assault says the judge basically admitted the police didn't do their job, and prosecution tried to stop pictures of measurements of the seating because the cops didn't use it. Judge ruled in favor of the defense because cops usually do it for the court. Oh, that's the second part of it. God, we're going to object to the measurements that they took. Oh my gosh.
I think the state's getting scared.
Yeah, I think the state sees that they're very possibly going to lose this case. Like it's becoming more and more likely by the day. and they've got to be concerned about it. Let's see, Matt B says, Nick, you ever stop and think how none of this, even you sitting and watching this trial, would ever have happened if Maddox didn't get mad at being called a cuck? I think on it often, actually. It makes me very happy to know that is what started this madness. Nabor 605 says the judge coughs are intentional to wake us up. Spidley says chinless lawyer sounds like Frito. I like money. Nabor says, wait, is bone testimony video on loop by accident? Nope. It was just that. Just some experts can just take time. Brian Law says to my man Nate, please say in your South African accent, brother, let me tell you the truth about Middle Earth. We was dwarves, we was elves, we was kangs. Chicken Bridge, how many times did the prosecutor get punched in the face before he had to get a third-rate face transplant? Oh God. No, I'm telling you, he was the woman in Jason Goes to Hell when Hookie gets pulled out of the fryer and smashed into her lower jaw and it gets shoved back into her throat. That was actually just a prosecutor standing in as a body double. Mike Zur says, who is coughing? Is that the judge? Yes. Is she a lawnmower riding, pen clicking super spreader? Keep up the good work, Nick and crew. Yes, she is. The amazing thing is, so the video that we were watching of the osteoporosis doctor or whatever, that was from a year and a half after the incident. So she's been coughing like this for that long. That cough
at least 6.5 years.
Yes. I mean, in every trial, in every case, in every hearing, she's right into a microphone. That microphone, if you put that thing in a children's ward, it would wipe out an entire generation.
She must be fun on a plane.
Oh, God. Brian Schultz says, load and slime. Member of United States of Q, welcome to paralegal status. Nabor says, sorry to paint a picture. Judge is married to her pens. United States of Q says, you have a new member. Me. Member Barry's voice from South Park. I forgot how those sounded. I just remember them saying, I member a whole bunch of times. Nicholas Zernal. Nicholas Zernal says, hey, Nick, wasn't the jawless prosecutor the one who made that potential juror cry because he reminded her of someone? Love the show. Keep it up, buddy. Yes. Oh, my God. That was him. Did you see that?
No.
Yeah. So the chinless prosecutor, he was doing voir dire of one of the potential jurors, and the juror just couldn't handle it. Like, she was so physically repulsed by him that she started weeping. And then he's like, I'm sorry. And she's like, I think you remind me of someone. And he just go uncontrollably crying. This guy's sitting there trying to like preserve this witness. Like, buddy, let her go. It was amazing. I gotta find that. I wonder if that video's available on YouTube. Let me see if I can find that. Good Lord, that was that's the stuff. That's the stuff of legends. Here we go. Let's see. YouTube. Jury selection. I think it was on, I'm pretty sure it was on Twitter that I saw it. Jury selection. Curtis Reeves cry. Let's see. Oh gosh, if anybody happens to know where that tweet is, please send it to me on Twitter, DM or something. and let me know in the chat, because I don't know easily how to find it. Let me see if I can. Oh, oops, trial. Do a search. Twitter search is terrible. Reeves, juror, cry. Oh, no, there it is. I found it. Sort of. Hold on.
Welcome back to another.
Oh, you know what? This will be funny. Long Crime has the video.
Of course they do.
Let's see if we've got. I got to get to the jury selection section. I don't know if they have it cut out though, or if it was just in their general. Day 4 of jury selection. They should have clipped it out. That's the kind of clip that you want to get out. And I can't believe that they don't appear to have that clipped out. Very, very, very silly of them. That's the kind of stuff that goes. That's the kind of stuff that can go viral if you're careful about it. Right here. Hold on, I'm seeing if I can.
You have no opinion.
Go to the third row. If we can.
It must have been in day
Number
4.
63.
The final day of jury selection where they actually were doing individual voir dire. Let me see if I find it here. This is very, very exciting. Riveting television, I know. It should be relatively easy to find, I would think, because he's. Oh. Okay, well, I didn't want to use this other guy's video from it, but we'll do it here. We'll do it this way. Hold on one second.
Nope, they're back.
Oh, are they? Okay, we'll do it in a little bit. I've got the video ready to go. What?
You can be seated, thank you. All right.
Okay, at the next break, I'll pull it up,
What do we
guys.
got, Mr. Rosenwasser?
Or JD Graff sent it to me on
Yesterday, I was
Twitter
going
also.
through Mr. Knox's stand your ground and deposition testimony and looking at the pictures of the mannequin recreation that Your Honor has. So I wanted to supplement my argument with this. I'm not 100% positive if all these factors came up during the argument. As the court knows, with respect to simulation case law, it's generally frowned upon. I wouldn't even consider this evidence as simulation. I would categorize this evidence as irrelevant, completely irrelevant, for the reasons that I'm going to discuss. And again, even if it was relevant, the relevancy of it would be substantially outweighed by the prejudicial effect. Okay. So in looking at these mannequins, all right, so this is what Mr. Knox has done. He's taken mannequins. So let's just use it. It's going to sound funny when I say mannequin Chad.
The defense in the Zimmerman trial destroyed the state with their own mannequin.
Mannequin Chad is not the same height as mannequin, as real Chad. Mannequin Chad isn't the same body shape as Chad.
They're doing this because they should have been done yesterday. They resolved these issues yesterday.
Basically, just to sum it into one big argument, mannequin Chad does not even get close to real Chad. So it can't be relevant.
Well, he's as alive as real Chad.
Anything in this case. Then you have, I sound so silly when I say it, mannequin Nicole, okay? Mannequin Nicole is not even remotely close to actual Nicole in any respect. height, weight, dimensions, the way
Mannequin Nicole's much less
I
affectionate.
mean, let's say that mannequin Chad is 2 inches, 4 inches, 6 inches off. That changes the whole quote unquote perception that supposedly the jury is supposed to see. If Nicole Olson isn't anything like Nicole Olson, then the perception is totally off. It's not relevant at all, and it's so misleading for the jury because it's so inaccurate, it can't have any relevancy to the case. And that's just the very beginning of the analysis. So in the background, we have a movie that's playing that's not the actual movie that was playing at the time of the shooting. So the lighting.
Yeah, that was
in
part of the
pictures
argument
on the mannequin
that they didn't know the
doesn't
exact
represent
moment
Chad.
of the exact preview,
That
therefore
has to
that it was
affect
completely
this
irrelevant
perspective
what any other
that the
condition would
defense is
be.
putting out of the defendant. Then, let's just say for the sake of argument, which isn't the case here, that it was the movie playing. We do not know what scene was playing at the time. So let's say that
There it is.
they were in a car, versus they were in a house, versus they were at the beach. The scene lighting that we don't know would be different. You couple that with mannequin Chad that's not even remotely close to the dimensions of real Chad or even real Nicole. It can't get more misleading than that because we're having factors that aren't even at play in this case. It's not even like, well, maybe it's somewhat similar. There's nothing at all remotely similar to what's going on in this case. Coupled with that, this is what you
Coupled with
have. And this
that,
is what I
coupled with
read
that.
from the deposition. In the deposition, the camera position is from Michael Knox sitting in the movie theater chair. It's not even as if the defendant was there for the recreation. It's Michael Knox sitting in a theater chair taking a photograph that now the jury's supposed to say, well, let's look at this picture taken by Michael Knox as Michael Knox is viewing it from a theater chair with mannequin Chad that doesn't even accurately represent real Chad against the backdrop of a movie that's not the movie playing, and the lighting conditions can't even be recreated because it's impossible. On top of that, the picture that was taken was from a tripod. The tripod was on the ground. So it's Michael Knox sitting, looking through a camera. The camera is on a tripod on the ground in front of Michael Knox, taking a picture of mannequin Chad that doesn't represent real Chad against lighting that doesn't replicate, nor could it ever replicate the lighting at the time in the theater. It goes on and on and on. We don't know the distance. He has a picture of some random distance between the camera that's on the ground, mounted on the tripod, to this mannequin Chad. I'm not going to go through it 500 times about how it doesn't represent Chad.
Curtis Reeves is
You're
sitting
gonna
there.
though.
30 years ago, I would have taken this guy's lunch money.
The defendant must have viewed this. It's
Made him cry.
really so irrelevant because it doesn't help the jury at all, because it has nothing to do with what the defendant saw in the theater at the time of the shooting. And it's not, has to do with the sheriff's office investigation, as we talked about the other day. There is no way.
Barely an
that it could
investigation.
ever recreate all those factors that occur in a movie theater. It's just not possible. That's why you have to rely on the video that's in evidence and eyewitness testimony, because that's the best evidence for the jury.
That excellent video
There's some
evidence.
different factors that I could keep going on about.
Yeah, that video evidence is not in any way a
that there's just
representation
no
of
way.
what he saw either.
But I guess one of the other big things would be positioning. This was a dynamic event that happened. People are moving left, right, angles forward, backwards. This is a
70% off the hardcover, folks. Law Self-Defense. LawSelfDefense.com/hard sale.
At some camera level, that's his eyes, not even the defendant's eyes, but there's just.
I mean, he
no
doesn't see an
relevance
infrared,
to
right?
prove or disprove how the defendant possibly perceived this event.
So
under the
dishonest, it drives me
circumstances that
nuts.
he experienced it through. Because
That
that's
infrared
exactly
camera can't
what he
represent
was
anything that a
exposed
human
to.
eye would see.
Did he reasonably believe that he was in imminent danger of death or great bodily harm? And really, only the people in the theater and the defendant himself knows that answer. This recreation or simulation, or however you want to characterize it, is simply not relevant, and any relevancy is.
Well, if only they know, but the jury has to decide. How do you inform the jury? Like this.
Response?
Yeah.
No, wait a minute. The According to the case law cited by the state in Brown v. State, first DCA opinion, the standard is the demonstrative has to be an accurate and reasonable reproduction.
And then, so my
Accurate,
argument would
not
be,
precise.
This is not even remotely accurate, and it's extremely unreasonable based on all those factors.
All right, and so as you were arguing that, what came to mind was, you know, the differences in likenesses that are pointed out, say in Williams rule hearings. You know, you can enumerate usually a dozen factors on each side. So you went through a litany of differences. Obviously in Brown, there was a glaring difference of, you know, styrofoam versus a human head. But so with that context, Mr. Escobar, what can you tell me?
Your Honor, first of all, this is for demonstrative purposes. Mr. Knox is not going to get up there and say, well, ladies and gentlemen of the jury, this is exactly what Curtis Reeves saw. It is a demonstrative aid to have the jury understand backlighting. Mr. Rosenwasser wasn't here for probably 95% of the arguments that we had yesterday, so he may not know that. But this
He
was
should.
a demonstrative tool to be able to show the jury what backlighting does when someone stands in front of another individual. If the court recalls, their own witnesses talked extensively about the issue of silhouetting. And we can't assume here in this particular case that every juror actually knows the effects of silhouetting. You know, I find it ironic, and I mean this with all due respect to Mr. Rosenwasser.
Sure you do.
But I
Which
find
is
it
none.
ironic that this investigation, the crime scene investigation in this case, was an absolute train wreck, totally incompetent by the Pasco County Sheriff's Office, because they didn't preserve the things that they should have preserved. They should have done all these things there at the scene. And because now they're not there, and we're trying to bring back some of that evidence, some of that experience to the jury, they're saying, well, if we do that, if we allow that to happen, then the easiest thing that the government can do and the sheriff's office can do from here on out is they don't take up any evidence. Because if they don't take up any evidence, then certainly, you know, it's not going to hurt their case, because you're never going to be able to go in and now present evidence in a form that is necessary for this particular jury to understand backlighting. These mannequins aren't there for purposes of saying, hey, listen, this is the perception that Mr. Reeves had with reference to these two bodies that were coming at him. This is a demonstrative aid. And just like that styrofoam head didn't mimic what a human head in that particular case did, you've got to allow some flexibility. That's the reason. That's the issue of reasonableness. You have to. I'm sure in the Brown case that they didn't measure.
All demonstratives are not the actual thing. If you had the actual thing, you would use that.
And the mannequin
Right.
didn't have any hair, and so why not put hair on the mannequin? We can't get beyond the fact that this is a demonstrative aid. And at no time is Dr. Knox going to say, hey, by the way, I did this because I want you to see that this is exactly how Mr. Reeves viewed the backlighting situation.
All right, and just to kind of clarify for the record, I think, as I recall the testimony regarding the silhouettes, you said the witnesses used that terminology extensively. I believe it was your terminology every time. They just said yes, silhouette, yes. Was it what? Couldn't you classify it as a silhouette? Wasn't it a silhouette? Or did you think it was a silhouette? I don't want to be leading, but because I'm sure you weren't leading.
I'm pretty sure he was.
Yes, indeed. That's how I remember the testimony, primarily your
Would you agree or disagree?
terminology, but nonetheless. silhouette has been testified to,
Infinity
which is
times.
why I agreed yesterday with the defense on this issue. Now, what about, all right, so Mr. Rosenwasser, you're pointing out all these differences.
Why I agreed with the defense. Why are we doing this? You've already
And,
ruled on this, Your Honor.
And obviously, again, in the context of a demonstrative as opposed to substantive evidence, there is a little bit of leeway there, obviously. What about that?
I don't think if you change the name of it, it makes a difference when you're doing a relevancy or 403 analysis. If it goes into evidence, that's one thing, but if they're gonna see it as a quote unquote demonstrative aid, they're still seeing it as if it is in fact evidence. So it's just more a different word really than anything else. Now, when the
No,
defense says
it
that we're using
definitely
for
matters.
backlighting,
Demonstrative
okay,
evidence is
I
not
don't
the
think the
same
jury
as
needs an expert
evidence.
to talk about backlighting. That was something that would be within the common sense purview of a layperson. People know what backlighting is, so we don't need Mr. Knox to come up and say, wow, here's an example of backlighting. Really, it's a perspective. That's what I submit they're trying to do, okay? Silhouette. We don't have a jury full of kindergartners that don't know what a silhouette is, okay? The silhouette is within the common
No, the
person's
jury's taller than
experience
you.
in their lifetime. We don't need Michael Knox to come in and give expert testimony on it because people hearing silhouette, backlighting, that's not terminology that requires any further explanation. It's in the common purview that people know based on their life experiences. Experts are used when there's information that goes outside the experience of what we'll say is a common juror. Backlighting doesn't do that. Silhouette doesn't do it. And I was thinking the same thing as the court. Our witnesses didn't get up and say silhouette. Now, that's just kind of, this is what lawyers do on either side. So I'm not saying in fault. It's a job of semantics, and that's just what.
Like contact?
But really, we don't need anyone to explain this terminology because it doesn't require any expertise. To say, well, it's going to demonstrate backlighting. It's backlighting on a movie theater screen that doesn't even have the same movie playing at the same time. So we're looking at this white effect on these photographs. What happens if it was darker? What happens if it was a mix? It's completely
Well, unfortunately, we don't know what the conditions were because the police refused to do that.
I understand that they're saying that the sheriff's office investigation wasn't great. I'm admitting it wasn't great. I mean, any reasonable person would view this case and say it wasn't great. But no one in the world can recreate it. It's just impossible. Like I said, let's say they put the movie on the screen. You can't then say, here's where Chad Olson was, and here's the angles, and this. You can't recreate it. It's just not possible, no matter who you are. So there's just no way to accomplish this. It doesn't need to be the jury.
A demonstrative is never a perfect recreation.
Jurors' common experience.
They use them all the time. Video animations, all kinds of stuff.
And the best evidence will always be the video and the eyewitnesses that were there.
Your Honor, it was a lot more than it wasn't great. As we know,
John, you've seen the video here. It sucks.
We have to have the trier of fact stand in the shoes of Mr. Reeves. I'm glad that Mr. Rosenwasser thinks that he's an expert on what jurors know and what jurors don't know with reference to the issues. With reference to silhouetting, we can't take
Don't
that
have to be
chance
personal.
in a court of law. We never know what 6 members of the jury know and don't know. And I've been doing this for 37 years. I would never take that leap to just say, oh, well, they must. We have, the trier of fact needs to stand in the shoes of Mr. Reeves, which means the trier of fact has to be thinking of themselves as 71 years of age at the time. The trier of fact needs to be seated in the same seat as Mr. Reeves. The trier of fact needs to be in the same darkness as Mr. Reeves experienced. The trier of fact needs to be in the same low noise level that Mr. Reeves experienced. The trier of fact needs to be seeing the backlighting that Mr. Reeves was experiencing. The trier of fact needs to be in the same health condition as Mr. Reeves. The trier of fact needs to know the use of force and the danger cues that are taught to all police officers and even more for Mr. Reeves. All of those factors, the jury has to stand in his shoes and make a determination whether his assessment that it was reasonable for him to fear death or serious bodily injury, whether that was reasonable. And so how can not? The problem here is that the crime scene detective did not do a great job by any stretch of the imagination. And the detective, the lead detective himself, admitted on the stand that he didn't have the tools himself to investigate a self-defense case. And so now Mr. Rosenwasser is saying, well, you know, we didn't do it. We didn't capture it. We didn't do all these things that really should have been done in order to assess Mr. Reeves's perspective of what was going on. And so, but we don't want you to present it as a demonstrative evidence so that we can aid the jury somehow in making that determination. Mr. Knox is not going to be saying that what's on the view of the mannequins is exactly what Mr. Reeves experienced. The jury is going to determine all of this based upon all of the evidence that we're giving them. This is a demonstrative evidence just strictly on the issue of backlighting and an individual in similar size as Mr. Olson standing in front of that seat 9.
All right. Thank you. I would have preferred to focus primarily on the argument. The issue that I asked about is the accuracy. Is it accurate? And within the realm contemplated by the case law, do we have any more guidance on that? I can't get into Westlaw.
I think
Forgot my
I read the Brown
password.
case. I thought is a very good. It's a flexible, yes, accurate, reasonably accurate.
Accurate and reasonable reproduction.
Exactly.
And there's 15 cases that cite this head note. I would love to see some of them if I could log into Westlaw, but I can't. So does anybody have any of those that more propound a little bit
The
better
court forgot to
description of what
update their credit card with Westlaw.
accurate and reasonable
Oh my God, how
reproduction. So,
embarrassing.
obviously, Mr. Rosenwasser has pointed out some significant differences. I'm not quite as concerned about the backlighting and the exact moment because the pictures that I saw had a variation. There was a pretty good mix.
And we did that on purpose.
Light and dark. So, and obviously there's not any sound connected with this, right? And they're not moving.
Yeah, if I had the
correct?
citations, I mean, I use Lexus,
So
but
what are we talking about?
Call me,
The
Judge.
differences with the
Yeah, no kidding.
the
I have
mannequins?
the super packet Westlaw.
How much
you can
different
use
are
mine.
they from the actual folks and the perspective?
Your Honor, they're a human body mannequin, just like the head in the Brown case was a styrofoam head. You're not required to exact every description or every feature of a styrofoam head, just like you're not required to do that with in a human body mannequin. That's why I'm saying that I think that these distinctions, are not the type of distinctions that we can.
they're a
attribute
pretense by the
all three.
prosecution
They're
to try to
just
avoid
not the type of
uncomfortable
distinctions
evidence.
that we can put a level of prejudice on. And so that's been my argument.
Of course, the
all along.
prosecution
Again,
does
if I was
this
gonna have,
all the time when it favors them.
Dr. Knox come in here and say, this is what Mr. Reeves saw, I'd be with you. I'd be with Mr. Rosenwasser. I'd be saying, hey, listen, I can't do that. We're not going to do that with our other experts. And so
Yeah.
this is purely.
Obviously, what Mr. Rosenwasser would have seen in that theater is different than what a person of normal height would have seen.
That is showing what happens when you have an object in front of, for example, Mr. Reeves, and backlighting, and what that does to that process. And I'm not going to take.
The defense should offer to exhume,
that
Chad.
These jurors all have experienced that and know exactly what backlighting is when someone gets in front of them with a screen behind them emanating light.
If this is not 100% what Mr. Reeves saw, it's not relevant. that's it in a nutshell.
All right.
The infrared video is not what Reeves saw.
You know, to
Is that relevant?
my decision into context, obviously the state is asking me to exclude some testimony and evidence that the defense feels is very pertinent to their case. So clearly I need to get this right. And I'd like to
Yeah.
have all the information.
Judge, if you give us 20 minutes, we can do this. I frankly thought this issue was done yesterday.
It
Nobody
was.
called me yesterday to tell me, hey, listen, get prepared because I'm bringing this issue back up again. If not, we would have done it last night.
I did say it yesterday. We need to adjust the issue with Mr.
Yes,
Knox again
he
before he
did, he
testifies.
did. As I indicated, you know, I'm sure we've all done plenty of Williams rule cases where you can have, you know, the same sort of thing. How similar is it? You know, and you can list 15 different similarities and then, you know, maybe a few dissimilarities. And the case law is clear that it doesn't have to be exact, and typically it isn't. So
It
we
never
get that
is.
It can't be.
discretion in there. And Brown simply says,
By the way, the people in the
"Did
witnesses
the
there are a
exhibits
terrible.
constitute accurate and reasonable reproduction of the objects
Right,
in
and if I could, I presented Brown to you, and you have to look at what the demonstration was for. You can't have a live human and place a knife in the skull to show the position so the jury can know the angles. That's what Brown was. So the styrofoam head served the purpose in order.
Will this
for the
mannequin
knife
have
to
a
be
chin?
placed. So visually, they can see the angle, which was relevant to how something happened. So did it fairly accurately represent that? Yes. There's a human head that is approximate. We all have basically a nose, cheekbones there. It was there.
He didn't say chin.
Avoided chin.
That's what they said. It had to be fair and accurate. Here, we have none of that. It's not fair and accurate at all. And so that's how we distinguish Brown, is for what the purpose is. That was for the angle. This is what did the defendant see? And if you can't reproduce that, then it's not relevant. They were
It's
able to
impossible in
reproduce
any
the
case
angle
to
of the
ever
knife in
reproduce what the defendant
accurately so
saw.
the jury could have a visual representation. You can't do that here because of everything that Mr. Rosenwasser listed. And so it doesn't meet that standard.
Well, the argument in Brown was that, the defense argument was that you know, there's no way to tell how deep the knife went in. There was no, you know, that was an unknown.
But that wasn't the issue.
Well, it kind of was, whether he intended to kill her or not. And so they, you know, wanted to know, you know, it does make a big difference if it goes in deep or not. And so that's, you know, like I said, just like with Williams rule, you can point out as many as you want. There's this and there's this on both sides. And I'm just not convinced to the point that all of these disparities are enough. You know, I'm just not. So I would like to, if there is any more guidance, particularly if there's something from the Supremes, that would be beautiful.
Imagine the
Like,
audacity
just
of the
some
state here.
analogies to what is.
They said they were going to bring
What
this
is
argument, and they
reasonable
didn't bring a single
reproduction?
citation.
Judge, if I can just have a suggestion, if maybe everybody can go to lunch early, and during lunch, we will do it.
10:45 at lunch.
Why don't you maybe just do another witness instead? And then
We don't have another witness instead.
This is in the dark here.
We-
And then just as
The
the,
dart's gonna be huge, and now, then we're gonna have a break in the middle of the dart. We could get, I think, Knox is not gonna be that, that long. My suggestion would be we take a break, we do the research and come back and start.
All right. I'll 10 minutes. I can go to my office and look this up on Westlaw in my office. I'll look at what we've got and I'll give you my decision when I come back. That's what it boils down to. And I already indicated yesterday that I was gonna deny the state's motion in limine regarding this, or I don't think that was.
Such bad form for a judge to rule on a motion and then come back the next day and consider it again.
Cameras and
Yeah.
backlighting and.
Okay, all right, that brings up the other issue. What about the camera? Where was the camera? How much difference is that?
The camera was
Listen how
positioned
angry she
exactly
is.
where Mr. Reeves's eyes would have been, okay, in his seat. There were measurements that were taken. I was there when that happened, and I can certainly speak to Mr. Knox and verify all that.
Mr. Rosenwalter, you disagree with that?
I do. I have a copy of his deposition. And let me find the exact page and I'll show this reporter.
No, folks in the comments, I see
Because
thoroughly unimpressed with
a
this
lot of
judge.
small
Oh, she's terrible.
inaccuracies can overcome a reasonable reproduction.
And I have it right there. Okay, this is page 101 of his deposition. Did you, and Mr. Martin, question, did you measure the height of the camera above the floor at the time you were taking the pictures? Answer, I don't recall if I measured the height of the camera. I set it at my eye level as I sat in the seat. So I sat in the seat pretty much straight up and set it to my eye level, but it was a tripod right in front of my eye. Did you take measurements of what your eye level was? No, I did not. And then.
So again, you're talking about inches of
A
difference.
tripod was put on the floor in front of
And tell me how that changes
where he
the
was sitting,
perspective in some
where he
way
took the picture of his own eye level.
in showing
And
a
how tall is
silhouette.
Mr. Now?
I don't know, Judge, I would have to ask him.
And,
Yeah, I can tell you he's not
also
as
you have
tall
to
as
take into
my client.
consideration where he was sitting. You know, was he leaning to the left, like Joanna Turner said? Was he leaning back in his seat? You know, there's so many different variables about the height of his eyes. I mean, it's just impossible to recreate this. I can't think, you know, like when you ask the question, which is, you know, what else is accurate or inaccurate? There's nothing about this is accurate other than the fact these pictures are taken in the cop theater in a seat. That's the only thing that's accurate. Every other variable is inaccurate.
Reasonable reproduction.
There is no reasonableness in it because there's nothing remotely accurate other than the fact it was taken.
No, it's remotely accurate.
10.
Yes.
He's not 2 foot 6 inches tall like you.
So you can't even use that. The only thing that is reliable or reasonable or accurate is the pictures were taken in theater 10.
The mannequins.
This is just scumbaggery by the prosecution, but
appear
I
to be
hate
of
this
human
shit that they
beings.
do.
Okay? But human beings have 5,000 different variables. You know, like you're probably mine.
So-
Like for me, my penis is tiny.
We use Mr. Martin's mannequin look very different. So just saying a generic.
Your Honor, when I was at the Lollipop Guild.
Doesn't mean anything because we're very different body styles.
Are they similar?
No, it's just it's just a mannequin in a human form, you know, and it really does matter. The broadness of the chest, the broadness of the shoulders, the head, the neck, all of that.
How
makes
sensitive
it
its nipples are.
This is just some generic mannequin. So it's not reasonable to have a generic mannequin. And it's not even reasonably accurate because all it is a mannequin.
Judge, again, whether you're 5'7", whether you're 6'1", it's the backlighting. That's the demonstrative issue here. It's the backlighting. He continues to try to gravitate, okay, to trying to tie this demonstrative aid as saying, this is exactly what Mr. Reeves saw. That's not coming in. We're trying to show the effect of the backlighting when someone, in this case, it was a human body, but you know, you could have a backlighting and have something even smaller than this just go in front of you, and it's going to have some of that effect. So we're not trying to tell this jury that this is exactly what Mr. Reeves saw. It's to show the effects of backlighting when a human body comes in between the backlight and the individual that is viewing it. So if you're 5'7", it doesn't mean that the backlighting doesn't occur. If you're 6'2", it doesn't mean that the backlighting does occur. It's the body coming in front. He's trying to gravitate his argument to suggest this is what Mr. Reeves actually saw. I would agree with him. I would agree with him. Under those circumstances, you shouldn't allow it in. That's not what we're doing.
All right. Let me take 10 minutes.
Oh my gosh.
Yes. Please do.
Again, this running concept that blows my mind in criminal trials of prejudice to the state. And this idea that you're supposed to completely recreate what the defendant saw specifically, which is going to be impossible. Like, let's be honest about it. You're not going to be able to do that. But the idea that the prosecution, who does this in every case, presents demonstrables and things that are not accurate to what happened, to try and illustrate a point for the jury. And they'll say stuff like, well, the deceased isn't here, so we have to do this. It's like, oh, nope, sorry. The deceased is dead, so you can't do anything from his perspective ever again because it's not accurate, because you can't perfectly recreate them. That this is a nonsensical argument. It's the height of scumbaggery and dishonesty that comes from prosecutors. And this is why people hate the system, in my humble opinion. I don't know. What do you think?
Well, I concur. It does remind me of the time they used the mannequin in the George Zimmerman trial, where the state brought in the mannequin so they could put the trajectory rods through the body to show the path of the bullets, to make it as graphic as possible. And then on cross-examination of that expert witness, the defense said, "Hey, can I borrow your mannequin?" and put it on the ground and mounted it and beat the crap out of it in front of the jury.
Did they really? That's amazing.
It was a great moment. That was not a boring trial.
Well, unfortunately, they can't.
Mark O'Mara, the lead defense counsel, just beat the crap out of that mannequin right in front of the jury.
Oh, that's good. That's good times. Yeah, I don't know. This effort by the prosecution just cements things that I have stated about prosecutors that I don't like over and over and over again. So I won't revisit all of it, but it's this disingenuous nature of what they're trying to achieve. They're trying to win. They're not trying to seek justice. They're really worried that if the jury sees it, for some reason, they're very worried that if the jury sees this, they're going to be automatically misled into finding the shooting justified. I mean, that's the concern, is that, and so that's what needs to be, the way evidence is weighed in all of these cases goes to Rule 403. Is the prejudice, or does the prejudicial impact does the unfair prejudicial impact of the evidence outweigh its probative value? If so, you exclude it. So what is the unfair prejudice to the state? Because this demonstrative has probative value. There have been witnesses who have testified that he was turned around, that he was a silhouette. Multiple witnesses have testified that he was a silhouette, that it would be effectively hard to make out details if you're looking at a silhouette. You're seeing an outline. So then, is that actually a true thing? The only way to find that out for the jury is to look at a silhouette in the same place with various lighting conditions that they've tried to reproduce to the best of their ability without actually having any measurements, or being able to know exactly what preview is on or anything like that. Any measurements from the state. They went to the theater and turned it down to preview lighting and then put on some images, some imagery behind them to try and recreate it. So then you show it, and it may not be beneficial to the defense at all to show that. Like, what are they going to do? Is the mannequin going to be wearing a shirt that says "I'm a racist and deserve to die" or something? Like, what prejudice again can possibly be hitting the state here? That is so unfair to them.
They'll swing the mannequin arm and it'll throw a cell phone and hit the judge in the head. By the way, I think the judge's Westlaw password is Bud Light forever. Exclamation mark.
No, our password is Janet Reno. Lost my phone number. Oh my God. Oh, that's just sorry. This type of shit is just infuriating. Lancelot says the next time someone coughs into a mic, I'm going to Minecraft them. BG Willia says to best simulate a human eye, use a 50 millimeter prime lens, an f-stop of about 2.4, an ISO setting between 500 and 1000, an angle view of about 55 degrees, and a 52 megapixel camera. Well, there you go. There you go. That's there. And they can do that. They can do that on cross. They can attack this guy's framing of the picture. But again, police use pictures all the time to do this stuff. This isn't uncommon. This isn't new to the prosecution. This isn't any sort of surprise. They do this in all of their investigations. So, ugh.
I mean, they had photos in evidence of the popcorn on the floor. Who saw that in exactly that way?
Yeah. Well, and again, keep pointing out they have infrared video from two different angles that are 35 feet up in the air. where the cameras are. No one saw anything from the angles of those videos. No one, not a single person, not even close. And I mean, not like they're saying, well, you can't tell from the angle. No. There's nothing even remotely similar in these things.
Maybe Mannequin Chad will come in reeking of booze.
Oh, shoot. The crying juror video. I forgot. Let's see. Here we go. So this is the, oh wait, no. Someone sent me the Twitter video of it. This is where it's more isolated. Okay, you ready? We have volume. Here we go.
Doesn't have anything to do with the lawyers, the judge. It's just because you're in this setting, you don't feel comfortable.
Right, and I think you remind me of someone. I'm sorry.
What's that?
She said you remind her of someone.
Sorry.
Okay.
Someone who touched me.
Doesn't have anything to do with
It has to do with the fact that it looks like you're wearing a skin suit. I can't look at you without seeing the endoskeleton underneath and your skin sagging off of it. Oh my gosh. That's so yeah. He does look kind of like a ghoul of some sort. Let's see. Where were we? Thank you. Eli 580 says, is the state lawyer upset that his sex doll was too big for him? You know, when you buy these things, they don't tell you they're over 100 pounds. I ordered it online. Damn that dollhouse, Phil. Spatula says the fact that the state is banking on any ambiguity weighing in their favor reflects the problems with the reasonable doubt standard. Yeah, actually, well articulated there, Spatula. That is a big problem with the reasonable doubt standard. And I think we discussed that a little bit earlier in the week. Maybe it was last week. I don't remember at this point. But this idea of reasonable doubt is long past what it was intended to be. Reasonable doubt should be the standard, but people don't approach from a perspective of an actual effective perspective of innocent until proven guilty. Therefore, the reasonable doubt never actually comes to fruition, in my humble opinion, because they don't see beyond a reasonable doubt. They see preponderance of the evidence. They go, well, it seems likely that this guy probably shot him, therefore he's guilty. It's like that's not the standard, but that's how people apply it. Oh, gosh. Okay, here we go. Next.
I reasonably doubt it.
I reasonably doubt it. I doubt it. Koi 540 says Fauci for prison. I'm a single issue voter. Colin Helmet says, Andrew, have you ever come to Tennessee and ridden Blue Ridge or the Dragon's Tail?
Many times. When I lived on the East Coast, I rode up and down the East Coast often on those roads.
How long? When did you start riding motorcycles?
I mean, I rode as a kid, and then probably when I was in my late 30s, I started up again.
Oh, okay. There you go. Brian Schultz says, thanks for trying with name, but it said with the T. You don't have a T in there. How? I mean, I'll pronounce it Schultz, but you should. Why would you pronounce it Schultz if it doesn't have a T in it? This is disturbing to me. Shadow Dragon 243 says, hey, Nick, what is going on with the Austin, Texas case against the soldier who shot the Antifa guy with the AR pointed at him? I don't know.
Folks, to the extent that a camera would look different than real life and the state objects to that, then the state can bring in an expert to testify to that.
Yeah, or the state can cross-examine the person who took the picture and right in front of the jury, make fun of him. Oh, you didn't measure how tall it was? So how do you know you even have the right perspective? Just rip them apart on the stand. That's what the defense does to the state experts.
But I think the state may be a little gun shy of cross-examination at this point. It hasn't been going well for them.
Yeah, well, they're getting outclassed by the actual experts who know what they're talking about. And that's why they're experts, and that's why typically they're not always testifying about a fact of the case. They're usually testifying about a principle or a concept or a scientific method or something like that. So what you should do is hire your own expert to help you develop a competent cross-examination strategy. But they haven't done that, or they haven't done it effectively, whatever they've done. Lady Ziploc says conviction seems less likely to me as well, but then again, that's what I thought in Kim Potter too. Yeah, and it's certainly possible that we see this differently, or I see this differently than the jury. I'm not.
But nobody's going to riot if Curtis Reeves is not convicted. That was the difference with Kim Potter.
Yeah, that is a very important distinction. Beast on the Run says, went to see the new Uncharted film. Really good, by the way, last night. Some jackass had their phone ringer on that went off at least 5 times. I was half tempted to pull a Curtis Reeves. Digitalis says, that's a beta blocker cough, side effect of blood pressure medication, very common in overweight old people. Andrew Clark says, Hassan's chair watched JXE. Jay wasn't happy about it. Drama is ongoing. Watch Jay's reaction content video, at least in part educational. I'll have to check it out. I don't know. I'm not gonna do it right now during this break or anything. Fish Tank Cleaner says, DM'd you my clip on Twitter of it, Nick. Here, let me see. We'll see if that one was longer. Where we go? Did you? What was that at? Did you actually DM me or did you tag me? EAB. Here we go. Okay, these are some, I see some clips. Where's this? Oh, why wasn't it showing me this? Here, let's perfect. Thank you, by the way. Yeah, this is a little bit longer clip of the crying, which might have a little more context to it. All right, here we go.
And I thought I was doing a good job, being very nice. But all of a sudden, the witness started to tear up and cry. I didn't know what I was doing. And I finally decided, well, I'm just going to sit down. I then had an opportunity to speak with that witness again within a couple minutes. And what I learned was I reminded that witness of someone. It's not what I was saying or doing, but it was, I then had whatever about me, my mannerisms, my looks, I don't know, just reminded that witness of someone, and it was emotionally painful for that witness, to the point where the witness agreed.
And remarkably, I run into that a lot when I'm dating.
2 weeks, I don't think I'm going to be paying attention all the time. All right. So let's talk about lawyers, because now we're going to have lawyers standing up here today, all day, and you're going to have lawyers.
Oh, good timing.
Okay, thanks. Okay.
Well, she's on her computer now. There she goes. Bud Light forever! Exclamation mark. I'm in. She's like a swordfish hacker right here. Maybe she should do a quick search on leading questions.
She should do something. Learn, know your. You should go to know your meme about leading questions. Leading questions, I'll allow it.
She does crash her way into that courtroom.
All right. I did find a few cases of interest. Ultimately, I got to Chamberlain v. State, which is 881 Southern 2nd, 1087 Supreme Court of Florida case, which cites their previous ruling in another case. It was a recent ruling.
Says no mannequins.
In Chamberlain, the standard for allowing demonstrative evidence at trial was recently reiterated by this court in Harris v. State, 843 Southern 2nd, 856 at 863. That's a Florida decision, 2003, wherein we stated demonstrative evidence is admissible only when it is relevant to the issues in the case. It is essential in every case where demonstrative evidence is offered that the object or thing offered for the jury to see be first shown to be the object in issue, and that it is in substantially the same condition as at the pertinent time, or that it is such a reasonably exact reproduction or replica of the object involved that when viewed by the jury, it causes them to see substantially the same object as the original. The person offering such evidence should be required to give a good reason for its acceptance into evidence, and this is particularly true if the object be not the original but only a replica or a facsimile. The determination as to whether to allow the use of a demonstrative demonstrative exhibit is a matter within the trial court's discretion. So, Mr. Escobar, I believe
I've got an a Supreme Court case from 2018 dealing with mannequins in and of itself.
all right, what is it?
I've got, it's called Lowe versus State, located at 259 Southern.
Looks like the Hispanic girl came through.
22-page opinion. However, I have outlined the areas that they deal with mannequins. I believe they start at head node number 5 through 11. I've only got half the opinions being printed right now.
So give me the site again, 259 Third.
259 Southern Third, 23. So 2018 Supreme Court of Florida opinion. And it deals specifically with mannequins. I'm handing that to the court. And my other pages should be here momentarily.
Patricia. Who's Patricia? She's right outside. What would we do without Patricia? So again, the question is, you have to show that the demonstrative is effectively representative of the object that is not available. So Chad is not available. So the question is a mannequin representative of a human body
For this purpose.
and the obvious answer to that is yeah.
I mean, we put clothes on them.
Mannequins are specifically there to represent human bodies in all of their applications.
Can you see?
This mannequin will be shorter because Chad was bigger. That weighs in the state's favor, by the way, that it's shorter. It's less imposing and intimidating. It's going to be narrower.
Oh, maybe they got the judge.
Maybe they got one of those. Wait, what?
The judge's sister is on the bench.
Really? Nope. There we go. Maybe they got one of those Nike athletic mannequins. So it's all just giant and buff. It looks like a 240-pound monster.
The MMA model.
They should have gotten one of the fat woman mannequins that Target uses now. Those are perfect. That could have been for Kurt. They could have put that in for Chad Olson. Let's see. Lackluster says, mic check. J-Dig 1982 says, what's the difference between the judge and Chad's relative chances? Relatives have proved they can hold a coffin. Wait. Oh, wait. What's the difference between the judge and Chad's relatives? Okay. I missed the pun. What's the difference between the judge and Chad's relatives? Chad's relatives have proved they can hold a coffin. See, like cough in.
Hey, did you get the coffee mug?
I did.
All right.
I did.
But you don't have it on
thank you.
camera.
I don't. It's upstairs. I woke up and ran downstairs to get the show started. I didn't even grab Pop-Tarts for me. I'm very, very hungry. So I'm going to go grab something in a minute, but we're at this riveting part of the case now where the judge's clerk came in to do something, Fixer Westlaw.
Tell me what relevance.
Judge, I think when you look at that particular case, they were actually using the mannequin for.
Wait a minute. Just tell me what the relevance is, please.
The relevance for our mannequins is the
Yes.
backlighting.
The backlighting is relevant to what issue in the case?
To what Mr. Reeves could have experienced, the backlighting, what Mr. Reeves would have experienced in the theater, meaning not that exact mannequin, not that.
Okay, that's all I asked.
Okay.
One more.
Yeah.
So how is that issue relevant to Mr. Reeves' defense?
It's relevant, Your Honor, because it actually blocks the light that was coming from the theater screen, which actually causes shadows in the individual that is causing the backlighting. That's the whole purpose of the backlighting issues, that phenomenon actually causes shadows when you're looking at.
Okay. What issue are you trying to bring forth?
I'm trying to bring forth the issue that this was Mr. Reeves's perspective, the actual backlighting. He actually experienced that during the actual shooting. And so because we have to stand in his shoes in order to be able to make that assessment, we need to have that factor, just like all the other factors that he was experiencing that day. Backlighting.
The
was-
totality of the circumstances.
Shadows and
The fact that the judge isn't bending
Okay.
over backwards
Okay.
to side with the defense here is really contemptible.
You mean with the prosecution?
All right, and in this.
No, she should be
low
siding
case,
with the defense. She
they
should
have
be
the
allowing
opportunity
this.
To
Yes.
review anything to do with the low case?
I have, and if it's okay, because I'm reading it to argue from a seated position.
You may.
The mannequin was used by the medical examiner in order to demonstrate to the jury the trajectories of the bullets. And in the low case, and I'm looking at head note, not head note, I guess it is head note 5 in the body of the opinion, it indicated, quote, the medical examiner then used the mannequin, which was slightly taller and thinner than Burnell and had valves inserted into it to demonstrate the relative trajectories of 3 bullets that entered the victim's body. The medical examiner testified because he could not state what position Burnell was actually in when she was shot. He could only give anatomical, not spatial trajectories, and that the trajectories had a small degree of error. And the court, in overruling the objection, actually asked, what would be the difference if it was off a few degrees one way or another? Because the analysis was, as the court was indicating, is it reasonably accurate? Is it reasonably accurate reproduction? And that was why in the low case, that mannequin was able to be used. In this case, Mr. Escobar just indicated exactly what our argument was. He wants to argue that this is the defendant's perspective. And there is no way that this camera held by a tripod on the floor in front of Mr. Knox sitting in his seat could possibly replicate the defendant's perspective. The only person that knows the defendant's perspective is the defendant himself. So that's exactly what we thought he was trying to admit for, to say this was the defendant's perspective of the backlight. It can't be any more misleading than that. Only the defendant can, it's his choice whether he wants to testify or not. I mean, Michael Knox can't say based on a picture I took using my eyes that this is what the defendant's perspective was.
No, he can't say that. But
That's what their argument was just now. This is being.
But they said they
shown,
won't
actually
have him
what's
say that.
relevant. His argument was the defendant's perspective of what the defendant saw regarding backlighting.
Your Honor, the issue is backlighting itself, not what is shown on those mannequin photos, because Mr. Knox can't say, this is exactly what Mr. Reeves says, but the phenomena of backlighting is what's important to us. And something that's very interesting in the low case. In the low case, they use those mannequins for a far more intricate forensic analysis than what we're using it for. And by the way, our mannequins are 5'9", so they are going to err on the side of conservative, because if they were 6'6", okay, they'd be arguing, wait a minute, it's blocking, more light. Our doctor actually did it far more conservative at 5'9". That's the relative size of the mannequin. And so I would say that what we're using it for is strictly for the backlighting.
all right, a couple of things of note. In the
Oh,
low
boy.
case, it points out the fact that the mannequins were not specifically identifying or made to look like the
No
individuals
blood came out of the
involved,
mannequins when you stuck them with the trajectory
so as
rods.
to perhaps evoke
They didn't scream in agony.
an emotional response from the jury. So I didn't see any issue with that in these mannequins. And so obviously, it would not, according to the Supreme Court, it would not be a good idea to use mannequins that are, more identically patterned after the individuals involved.
Had Chad's face on him.
Secondly, the
The face of rage.
no, I lost my train of thought.
No kidding.
Oh God, no one is surprised.
The overall impact, the size, as you indicated, Escobar, I believe in Chamberlain, which I cited earlier, the state used a much larger version of the weapon.
It was an asp.
Yes, and the court found that that was okay. In this case, as you indicated, this is a smaller mannequin. I understand the distinction there. Obviously, if you used a much larger one, that would be subject to further scrutiny. But in this case, as you indicated, it's more conservative. This is within my discretion, and in considering all of the aspects, the case law, the reviewing the photos that were provided to me, I am going to overrule the state's objection to.
Oh, finally, this is not a hard decision.
Demonstrative, and we'll get to it.
Your Honor, could we have just a limiting instructions? I don't know the best way to craft it, maybe something to the effect of, this testimony is being offered only to demonstrate the concept of backlighting.
Judge, I'm gonna go outside with the court's permission in a little while and instruct Mr. Knox, to stay within the parameters of his opinion. And that's only as to the fact that backlighting is created when an object comes in front of that backlight to create the shadow. That's gonna be his testimony. He's not gonna say anything beyond that. He was never intended to do anything else.
All right, so if there was a limiting instruction such as Mr. Rosenwasser indicated, I don't see any harm in that either, as to that portion of his testimony. Say it again.
This testimony is being offered only to demonstrate the concept of backlighting.
The amount of time spent on this issue is
All right, I think
unreal.
that's fair as to that portion of his testimony. So can we
I would agree with that.
pause?
And Judge, I would agree with that. I don't have any problem with that. That was our intent from the very beginning.
All right, so we can pause briefly before he begins that portion, which will include the PowerPoint.
I will make sure that happens.
All right,
Can I go and
let's-
talk to Mr. Knox now?
Yes,
Try
please.
to get that,
Before you go. Just
Immediately
one
to the
thing,
clicking.
The fact that they used a mannequin, I mean, it is kind of interesting to demonstrate the backlighting.
What?
So I've intended to ask him, and I don't know how you want to handle it. I don't want to open the door into, Pandora's box, so to speak, that, in this case, he chose to use mannequins. He could have used any object at all, but he chose a mannequin. I mean,
Judge, you chose a mannequin because of the fact that if he would have chosen a TV like this and it would have been, very, very dark, then we would have gotten objection. The reason is a mannequin is a human body. Human bodies have arms, they have areas of the neck that are a little.
Okay,
That's why we use
so Mr. Knox can certainly answer that without opening Pandora's box.
Okay.
Just that simply.
I will talk to him and make sure that he is.
Okay,
This issue just cost Curtis Reeves what, like $2,000? just on that. Think of it that way, guys. He just spent a nice weekend away with plane tickets on figuring out if they could introduce photos of a mannequin in a theater to represent that there was backlighting who shot someone, or when he shot someone. What a colossal waste of resources. Oh God. Stephen Oglesby says, notice the judge has a dark blue Law of Self-Defense coffee mug.
Everybody should. lawofselfdefense.com/mug.
Something tells me that's not true, though, about her. BN says, okay, defense wants to use the mannequin to show the trajectory of the light towards the eyes of the defendant. Kind of. They just want to. Several witnesses have testified that there was that the person looked like a silhouette. Well, everybody has the prosecution's kind of right. Everybody knows what a silhouette is. Sort of. Everyone knows what they think a silhouette is. But a silhouette in a backlit condition is a very specific type of silhouette. It means that there's light coming from behind it. It's not a cutout silhouette, like a piece of cardboard that's cut out to represent this outline of a person. It's nothing like that. It's an actual silhouette effect created by a human body. And so they want to bring in a picture to demonstrate that silhouette effect because it's going to matter when it washes out I'm guessing washes out the features of the mannequin, or there's a giant waste of time.
Mr. Knox said about why you use a mannequin and not a board or something, if that's what the court wants.
I don't care.
Okay.
If Mr.
Friday can't get here soon enough.
Bring that out on cross, I'm sure we'll hear. It's not that I don't care. It's just at this moment I don't care. It's okay. And that's up to Mr. Rosenwasser when he does his cross. But as I indicated, that's not going to open the door for every other thing to come in.
Yes, sir.
It'll be answered accordingly, and we'll go from there. All right, let's bring the jury back in, please.
Jurors in the courtroom, Your Honor.
Okay.
Jurors may be seated.
Thank you, ladies and gentlemen.
Click,
Were you all
click,
able to
click.
abide by my instructions during that brief break? Hopefully. All right, thank you. We're gonna get started again. Mr. Escobar?
The defense would call Dr. Michael Knox.
Did they call him doctor?
Yeah.
Do you solemnly swear?
Dr. Michael Knox, silhouette expert.
To be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
See how long this his CV takes.
Good morning, Dr. Knox.
Good morning.
Hey, Dr. Knox, your name
Doctor,
rocks.
would you please pronounce your name and spell it for the court reporter, please?
My name is Michael Knox, and first name is common spelling, last name is Knox.
Dr. Knox, would you please, I'd like to review a little bit about your educational background. Let's start with your educational background, if you can. Your college experience, obviously.
Sure. I have a bachelor's degree in mechanical engineering from the University of North Florida, a master's degree in forensic science from the University of Florida, and a PhD in criminal justice from Nova Southeastern University.
Let's talk a little bit about each one of those degrees that you received. First of all, your associate's degree. Let's talk about what the areas of concentration were for those.
For associate's degrees, I actually have two. One is an associate in arts, just general education, and then I also have a associate of science in criminal justice technology.
Okay. And when you went to get your bachelor's, what was your, I believe you indicated your major there was engineering?
Right, mechanical engineering. That's correct.
And explain to the ladies and gentlemen of the jury what that all entails.
Well, mechanical engineering is the branch of engineering that deals with the design and operation of machinery. So
That's Bill Nye's academic
a,
degree. Bill Nye, the science guy, has no science
engineering
degree.
degree.
He's got an
where you're
undergraduate in
doing
mechanical
heavy
engineering.
math, doing all the calculations to calculate things like stresses and strains in a machine, and heat transfer, fluid flow, and all sorts of
And
things.
no,
like
folks,
that.
engineering
So
is not
it's very
science.
math intensive, a lot of physics and
Damn.
mechanics involved.
Engineers
dealing primarily
BTFO'd
with
by Branca.
things that would involve moving machinery. So that's sort of the area.
It's not inferior. It's just different.
You also received, as my understanding.
Nobody wants to fly in an
master's
experimental
degree, is that correct?
plane
That's
on
correct.
And that
vacation.
was in forensic sciences. Explain to the ladies and gentlemen.
They don't want a plane made by a scientist. They want a plane made by an engineer.
So the forensic science program at University of Florida, they have different tracks, but the one that I did is the general forensic science track. So it's sort of a variety of different courses related to forensic science. Some of them are just general forensic science concepts, statistics, and various things like that. And then I took courses in things like bloodstain patterns, forensic entomology, which deals with the collection of bugs at a crime scene, and the utility that they have. Forensic biology and forensic chemistry, all different things like that. So sort of a general overview of the forensic sciences with a lot of detail on the technical side and the application of it.
You then also received your PhD in criminal justice. I know there was a focus of that PhD as well. Explain to the ladies and gentlemen of the jury what that PhD entailed.
So the PhD in criminal justice is primarily a research degree, a scientific research degree. So what you're doing there is applying a scientific method to criminal justice related problems and looking at various types of data. So you would be looking at things like it might be a particular criminal justice program to treat an offender. Does it work? And then you'd have to do the statistics to be able to figure out, is it actually effective or does it not change the outcome? You could be dealing with, all different sorts of problems, whether or not a particular laboratory procedure was effective just by applying, again, statistics and a methodology to that. And then I had a concentration within that of behavioral science. And I actually did my dissertation on the crime scene behaviors of school rampage shooters.
Ooh.
Let's talk a little bit about your law enforcement career. Tell the ladies and gentlemen of the jury when you first started your law enforcement career.
So I started as a police officer with the Jacksonville Sheriff's Office.
It's the most overeducated police officer that could exist.
In December of 1994. And I was a police officer in uniform for about 5.5 years. And then I went to the crime scene unit. So at the Jacksonville Sheriff's Office, all of the crime scene investigators are sworn police officers. So after you've done a certain amount of time as a police officer in uniform and patrol, then you can transfer to the crime scene investigations unit, which is part of the detective division. And so I spent 7 years there as a crime scene investigator, training coordinator, and then I left that unit in 2007 and spent 3 years as a traffic homicide investigator before I left the agency, took an early retirement in 2010.
Let's talk about those years as a crime scene investigator and tell the jury, if we can, what is a crime scene investigator?
So as a crime scene investigator, your primary role is to document and collect, preserve, and in some cases, analyze physical evidence from crime scenes. So your primary focus is on the physical evidence. And your job is really to secure everything and to first document and then to assess it and apply appropriate procedures for being able to collect, process evidence, for example, processing for fingerprints or collecting samples for DNA or doing things like that, as well as, doing other things, maybe documenting bullet trajectories or blood stain patterns or things like that.
So 3 of your years in that department was as a major case crime scene investigator?
Actually, I was a major case crime scene investigator for almost the whole time that I was in the unit.
So for the entire 7 years?
Yeah. So what happens is you come into the unit and once you've gone through training and you've gotten sufficient amount of experience that they feel comfortable letting you be the lead crime scene investigator in major crimes, which would be homicide cases, serious sexual battery cases, ones with injury or things like that, or police involved shootings, or there's certain enumerated offenses that would be classified as major case designated, and you have to be designated as a major case investigator to be able to be the lead crime scene investigator on those.
And that's what you were for Jacksonville?
Yes.
And you've also, I believe you indicated you had a title of training coordinator. Tell the ladies and gentlemen of the jury what that training coordinator position also entailed.
So from 2003 until I left that unit in 2007, I was in charge of training everybody else in the unit. So that meant I was providing a lot of the training to other people, new people that would come in, I would give them training, as well as do ongoing training with those people who are already in the unit. And then also I made sure that if there was any outside training available that people were able to go to, that, kind of organize that and send the appropriate people and those sorts of things.
Now, it's my understanding that you also had some coursework, some work within your department, for example, in the Institute of Police and Technology. Let's go through some of those if we can. Tell me what you did for that particular institute.
Well, I did went to a lot of training courses there over the years. So it's the Institute of Police Technology and Management, which is a training center for the University of North Florida. And IPTM trains police officers from all over the country, but even internationally, in a lot of different fields. They have a forensic science, forensic investigation section. So starting from the late 90s on forward, I took a lot of courses there in traffic accident reconstruction and things like that. And then probably starting early 2000s.
Traffic accident reconstruction. He just plows his truck into people.
Crime scene reconstruction, bloodstain pattern analysis, and a lot of other courses related to crime scene work, use of alternate light sources and things like that. And so I took, I don't know how many, but probably at least 15, 20 different courses from IPTM from the late 90s up until about the mid 2000s.
Some of those courses also included lighting optics. Is that correct?
I've taken the course on lighting optics and visibility for forensic investigator. That was actually not IPTM. It's another training company that put that on, taught by a lighting engineer, person who had a background actually designing lighting and systems and stuff. And that course dealt a lot with the documentation side, how to photograph lighting conditions and how to be able to take measurements and things like that.
There was another course you took, lighting and visibility for the forensic investigator.
Yes, that's the course I was talking about.
Okay. You had a Glock Advanced Armors course. What's that about?
Including that, I have that.
Several times up to the Glock factory up in Smyrna, Georgia, and they put on what they call armorer training. So basically, an armorer is a person who is certified by the company to work on their pistols. So if you go through the Glock armorer training, then you're certified to work on all models of Glock pistols, which includes diagnosing if there's something wrong with it, and
Oh,
changing out parts
diagnose
if the
me
parts need to be changed, things like that.
with sleep
You also took a
deprivation.
course called Street Survival Seminar, is that correct?
I actually took that one twice, way back in the 90s, actually right before I went to work for the Jacksonville Sheriff's Office. And I took it again in, I don't remember exactly what year, but early 2000s.
What is that course about?
So
Defending yourself from
there's
attacking a
something
movie
called
theater.
Press that they publish a lot of
You
books
took
and
movie theater survival.
training literature for police officers. Most of what they deal with is, tactics for police officers to survive armed encounters and things like that. And so I've been to that training twice. First time because of becoming a police officer, and second time because it more from the investigative side of staying current on what was being taught to police officers for them to do, so that if I went to police involved shootings, that I could, stay current to that information and know what type of evidence to be looking for.
You took a course on digital photography, is that correct?
Yes, I've actually had several different courses.
That was a YouTube course.
IPTM has a digital photography course that's digital photography for law enforcement. I've taken that one twice. And then I just a couple of years ago actually took a couple other digital photography classes. One on autopsy and injury photography, and
I'm going to need an autopsy very soon. I'm ordering one
You
right
also
now
took,
from Amazon.
your courses on homicide investigations in general?
Yes.
And how many of those did you take?
Well, I took one 40-hour class at IPTM that's on homicide investigations, and then I took another one on it's titled Injury and Death Investigation, which was at the Police Academy in Jacksonville in the 90s when I took that class.
Certificates that you currently hold?
I've had multiple different certificates. I actually was certified by the International Association for Identification, which is a forensic institute that has a crime scene certification program. I held their crime scene reconstruction certification for 10 years, but they decided several years ago not to continue that particular certification. So for those of us like myself whose certification expired toward the end of last year, they didn't offer a renewal. But I did hold that certification. I had to go through the process of getting that, which is you have to meet certain requirements, and then you have to take a test and then a practical in order to be able to get it. And then I did another test and practical 5 years later to renew it.
And you, that lapsed when? You said last year?
Just the end of last year.
So in 2014, you had that certification, is that correct?
I did, yes.
At some point in time, you left law enforcement, is that correct? Tell the
That's
ladies and gentlemen of the jury why that happened.
I started doing consulting work as a part-time, and I began to get too busy and basically was working two jobs. And so I was able to take an early retirement, invest my time and leave and still get a pension, eventually. So I made the decision to leave the Jacksonville Sheriff's Office and then go full-time into the crime scene reconstruction.
What's your hourly rate for this case?
And what is your specialization in your consulting work?
So
Silhouettes.
crime scene reconstruction would really be what I would call my specialty, with other things that go underneath that, with a particular focus on shooting incident reconstruction. So the majority of the work that I do is reconstructing shootings or firearms involved incidents. And of course, that includes doing things like bloodstain pattern analysis and bullet trajectory work and things like that.
Members of associations?
Primarily, I'm a member of the Association for Crime Scene Reconstruction, or what's known as ACER, which I've been a member of since, 2008 or 9, something like that.
Are you still a member of the American Society of Mechanical Engineers?
I did not renew that one, I think in the last year or two. Primarily what I've decided is in terms of focusing on professional organizations is that it's related directly to my field. So ACER would be the one primary organization.
Have you been published in the past?
I have.
And let's talk about some of those, and we'll probably go from the, I'll give you just a few. Forensic engineering applications in a crime scene reconstruction. Did you author that paper?
I did.
Okay, and was
So that
paper
discussion
also
about the mannequins took about an hour.
Would you explain to the
Almost an
ladies and
hour.
gentlemen of the jury what that means, being peer reviewed?
Yep.
So a peer-reviewed
Oh, a complete
paper,
wasted
technical
hour.
paper or scientific
49 minutes
paper
and
is
30 seconds.
one
Not
where
counting the break
you
in the middle, so she
submit
could
it,
look up her Westlaw
it has
password.
to go through various steps of approval. And one of those steps is that it gets sent usually to two reviewers who are experts in that field or that have the appropriate background, who will then review that paper and make a determination as to whether or not it meets the scientific rigor for whatever publication or whatever conference it's being published at.
Another one that you did, the forensic engineering analysis of ejected cartridge case patterns for reconstruction of firearms related incidents. You wrote that paper as well?
Yes.
And that paper also reviewed?
Yes.
Forensic analysis of an accidental firearm discharge due to a blow to an exposed hammer spur. You did that one as well?
Yes.
Forensic engineering analysis methods employed for the purposes of determining the location of long-range shooter based on terminal bullet trajectory. Did that one as well?
Yes.
No. No, I didn't do that one.
Okay. Books. Tell us about books.
Well, primarily, I was involved in, and an associate of mine had written a crime scene processing manual, basically on A to Z's of processing a crime scene. And then for the second edition, rather than updating the book, we took the entire book and turned it into an online format. It basically was delivered on a DVD so that somebody could put it in the computer, and that allowed us to actually include not just the text and the photographs that were in the book, but add videos and multimedia stuff to be able to sort of explain and demonstrate all different kinds of crime scene processes. So if a crime scene investigator needs to know how to document a footwear impression, we had that in there, explaining how to do it, and had videos actually demonstrating the process. If they needed to be able to take measurements of something, then we had it in there to be able to explain that. So we sold that for probably about a 10-year period. I don't think that there's been any sales on it in the last couple of years, but for a while it was published not just by us, but also a third-party company that sold forensic equipment and supplies carried it in their catalog.
Teaching, have you held some teaching positions?
Yes.
People who sell books
Would
are
you, tell
terrible.
the ladies and gentlemen of the jury about your teaching positions in the.
I was
area
professor
of
emeritus in the School of Hard Knocks.
Specifically in forensic.
Well, the main teaching that I do is for the Institute of Police Technology and Management.
The main
where
teaching that I do
am
is a
an adjunct
BDSM course.
instructor, and I am the lead instructor for shooting incident reconstruction classes. So I teach that class every year in Jacksonville, and then we teach it periodically on the road if an agency requests.
Can't believe this guy's grifting a book.
Out of town was in
So rude.
Sacramento, California, for the California Highway Patrol.
It's terrible. Disrespectful, really.
And then I've also have taught as an adjunct instructor. I taught a forensic. There was a forensic science class for Kaiser University, and then I also taught a
Some folks
class
call it
on,
a sling blade. I call it a
crime
Kaiser
scene
blade.
and forensic investigations for Flagler College.
Have you also taught and lectured abroad?
I have.
And would you explain that to the ladies and gentlemen of the jury?
So I taught a shooting reconstruction class in the Republic of Georgia, not the state of Georgia, the Republic of Georgia, over next to Russia. And that was under contract with the U.S. State Department.
I'm going to run and grab
for the Georgian police.
some breakfast real quick. I'll be right back.
And then I've also taught a couple of courses, general crime scene courses for a company called Cervical Fingerprint Laboratories, which is a company that manufactures and sells crime scene equipment and supplies. And I taught that course in Dubai, in the United Arab Emirates, for the police and their forensic science laboratory there. And then I've taught that class twice to different groups of prosecutors and medical examiners in Peru, in 2 different cities in Peru.
And have you been qualified as an expert in the field, in your particular field?
Yes.
And can you tell me if that was in
Don't forget the 70% off sale, folks, on the hardcover version of the Law of Self-Defense Principles, lawofselfdefense.com/hard sale.
Several other related sort of subfields of the crime scene reconstruction.
Let's start out about talking about how is it that we engage and investigate a crime scene from the very beginning. What do you do as a crime scene investigator? What are you required to do as a crime scene investigator when you first take on that responsibility?
The first part of whenever you get there is just what I call data collection, or collecting information, essentially. That's going to start with information where you're going to get at least some idea of what's the nature of what happened. And then you'll begin to assess things like what's the extent of the scene? Where did this all take place? What kind of physical evidence is present? And you begin documenting that. So initially, what you're really trying to do is just document and collect everything and gather all the data that you can gather without really making any decisions on anything. You're not trying to figure out really at that point exactly what happened or who was involved. You're trying to figure out what evidence is there and what information do I need to collect, what do I need to document, and what's going to give me the information that we're going to need to be able to start piecing everything together. And then as you document through photography, through measurements, through actual collection of different types of evidence and various different types of processing, depending on what you're looking for, then you would move into where you start to piece things together and figure out what it means. So now I have information and I know this. And so what does that mean? What does it tell me about what took place? And then you begin just steadily and methodically working through all that to be able to eventually get as complete a picture as you can of what actually took place and what is it that you need to find out.
So are you telling me then, well, let me ask you this question. Does a crime scene investigator just go into a crime scene and allow the crime scene technicians to do whatever they want to do or whatever they feel is appropriate to do? Or is the crime scene investigator heavily involved in the entire process of the investigation?
You should be heavily involved. So basically what you're going to have is in a situation like you have here in Pasco County, where you have non-sworn forensic investigators and you have a detective that's assigned to the crime scene whose job it is to oversee what's going on, then the biggest piece of what's happening here is communication back and forth between the detectives that are doing interviews and that are finding out different pieces of information and making sure that that's communicated with the forensic investigators who are actually doing the evidence collection and documentation. Because you have to have some idea of what's going on to really know what to collect, to know what evidence to process, and to know what's important. If you don't really know anything, then you wouldn't know what's out of the ordinary, what's part of the scene that's ordinary and isn't really part of what took place, and those kinds of things.
How critical is that aspect of doing a proper investigation, knowing what others are gathering in the form of information?
That it is, you really couldn't overstate the necessity for that. You have to make sure that you're communicating, that you know all the information that's coming in, because you can find out things in a crime scene where somebody, there may be something that's related and you have no idea that it's related because that hasn't been communicated.
Has the state objected
So
yet to
you
his
have to
characterization
find
of the
out not
mannequin?
just what's there
Not
in
yet.
terms of physical evidence, but every
You
piece
know
of
that's
information
coming.
that you
I
may
haven't said the
know
word mannequin yet.
about a crime. Even when you have a crime where nobody witnessed anything and you have nobody alive to tell you what took place, as a crime scene investigator, I still need to know what information is known. Things like when were people last seen alive, or what's the parameters of what took place? Where might things have happened? Where did this person go? What do we know about it? So there's a absolute necessity for communication going between the detectives that are doing all the interviewing work and the crime scene investigators and technicians that are documenting and collecting all the evidence.
Obviously, there could be two types of cases. One is who did it, right? And the other one is what?
That's right. Basically, you can understand physical evidence in two terms. What we call associative evidence, which is evidence that tends to associate things with people or things with other things, or maybe things with a location.
Things are things.
And associative evidence typically goes toward the question of answering who was involved, who did it, so sort of the classic of that would be like I was giving the example of a homicide. You get there and there's a body. And what you know is that this person's been killed, and that's all you know. Somebody found them. When you go to a scene like that, your primary focus is on associative evidence. What am I looking for that's going to help me identify who was here to try to figure out who actually committed this crime? The other type of evidence that you deal with is what's called reconstructive evidence. So that's evidence where you're using it to figure out what happened, not necessarily who. Now, you can be doing both in some cases where you're looking at associations and reconstruction of what took place. But certain cases, and this would be one of them, where the who is not really a question. So the real focus is what happened, and what you're doing with the physical evidence there is going to be centered on determining what took place.
So the dynamics of what happened is critical in the gathering of relevant evidence. Is that a fair statement?
Yes, I think that's a fair statement.
And so how do you go about then gathering the information that you're going to use to try to preserve evidence of what happened? How do you go about that?
It begins with having, you have to know and understand what's the extent of your scene and where your evidence is going to be found. Because then you know where to search, you know what areas to document, what stuff to measure, what things need to be collected, and what's the area that you focus on. But you can also have things that you're looking at that aren't necessarily like a piece of physical evidence that you're trying to find, but documenting things like if you have an incident where you have a number of different witnesses, then you could be also needing to identify where were these people and what were they looking at when they saw or heard or perceived various things that they've discussed or have told the detectives, so that you can document from their perspective. And there's a couple purposes on things like that. You're actually documenting where they were so that it's known, but looking at things like how far away is the person? What's the line of sight for that person? And you can also get into what's the lighting, what would they see under the lighting conditions, things like that. Because the idea is, one, to be able to test what anybody says for accuracy. Is it correct or not? And two is just to be able to have a record of that later as to, from this perspective, you could see this. So that's why you're
pretty interesting that they
back
have
and
a
forth, and then you're looking at everything that you need to document.
an expert
collect,
investigator and crime
and
scene
in a particular
reconstruction
scene.
expert here when
Obviously, you know,
the
this is
crime
a
scene here
self-defense
was not preserved well, not
And so
investigated
how
well.
important, we're just going to get back to the witnesses in just a second.
And that's why they have them, obviously. But
How important is it for the crime scene investigator and the lead detective to determine whether there has been contamination that may have taken place there at the crime scene? How important is that?
That's something you'd want to make sure you knew as much as you could about what happened in terms of the scene. And by contamination, you can have a lot of different things that can take place. One being is whether or not physical evidence is moved or touched or anything has happened to it between the time that the incident took place and the time that you're arriving there to document. If anything got moved, then you need to know that it got moved, and you need to know where it came from and try to get the best possible evidence as to where it originally was. Where did it come to rest when everything ended? As well as making sure that all the evidence is handled such that you don't destroy anything that might potentially be important. Because it could, even though you have a shooting scene where you're really focused on reconstructing what happened, there can still be important associations and associative evidence that you could be looking at, trace evidence of things, maybe DNA or fingerprints or things like that, that could tell you what events took place. One I get on a not infrequent basis is where somebody's, say, struggling over a gun. So we need to know that there's some type of struggle that took place with the gun, because we could be looking at DNA or fingerprints from the people who were struggling over the gun to try to verify whether or not they actually were struggling over the gun. So that's really the importance there.
So we've talked about contamination, obviously, with evidence. Is there such a thing called contamination of witnesses?
Yes.
Explain to the ladies and gentlemen of the jury what contamination of witnesses entails.
Well, the biggest thing with witness contamination deals
Well, he's
with
talking about a lot more than silhouettes.
not wanting witnesses to talk with one another about what happened, so that each person that you interview and get information from is giving you their recollection of what happened. And they're not getting pieces put in it from conversations that they had with other people. Because what you want to know is what does that person know? What did they actually see or hear? You know, where were they? And you want to understand how certain they are about it. Whereas if they've talked with other people, then they may have had additional information added to what they recall, to the point that by the time you interview them, that those things can no longer be separated.
Would you agree or disagree that individuals that sometimes listen to others actually start believing that they themselves may
again,
have
with the
seen
agree or
heard
disagree crap,
what they've been contaminated with?
It happens frequently, yes.
And tell the ladies and gentlemen of the jury how dangerous that is in our criminal justice system.
why don't you just
the
ask him
biggest
how dangerous
problem with
that is in the criminal
is
justice system?
that you're not getting that person's actual knowledge and recollection of what happened. And see, when you're doing crime scene reconstruction, I can't take what a person tells me and then I don't have some magic way of knowing whether it's true or not. What I have to do is take what they say and compare
The
it to
judge is in her
physical
happy
evidence to
place.
see
She has
whether or
found
not
her
what they
pen
say
to
is
click incessantly
possible,
for the
not
remainder of the
possible,
trial.
whether it's consistent with or inconsistent with physical evidence. And so you have to be able to assess those factors within what a person tells you that are reliable pieces of information and those pieces of information that aren't reliable. When people begin to talk to one another and begin to adopt things that they've discussed amongst themselves, then you begin to have multiple witnesses telling you things that perhaps if they had been separated and they had not communicated with one another, you would get a piece from one witness, and you might get a different piece from another witness, and then maybe a different piece from another witness. And that helps you to be able to separate what people actually know and saw and heard, as opposed to getting kind of the chicken soup at the end, where multiple different people's recollections are kind of thrown into one bowl, and they can't really tell who actually saw and heard what.
And so the issue of separating witnesses, is that a concept that you learned early on in your law enforcement career?
Pretty much a day one concept. Yeah, pretty much.
Meaning your initial training as a police officer, the police
Right.
academy, I should say.
Right.
They teach you this concept of you come to a crime scene and you do what? Witnesses are there. What do you do?
Yeah.
Separate them, right?
Yeah, you're in police academy training. You would, as a patrol officer, would be taught.
Oh my God.
Your first priority when you arrive at a crime scene is safety, making sure that there's nobody that's about to be hurt. Second priority is making sure that if there's an outstanding suspect and somebody that may potentially be dangerous, that person is dealt with. Your third priority is secure the scene and make sure nobody touches anything and does anything to change the scene beyond what it is right now when you got there. And that you're very close to that would be your priority of separating witnesses and getting people off the places where you'll be able to interview them and get their recollection of what they actually know about what happened.
And so you've talked about the dangers of contamination. What happens when you come onto a scene and you realize that multitude of witnesses are talking to each other? How do you handle that problem? If you can.
Well, if you've already got where people are beginning to talk to one another, if you want to separate them still as fast as you can, because they may have talked about certain things, but the longer you let them stay together, then the more they're going to talk about what happened. So as fast as you can, you need to separate them. But then what you would do is in that process of interviewing people and figuring out what they saw, you need to sort of understand, if you came up and there are people that are talking to one another, keep track of who's talking to who, so that you'd know that these people were in conversation with one another. And you ask them too in an interview. You can ask the person, have you talked to anybody else at this scene? And then you can also start to look at things like when you have multiple witnesses telling you the same thing, to question them about, did you actually see that, or did you actually hear that? Or is that something that you heard from another person? Because sometimes the person will tell you, they'll say, oh no, I didn't actually hear that. So-and-so.
So I know this is super boring, but
and then
this is important to their case.
That person doesn't actually know,
because they've been trying to establish the entire time
they were told that
this investigation was shoddy. Now they have an expert up there telling you why it's shoddy.
Obviously, you can't unring the bell of anything that they did hear, but you can at least try to get a handle on what they heard and what contamination may have happened.
Would you agree or disagree that becomes even a much greater problem if you have an emotional scene, for example, in a shooting? And if so, why?
It is always, one of the biggest problems with dealing with scenes, especially in the initial few minutes of arriving at a scene, is that there's a lot going on, a lot in terms of what's happening. If you have a lot of people there, then you have a lot of emotion going on. You have a lot of things happening, and you have to separate people, not just from the standpoint of them not communicating, but it also helps calm the whole thing down. Because when you let people sit quietly and reflect quietly on something, then they'll have a tendency to calm down more than if they're talking to one another, and perhaps conversations can get people going. You sort of want them to get them thinking of what they remember and kind of get calm in that, and it'll be easier to interview them once they've had some chance to calm down.
The process of trying to investigate those witnesses that have been contaminated, would you agree or disagree that part of that process is actually testing their recollection? Meaning, where were you seated? How far were you from the seat 9? Taking them back actually at some point in time into the crime scene. Is that something that should be done when you realize that there is contamination in your crime scene?
It's good to do even without contamination, but to take a witness and actually interview them at the place where they were. You can interview somebody in a separate location, get preliminary information, go through their account of what happened, but it's a really good idea to take that person back to where they were to walk through it, because a lot of times it'll help them to sort of trigger their memory where they remember things, because now they're actually seeing. So they're looking out there and they're actually sitting there looking at the seats in the movie theater where they saw things, and they're able to sort of get an understanding. And sometimes you get witnesses where you take them back and they've told you stuff, and then you take them to a location. You say, okay, now was the person over there? And they'll stop and look and go, I remember this being over here, or this. In other words, they realized that there was something false.
This actually was a big problem in the Michael Brown shooting, because they had a lot of witnesses who were repeating rumor and claiming it as firsthand knowledge. And then when they were questioned in detail critically, it turned out they were physically located on the other side of buildings, for example. They couldn't possibly have seen what they claimed to see.
Sometimes what happens is you take the person back and then
hiding behind a car
there's a line of
with
sight
no
problem.
view
Couldn't
of
even
Michael
see
Brown
it.
or Darren Wilson.
Or there's something in between, or there's some type of issue that maybe they couldn't really have seen what they said. So it's a really good idea to get them to show you, and not just go back in and look at it, but have them demonstrate it. Where were you? Okay, you were sitting in the chair. Well, how about having a seat back in the chair? So you turned and you looked over
Nobody
your shoulder.
on
Okay,
God's
so you
good
show me
earth
how you
is
looked over your
innocent,
shoulder.
but Curtis
And go
Reeves
through that
looks
whole
increasingly not guilty.
And do you document that? And do you preserve that process as well in a crime scene diagram or some other form, so that others like myself at some point in time can see that?
Yeah, the primary ways that you can document that is photography is one. And by that, you could photograph the area where the person was, and then take pictures from where they were back in the direction of where they were looking to see what they saw. You can include them in a diagram. So that's quite typical, would be to put a diagram together and then show each person's location on that diagram. Measurements. You could collect a measurement from where they were, say just a straight line measurement, over to where they were looking, so that you have some record of how far it
Just
was.
cannot stop.
And then you can also
They're going to find her one day with a
during the
pen
process
embedded in the back of her
interviewing them,
skull.
you can audio record it, or you can even video record that interview with them, so that it's all completely documented and recorded for any.
I mean, the
need
amount
later
of clicking, it's
Let me ask you
actually
a question about
embarrassing.
recording, which is maybe somewhat interesting. Law enforcement officers don't have to tell the individuals that they're interviewing that they're recording them, right?
That's correct.
Perfectly legal, right?
That's correct.
You don't have to, spook anybody that you're recording them. You can put the recorder in your pocket and fire away.
That is correct.
Is that correct?
Yes,
Okay. Is that a tool that's used quite often by law enforcement?
it is. It is.
Kind of
A lot
blew
times
up
if
that
I was
whole
interviewing somebody with
investigation strategy of having a pre-recorded conversation.
Know that, but I would by no means required. In fact, depending on the particular location and stuff, you can even record people without you being present. So, for example, the backseat of a police car, it was not uncommon that we would have a.
The longer this goes on, the later she gets for that Bud Light for lunch.
Two people that you believed were involved in
The
a crime.
more frequent the clicks until it's a solid tone in the
In
background.
the backseat of the police car, turn the recorder on, or some of the units now even have wireless microphone systems, so the officer can stand outside and listen. And then they have a conversation. Hey, tell them this. Then you know that, and so then you're able to challenge them with, well, you said this, but you and your buddy just made that up in the backseat of the car, didn't you? So you can freely record certainly any conversation that you're a part
what we've been talking about, and I'm going to call it verifying a witness's statement or refuting it through forensic processes. Is that more important in scenes where you have the incident occurring with limited light?
That's
Chad Olson was definitely in imminent threat. Folks. Imminence is not really an open question here. He was
like in a movie theater.
he was committing a battery at the very least on Curtis Reeves when Curtis Reeves shot him.
Atypical lighting conditions.
You may disagree about the degree of threat. That's fine, but it was
fairly,
definitely imminent battery. It was
fixed amount
actually
of
taking
light that's
place.
steady throughout the room, and it's pretty consistent throughout the room. Obviously, in a movie theater, while you have something playing on the screen, the lighting conditions not only are quite a bit darker than normal lighting like this, but you have lighting that's constantly changing because of what's on the screen. So that is something that's becomes really important to understand how that would affect what anybody saw or perceived, and you'd want to be able to document those things.
Would that likewise be important when you have a scene where, for example, in this case, previews being played loud?
Sound also, yes, is an issue because
Maybe the clicking's the court reporter.
particularly where you
I
have
guess
people that are
maybe that's it.
reporting things that they heard, that you want to make sure that they could hear it and that there wasn't going to be any interference with what was playing. And then in fact,
Man, people are steamed up about my engineering comment.
What was going on.
Folks, engineers can do science and scientists can do engineering, but science and engineering are not the same thing.
Would you agree or disagree that two of the most important
Walks
senses
it
that
back,
have
walks it
human
back in
beings
real
are?
time. Can't believe the dishonesty of Andrew Branca.
Why is that the case? Why are they so important?
Well, in most of the time when you have somebody that is what you'd call a percipient witness, a person who perceives something related to that's going to be, they either saw it or heard it or both. It's not uncommon where we'll have shooting cases where a person never actually saw anything, but they heard something. Sometimes you have cases where they don't hear anything. Maybe they're inside a house and they're looking outside and they see it, but they don't hear it. But obviously, if you have a shooting incident that takes place in a room and there are people there, then potentially they're going to both see and hear it. That's probably about the only thing they're going to really perceive, but they will certainly see and hear based upon what they're looking at and what they're able to hear.
And that influence of light and noise, could that have an impact on the accuracy of what they're saying?
It could, because again, just like talking about line of sight and going where the person was, the lighting conditions can affect what they could see. I can obviously see a lot better in this room with lights on than
Well, I agree with that comment. Fuck Bill Nye.
So you'd have to really,
Well, yeah.
you want to know that.
Bill
You wanna
Nye can eat
understand what
shit.
could a person actually see based upon those lighting conditions and how it's going to affect what they saw.
Would you agree or disagree that there are tools that are available to preserve?
Would you agree or disagree that the prosecution team's average
Yes,
height
there
is
are.
5'1"?
You tell the ladies and gentlemen of the jury what tools forensically are available.
The very word
to
STEM,
preserve both light and
folks,
noise.
would suggest to you that science and engineering are two different things.
Lighting conditions
We have
can be
different words
documented
for the two different things.
with photography, and can be documented with taking a light
Hey,
meter
look at
and actually
this.
getting readings of how much light
There it is. Thank
Nice.
you.
there is. And
Birds of a
Arrived
feather.
intact.
sound.
Lawofselfdefense.com/mug.
Documented, could record it.
It's not just for coffee,
And you
Nick.
can also use a sound level meter.
Trust
to
me.
see how loud this particular sounds are.
Would you agree or disagree that in a self-defense case, the perception of the accused is extremely important?
It is important, yes.
And so would you agree or disagree that the individuals that are investigating a self-defense case should certainly have the competence to know how to deal with those particular cases, correct?
Yes.
And so if you had arrived at a crime scene and the lead detective in the case clearly did not have the competence to understand and investigate a self-defense case, tell ladies and gentlemen of the jury what you would do.
Well, one of the things that you have to do anytime that you're investigating any type of a crime scene is know your limits. Those limits can be based upon
I have no limits. I
your
am
own knowledge
limitless.
and training.
No limit, Chad.
Those limits could be because you don't have the equipment.
Chad was limited
Those
only
limits could be
by the
because
extent of
You
injury.
just don't have the experience with it, and you're not comfortable in terms of having enough practice, basically, with a particular process or something that you need to do. And so you have to consider your outside resources. The biggest thing with a crime scene is that once you
Imagine
get
if Nicole Olson goes to the gun store to
You
buy
can
a gun
control
for
that scene
personal
as long as
protection,
you
and the
can.
guy behind the counter discourages her from getting a
There's
380
not
because they're not very
anything that
effective for
legally
self-defense.
prohibits From holding a scene, you may have to get a search warrant, and you may have
I
to
beg to differ, sir.
go through some hurdles, but those are easy hurdles to go through. And I
They
have
said they
worked
would
crime
easily
scenes
get this
where
done
we've
before
held
lunch. I
a
just want to
scene
remind everybody
for
of that.
5 days.
The lies,
And
the
potentially
lies
longer
of the
if you
defense
needed to.
attorneys here.
Because
The judge is going to reverse her
once you let
motion,
it go,
her order.
it's gone. You
bastards.
You have to assume that whatever evidence you wanted is gone, because even if you went back and found it later, the argument
There's
is
a foot-long steak and cheese and 2
preserve the
cans
scene.
of
How do you
Bud
know that
sitting
that's
back in her
the
office.
evidence that was there? So you have to do that step. You have to document all these different things, and if it requires getting outside help, that outside help is available.
And where would that outside help be available if you need it?
Well, the first place that, being a police officer in Florida, the first place that I would look to for outside help would be the Florida Department of Law Enforcement, because they have forensic science laboratories at various different regional laboratories throughout the state. And so they have a lot of different people and provide a lot of different forensic services through their laboratories. If FDLE is not able to provide that service, then your next step would be looking at other law enforcement agencies, perhaps federal, FBI, Bureau of Alcohol, Tobacco, and Firearms and Explosives. They have their own laboratories and their own experts in various things. There could be other ones. And then past that, if you can't find it in a forensic science laboratory, a government laboratory, or law enforcement agency, then you look to private sector people like myself that do stuff. And I actually have done some cases where I've been called by law enforcement and brought in to help them with whatever particular issue that they were dealing with, in order for them to figure out what happened and be able to make a decision as to whether or not to arrest somebody.
Would you agree or disagree that if you have the lead detective who was not well versed in the issue of
This notion in the comment that they did a bad job because they were trying to protect Curtis Reeves is kind of silly, considering within minutes after the shooting, they arrested him on a charge of second-degree murder.
No, in most agencies, you got somebody in the
I've seen
agency
that
that's got
a couple times, and I don't get the
some
idea.
background with that. So,
And it's like the long con of
there may not be the one
covering for
that's got a
Curtis
lot of
Reeves by
background
throwing
in
this case 8 years
If there's
later.
other detectives,
It just doesn't make any
and
sense.
Typically, when you're at an agency, you already know.
If they lose this
I mean,
case,
it's
they
who
look
you work
like
with, so you
absolute
know
idiots.
Who it is that I would get calls because
I mean,
had
just because that
kind of
seems
a
like it might
specialty in
happen
doing
doesn't mean
shooting
that they don't look
reconstructions
like
and stuff,
idiots.
Where detectives would come to a scene, there'd be another crime scene investigator there, and the detectives would. Next thing I know, I'm getting a phone call from my supervisor saying, "Hey, the
This guy's still going to be talking when I get home from Texas."
because they recognized that I was able to do things that
No lies
maybe the ones
detected.
that were out there didn't have as much experience with. So
No, Branca. Who arrested Curtis
Between
Reeves?
your own
Not the
agency
police,
and
not the detective.
other law enforcement
Yeah, it was
agencies
actually the
and
detective.
worst case, the private sector.
Yeah, the
to
first
find
guy,
the assistance that you need.
the dumb detective was the guy who did the.
Let's continue on this road
did
of
the arrest.
perception if we can for a bit longer.
We have him on video or on audio saying how sad he
is
was
the
that he had to
environment
arrest Curtis Reeves.
of where a shooting takes place. Is the environment important? And if so, why?
Well, the main issues that you have with respect to environment, it's always important. There's always going to be something about it that's that you need to understand. But you need to be able to understand the constraints within a particular environment, meaning what things limit what could have taken.
A lot of people get shot dead by 380s, folks, mostly because you can put a 380 into a very inexpensive firearm. So a lot of cheap street guns fire 380s
pretty much all
because you don't need a very complicated recoil system.
What that's like when you go in and you sit down, and especially if you're not at the end of the row and you're in the middle of the row and you have to go from the end of the row to where your seat is, those kinds of things that create constraints as to what could take place. There's a lot of chairs in the way. You have a very limited space between there. You also, in a movie theater, you have things like step down from one level to the next level. That's not, normally if you're in a room like this, it's all at the same level. In a movie theater, it's not. So you have to be able to document all those things to know how is that affecting what could happen and what somebody could see or perceive.
Let's talk about some of those issues that in the environment could possibly affect perception. Would you agree or disagree? I think we've talked about lighting. That's an easy one, right?
Right.
We've talked about noise. That's an easy one. Is that correct?
Yes.
Physical layout. How does physical layout sometimes affect one's perception?
Physical layout really more than anything has to do with, like I said, the constraints, the ability to move, the ability to see what's there and what could, affect how you perceive something.
The 380 and the 9mm are not the same size, folks. They're the same diameter. The 380 is a shorter round in terms of overall length.
Movement. How does it affect the way somebody can move or react to something that's happening, things like that.
Now, in this particular case, we had video cameras, surveillance cameras in this theater. Is one going to get the same perspective that the accused has if he's sitting in seat 9, back row, as you get from a video camera that's up 30, 35 feet up in the air?
No.
And
Oh,
explain to
God.
the ladies and gentlemen of the jury
You're
why
not?
you don't get the same perspective.
Multiple different reasons. I mean, not the least of which is that the video camera is not really giving you the same perspective. Even if I had a video camera sitting right next to my eye right now, the camera and what people would see watching that video would not be identical to what I see.
Are we starting to get into this
But
a little bit? What they called
The
them up for?
location of it is significant.
Oh my goodness.
In fact, one of the training, whenever I teach a shooting reconstruction class, I talk about video quite a bit because, especially nowadays, it shows up so much in the cases that we work. I have an example case that I use where there's two different in-car, it's a police-involved shooting. There's two different cameras, police cars that have in-car video cameras that record the incident.
Objection relevance to the question that was asked.
It's very, very relevant. He has explained that process and that problem.
Overrule.
And what happens there in this particular one is one of the reasons why I train on exactly this topic is that the first video camera, you play it and the way that the shooting looks is it basically looks like a guy's walking away from the police and they shoot him in the back and kill him. And even in a room full of police officers, you play the first one and most of them like, wow, what was that? And then you show them the second car. And in the second car, you see the guy pull an object out that looks like a gun, point it at one of the officers. And there's a lot of information that's not captured. So whether you have multiple cameras or even multiple witnesses, wherever I am, I'm seeing something that even somebody that may be close by me doesn't see exactly the same way I saw it. And certainly a camera is the same way. If I've got a camera that's way mounted up on the ceiling over there, it's not seeing this incident the same way my eye sees it at the time.
So what do you do with that? That's a problem. How do you try to compensate for that?
Well, the main thing there is to document as much as possible from the viewpoint of any given person that you're dealing with, whether it's a witness or whether it's the person that's actually involved in a shooting, to get their perspective. So if you have, say, a shooting like this, where you have a person that's in a movie theater seat and shoots somebody, I would want to go back to that movie theater seat and have them show me, just like I would with any of the other witnesses out there. I'd want to bring that person back in, put them back in that movie theater seat and have them explain everything from that perspective, and then look at it. They say, I saw such and such. Okay. Can they see that from their positioning? What kind of lighting? And you can go through really in detail with them. What was the lighting like at that point? What could you see? And get the details of it, and then document that the best that you can with photography and the video, if possible, and those kinds of things, to be able to know and one, keep a record of it, but also to sort of test the veracity of what you're being told.
And if you're in a theater like the Cobb Theater, and would you have the ability to go to management and say, I want you to turn that lighting to mid one?
Certainly. I mean, as long as that the movie theater's cooperative, which in this case it was, then you could simply ask the management I myself went to the movie theater and did exactly that and said, show me the lighting level. And they explained the different lighting levels, and they set the different lighting and things like that. And of course, if you needed them to replay whatever was on the screen, things like that, just ask them to do it and see what what you're able to document and do with that.
And if they refuse, you have subpoena power and you have search warrant power, right?
That's right. Investigative subpoena, which basically, as a detective, all you got to do is go to the state attorney's office and ask them to prepare an investigative subpoena. And then you can also, if necessary, get a search warrant, draw up a search warrant, take it to the judge, have it signed, and then and then at that point, the theater doesn't have a choice.
Dr. Knox, in a situation like that happening in the theater, would you yourself, as the crime scene investigator, would you sit in that theater and have the lights dim to mid-level one and have the previews play?
Objection relevance.
Overall.
Would you?
I would, yes. I would routinely in shootings look at those kind of things. And in fact, I even teach it when I teach a shooting reconstruction class.
Of course, it's relevant. A whole theory of the defense case is that to the extent there's a lack of corroborating evidence for self-defense, it's because the investigators failed to collect it.
Right.
Parameters for viewing. Why would you do that? Why is it
And
important?
it's relevant because, they interviewed the detective.
Well, several things.
And impeached the
part of it is that you
impeach the investigation specifically.
because you don't know what questions are going to come up later on. You don't know what issue may arise later on as you go through an investigation. So you want to document what's there. But also, more than that, is because here's a scene where you're trying to reconstruct what happened. That's sort of at the center of reconstructing it is knowing what are the conditions, everything in terms of the conditions at the time that would affect what a person saw and perceived and what they're responding to.
In you mentioned bringing the accused to sit there in the seat. What sort of information would you want from the accused in your questioning of the accused in order to give you a good perspective over what the accused was possibly seeing and knowing at the time?
Well, you really want to understand with whether it's the person that's the shooter or any person, the witness or anybody, you want to know what it is that they say that they saw, and you want to test it. Because obviously, if something that a person is telling you is inaccurate, particularly if they're the person involved in the shooting, you want to confront them with the fact that it's inaccurate. So you might find something that as you bring them in, you test it and they've described something and then you realize that's not possible. So then you would confront them with, well, that's not possible. So, explain to me why you say this, but this couldn't have happened. Because one, you're giving them the opportunity to correct if there's something wrong in their recollection, or you're trying to see what a person may be doing. So if a person's being deceptive, for example, you keep testing them on those things, and then you just find that they keep changing their story, and that would tend to lead you to, think that maybe they're not being truthful. So it's not just about coming in and then just taking what somebody says at face value. It's about testing what they say to make sure that it's true and accurate and it's correct.
Obviously, you have participated in police-involved shootings in the past. Is it important to know?
You participated in police-involved
police
shootings? How many
officer
people have you shot and killed?
The body of knowledge that the police officer has.
Yes.
Yeah, I'm going to object to that. May we approach?
Yes, you can approach.
Your Honor, it's time for lunch.
It really is, though. I mean, this is really long. They haven't gotten to the demonstrables yet. This is, they represented that this would be quick. This is going to be anything but quick. Ugh. Blech. Blech. But I mean, I guess you gotta challenge what happened. That's part of the whole deal. That's one of the main theories of their case, of course. That this investigation was done poorly. You just wish they could do it a little faster. Goodness gracious. But I'm curious what their objection is here. So the question was, you have to test the body of knowledge of the officer in an officer-involved shooting. But I mean, they did probe Curtis Reeves' knowledge of self-defense law and stuff like that. Because they tried to kind of get him on that. I'm not sure where that's going. Any idea? Like any idea what the objection is here?
I think they're just tired of having this guy testify about how much the investigation sucked.
Yeah. I mean, it is kind of getting
2
old.
hours of it is
Yeah. When you want it to take this long, is it's all good for the developing the narrative? I mean, the defense wants this guy to talk forever about how bad everything was. That's, again, good or bad, that's the entire theory of their case. I don't know if shoddy investigation is as necessary to their argument as they're making it, but they're the guys who do this all the time. So gosh, I think I'm just getting done with this case in general. I kind of want to move on to something else and not be awake at 7:30 a.m. every day. I think that's where I am. I don't know about anyone else. I can't speak for anybody else, but holy God,
I get up at 4:30 to write my summary of the previous day's proceedings.
Ugh.
And I just barely get it done before the court goes into session.
That's a lot. That's too much, maybe. You should consider that is too much, Andrew. You're working too hard here.
I am indeed envious of all you guys who just you live stream on video and then you don't have to write anything.
It's a much more effective. It's like voice to text. That's all it is.
I guess I have a more boomer audience. My people, they want to read stuff.
You got to break them of that. You got to tell them what's actually true about life. And what's true about life is that they don't want to read. They want to watch. They want to experience. They want to get in there. Oh, man. I don't know, man. This courtroom's a disaster. This judge is a disaster. The prosecution team's a disaster. The defense has been very good after opening arguments. That opening argument started off really, really bad.
Yep.
But it got fine once they started, getting into cross exam. But all of this stuff, like, look how long this objection is. What are we doing here? You need to get off Rumble. It's a known alt-right hangout and full of Nazis. Oh, good. That's where I need to be then. Anytime something is called an evil haven of some sort, that's where I want to be. I want to make sure, because that's the dangerous place. That's the place where change is happening, and people are doing stuff that's useful. So I want to just point that out. I'm guessing you're being tongue in cheek and joking, but it's yeah, that's what we need. And I've gotten, see, this is the problem. I signed up for Rumble. I already had the Odyssey, but I signed up for Rumble, and now I've been approached by another platform who's like, hey, by the way, sign up for us and stream over there too. And I'm like, oh God, it's another window. It's another thing. It's another thing to set up every time. It's all the shit I complained about. Now I have another one. JC Chappie says time must work different in a courtroom. This isn't quick. And Salty One says, look, Mom, it's me, the evil Nazi on Rumble. Dang. By the way, someone made this Rumble rant. Whatchamacallit? It's called a bookmarklet or something, where it keeps track of the Rumble rants in a separate little pane on the window, which is amazing. And I mistakenly said it was made by Jim Satala. I don't know why my brain went to Jim Satala for that, because he is not the person who made it. So Jim, I love you, buddy, but you got credit that you didn't deserve and didn't earn. And it's your fault, not mine, that I said the wrong thing. So I wanted to make sure and give credit where credit was due. Just a moment. It was Stephen Crater. Stephen Crater is the guy who made it. And I said the wrong name. So I apologize for that. But it's a really cool little helpful thing that he developed to help keep track of those Rumble rants over on Rumble, until they build in some sort of system of their own. Oh my goodness. If I stay over on Rumble, I'll be radicalized like Viva Fry, the evil racist Viva Fry. Okay, I'll take it. Stephen Crater is later with Crater. Yes, that's it. Is Regina Chu 69 years old yet? I think she passed that, didn't she? Isn't she much older? I don't even know. What I do know is that Regina Chu has the blood of Kim Potter on her hands, whatever that means. I mean, it's not literal blood, but yeah, the fact that she's responsible for her going to prison is very true. And she had a duty to prevent that from happening. As a judge, she should have made a ruling as a matter of law, and not worried so much about the politics of it.
Yep, that was her job.
And she failed. Objectively failed. Okay, let me BN says, okay, defense wants to use a mannequin to show the trajectory of light towards the eyes of the defendant. Oh, I read that one. Brent Mack says, it's the outlaw Josie Wales defense judge. He had the edge with the sun at his back. Now spit. Drew Addison says, "Screw the grease monkey, mechanical engineers." This message brought to you by the electrical engineering gang.
To the crime scene investigator. It's a self-defense case. And you know that the person that's accused is a retired police officer. Would you want to know the body of knowledge that that police officer, former police officer, had in threat assessment and realizing the cues of danger? Would you want to know that if you were the crime scene investigator and the lead detective?
You would. Primary reason is just so you understand from a person's training and background, things like their knowledge and ability to handle a gun, how would they handle it? So if you've been through
Pretty darn well.
law enforcement training, then there's certain ways that you shoot a gun that you're trained to do that somebody who's never had that training would not necessarily inherently do. But also you want to look at what it is that he's looking at and what he's aware of in terms of cues and indicators to him that may have led to the decision to fire. So as a crime scene investigator, I'm primarily looking at trying to identify those things and then figure out, what is it that he saw? And that's going to be within the framework of his knowledge and training, not just that he saw something, because what does it mean to him? And so then you know better how to document that. So what do I do to document that so that it shows what he's perceiving and whether or not what he's describing to me matches up with what he's saying. So again, it's a matter of let's figure out what he made his decision on, and then we need to document all those factors to the best of our ability to be able to show that, if there's a particular decision that he made, was it made on,
Imagine if Chad Olson had been clicking a pen. Curtis Reeves would have used a flamethrower on him.
Oh, another sidebar. Oh, good. Another 30-minute discussion with the judge. We really don't like that he keeps saying everything was bad.
Yeah, they really don't like that.
It's amazing. Lancelot says, "So many boring cops. I want Chad Cop back, saving hostages and driving through a blizzard after heart surgery." Me too. Me too. That guy was great. Iams. Call me I, James.
So let's continue with this.
Oh my God, they're not going to break for lunch yet?
Nope.
Factors that we talked about. I think we left off with physical layout. Video surveillance. We talked a little bit about that, did we not?
We did.
Okay. And so how important is it to a crime scene detective or crime scene investigator to realize, first of all, whether there's video or not?
Video is,
I'd object only because I thought this was asked and answered. We went through video already, but I don't know more. But
All right, to the extent that it's been asked and answered, sustained.
video.
Whatever
is
was asked and
important
answered.
to
Nobody remembers.
Yeah. Okay.
documented to be aware of as a crime scene detective, because one, it can potentially show you very important evidence. One of the biggest things we get out of video in terms of reconstructing, particularly in a shooting, is timeline. Because when witnesses are telling you about something, you don't really know exactly how fast it happened. You just know what their approximation. So if you ask somebody, well, you heard this and then a shot is fired, how long in between those things, they're giving you an estimate. But with video, you can often go to it and know exactly between an event to another event Sometimes we get video when you have multiple shots fired. We can know exactly the cadence and the speed with which the shots are fired because of what's recorded on the video or audio. So you need to look at it. You need to know and be aware of it, because until you know it, until you've seen it, until you've had a chance to really analyze and look at it, you have no idea what it's going to tell you.
And so if you go into a theater and you see that there's a surveillance system, you just tell yourself as a crime scene investigator, I'll see it tomorrow or the next day.
No, it could, because like any other type of evidence, you need to secure it.
Immediately?
You need to secure it immediately, because you need to make sure as fast as you can that just like any other evidence, that nothing's going to happen to it. And then you also need to see it as soon as you can, because that can affect how you process a crime scene, what evidence you're collecting, because you may see things on the video and realize, oh, wait, that's involved, or I need to look at this item, I need to look at this location, I need to do things because you just saw it on the video. And so, it was not uncommon for me, even in smaller things. I'd go to a burglary scene or go to a robbery scene.
Made the
and see that they
burglary
have a
scene.
surveillance video, and I'd ask them, can I see that video? Because if you had, say, an armed robbery, it was an excellent tool for me as a crime scene investigator to watch it happen on the video, so I could say, okay, well, the person went over here and touched this, and they went over here and touched that, and now I know areas to process, and I know what kind of things to do.
And so tell me, what if the company says you're not getting it?
Well, the first thing is secure it, because you don't want them to be able to do anything with it. And then go get a search warrant. And then once you have a search warrant, they can tell you you're not getting it all day long, but they don't have a choice. That's a signed by a judge. It's, an order for you to go get the.
Well, we learned in the Kim Potter case that
So
warrants issued by a judge are optional.
that would be
Right.
the
They don't
step
matter
you
at
would
all.
take. You would not let that just go and then rely on somebody else to provide it, because you don't know what they're going to give you and what's been contaminated in the process.
So law enforcement controls the process of securing it?
Absolutely. Once you're there at the scene, then you take control of all of it.
Would you allow an entity just to kind of help you out to preserve it?
You wouldn't, I mean, obviously there's going to be probably some level of assistance, even if it's just, can you show me where the DVRs are? Have them take you to the room, those kind of things. But you're not going to let them.
It would have been funny if Curtis Reeves had shouted popcorn, popcorn, popcorn before he fired that shot.
Not just because of fear that they may do something to it and contaminate it, or that they may not cooperate with you, but more than that is that you don't know what level of training they have in handling that type of evidence as a forensic matter, and they may do something inadvertently to contaminate that evidence that you now have to deal with. And so, that could be problematic. You need to secure that as fast as you can.
Do these departments, for example, the Pasco Sheriff's Office, do they have cybercrime units that are competent individuals in order to properly preserve video evidence?
Most reasonable size.
I'd like to see how many members of the Pasco Sheriff's Office we can throw under the bus with this testimony.
Usually in the detective unit or technical support unit that's able to do that. And if the agency itself doesn't, Florida Department of Law Enforcement does, and it's just a phone call away.
What about seating? Not only the seat that the accused person was sitting in, but seating in general. Is that an important factor to consider?
Yes. Whenever you have a case like this where, a person is seated and they're dealing with a person who's on another seat in front of them, you have introduced, as I was describing before, constraints. You have stuff in the way between the two people. And also, obviously, things change. Perspective changes. All sorts of things change based on, if I'm sitting down as opposed to standing up.
So what do you do with those seats? Do you measure them?
Yes.
Do you examine them to see what type of seat it is, whether it's a very deep cushion or firm?
Yes.
Do you measure the distance between the seats?
Yes.
Do you measure the height of the seat?
Yes.
Do you measure the height of the back of the seat?
Yes.
Do you measure diagonally as well, if need be?
If need be, yes.
And while you're doing those measurements, what do you do in order to memorialize what you're doing?
Well, you can do several different ways to keep track of that. You could draw sketches or diagrams and diagram and show all the different measurements that you collected. You can photograph them. You can put, a measuring device down and then take pictures of each measurement to be able to show it. So there's several different ways you can do that.
And the reason that you're preserving all those measurements is for what reason?
Well, primarily because from a standpoint of reconstructing, you need to have the measurements of the area so that you know what kind of distances you're talking about. But also, in the initial portions of it, you're just
the jury right now is
documenting everything
pissed.
to have it documented so that you know
They've got a subway platter waiting.
locations, distances, and all those sorts of things.
Mayo's
because
getting
the question
warm.
may come up later on during an investigation, and you don't want to have to go back and try to get those measurements.
Mr. Escobar,
Yes, sir.
we need to take a lunch break.
Thank you.
So, ladies and gentlemen, we're going to take an hour for lunch. If you would be back at 2:00 at the jury pool room. Please remember my instructions during the recess. Don't do any independent research. Don't talk about the facts of the case amongst yourselves or with anyone else. Don't watch any news. Thank you. Enjoy your lunch.
I'll ask for the recess in 1 hour.
Yeah, it's 1:00 there almost. These jurors have been there since 8:30. It's almost 1. And now they're finally getting to go to lunch. And their break was a long time ago as well. So this has been extensive. Oh boy. Well, I'm thoroughly entertained. How about you? How you doing over there? You're muted. You're muted though.
Of course I am. I'm sure the defense only needed a few more minutes to finish up with this witness, and we could have wrapped up.
No.
Like hundreds of minutes.
Yeah. It's gonna be forever. I don't know what they're look.
They haven't even said silhouette yet.
Yeah, they haven't said silhouette. They haven't wheeled the screen into place. Look at the binders. Just oh wait, I don't have here. Let me pull it up. Look at the binders.
And they're all labeled evidence of innocence, volume 1 through 60.
This binder is called 4 Inches of Innocence. Oh, he doesn't seem to have any trouble walking now. A cane's obviously for show. What if he walked out and just left? Never came back. I'm done with this shit.
Went to see a movie.
I never got to see Lone Survivor.
I went to go see that new Mark Wahlberg movie. What's that one? Something Island, or it's based off a video game?
Uncharted.
Uncharted, right.
Yeah. Yeah. Oh, I forgot that's Mark Wahlberg in that. Oh gosh. I never played those games. So I have no idea. Oh. This is
I
brutal,
played
though.
Asteroid.
I did too.
Missile Command. Those were my video games.
Missile Command with the ball in the arcade. That's how you had to play it.
Oh, I played on the Atari.
Oh, so you had the little dial that went back and forth on
My
your thing, or
first
did you have
ever
a
video
joystick?
game. My aunt opened up an account at a bank and they gave her Pong. That was the only
Yes.
game on this machine. You couldn't put cartridges in it. It was just a box that played Pong.
Right.
And it had the little dials. You hooked it up to your black and white TV. But after that, we upgraded to the Atari, where you had the joystick and the one red button.
Yep, I had one of those. It was great. I had the Atari XE, which ostensibly had the ability to program games. My dad's like, you can actually program your own video games on this. Yeah, I'm like, Dad, I'm 7. It's not programming shit, especially back then. Like now, my kids actually do make games on Roblox and Minecraft and stuff like
Yep.
that. They build worlds, but the environments are developed for you to do that. They did all the lifting on the back end. Back then it was like, what, I'm going to sit down and write lines of code? Sure, Dad. What do I look like? A journalist who's out of work? No, thank you.
My first computer game wasn't even a video game. It was we had our school had computers. The computers were actually teletype machines that connected to a mainframe at the public library, and there was no screen. You could only type. And they had a football game where you would type like K for kick, and then it would run an algorithm for 20 minutes and return you how many yards the ball went. Just a number. Nothing to see except, beep, 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 printing on the paper.
Oh, that's amazing.
You had to put a telephone handset, the old big ones.
Yeah.
In the box that had like 2 suction cups for the handset.
Yes, the thing that yeah. Where it actually like made the modem sounds into those things.
Into
like,
the phone. Right?
Oh God. It's amazing how far we've come, right? From there to broadcasting live video anywhere in the world immediately while watching another live video broadcast
from anywhere
from anywhere else. Yeah. It's nuts. Lancelot 652 says, I fell asleep for most of this guy's CV and we're just now getting to the topic. Wow. And only barely getting to the topic. Not to the matter that they debated was at the movie theater. He's still talking in generalities about investigations. He's not talking about this particular case in much specifics, except for the vague reference that maybe they should have asked this guy what he knew about justifiable shootings. Although to be fair to the prosecution objecting to that one, I mean, they did kind of ask him what he knew. And the second part is it doesn't matter what he knows, right? Like what matters is there evidence of his guilt and is there exculpatory evidence and did they collect it? Whether he knows that evidence is actually not particularly important.
Well, it kind of depends. I mean, it's there's a subjective component to self-defense, right? Subjective reasonableness. So what he knows is definitely going to play a role in that. And you wouldn't want him to claim later that he knew things he didn't know at the time, right?
Sure.
But this guy's, he's going to spend at least an hour talking about what he did at the movie theater with his measurements and tripods and cameras and lighting, and then another hour sharing the photos that resulted from those efforts.
Yeah, I know it's going to be horrible. It may I legitimately just kind of like my brain is going, you just end the stream. You just end the stream. It's okay. It's okay. I'm not gonna chat. You're stuck here with me. But God, it's tempting. It's like, just go lay down.
I'm not trapped in here with the court. You're trapped in here with me.
You've seen that movie then?
I've seen that scene.
Oh God, it was good.
I don't even know what movie it's from.
It's from shit. What is that? Watchmen. Yeah. Character Rorschach. And he like pours hot grease or boiling water right on one guy's face. That was beautiful. Oh God.
Turn off your phone.
Shit. Oh, so I was I'm watching Reacher on Amazon, which is a pretty good show. And I was stunned yesterday.
The new one with the new guy.
Yeah, the new one with that guy's the guy actually plays Thad Castle in a show called Blue Mountain State, which was hilarious. But yeah, he's Reacher. And I was shocked and blown away by what happened. They did law correctly for just a little bit. And this happens from time to time. It happened in Breaking Bad when the guy when Walter White's in that RV on the junkyard lot and the guy tries to articulate exigent circumstances that it's a movable exception because it's a wheeled vehicle. And the guy's like, actually, no, that thing doesn't move. Therefore, it makes it a domicile and all this stuff. And they have this nice little Fourth Amendment back and forth. They had a similar one, adequately explaining exigent circumstances in episode 3 of Reacher. So if you guys are interested in that, I was thinking about doing the stupid legal thing and grabbing the video clip and doing a video to talk about it, but I haven't had time yet. Plus, it doesn't really matter when I do it, but so I'll get around to it eventually, maybe. But as a preview to that, you can go watch episode 3 of Reacher and check out that scene where they talk about exigent circumstances and entering a property without a warrant. And it was actually well written. Like they consulted a lawyer who knew what he was talking about. So it was a good job.
So Reacher's worth taking a look.
So far, I'm 3 episodes in. I really enjoy it. I think it's good. You know, it's a pulp detective-y whodunit, not really whodunit, but kind of a whodunit, but a conspiracy mystery. And it's fun. I like the character and the way, and I like the actor who plays him. And I would recommend it so far, but I'm only 3 episodes in.
Yeah, I got it.
Let's see. Well, I've got there are many chats that I can read. JC Chappie says Rumble really missed it by not naming their super chats Rumble Grumbles. Yeah, that would be good. Let's see, I need to go back to where we were in these.
By the way, folks, I'm also on Rumble and Odyssey. There's not much there. I just this morning, the reason I was using up bandwidth, I just uploaded a couple weeks of my last couple weeks of content up there. But if you want to check that out, I'm not sure how you find me there. I guess you just search for Law Self-Defense in their search window.
How did you upload weeks of content? Like, did you do them individually?
All my coverage of the Reeves trial.
Yeah, so you had to sit there and make the individual uploads for each
Well,
one?
I had them already because I uploaded them to my membership and to YouTube. So it's just a matter of uploading the files.
Yeah, but then putting the description in.
I've been doing that while we were listening to this guy.
That's the stuff I hate right there. Is putting everything into everything. Oh God, it drives me nuts.
Yeah, there ought to be like you can do with StreamYard, you can stream to multiple platforms at the same time. There ought to be some way I can upload a video and it goes to all the different platforms. I don't have to do it 5 times.
Yeah. Odyssey,
it's all the same steps. It's the video, it's the featured image, it's a title, it's a description.
Odyssey will mirror your YouTube content automatically.
Are they part of YouTube or
no?
No.
You go into your, it's in your,
I guess I didn't need to upload all that stuff then, huh?
Yeah. If you go into Odyssey, you can, into your creator page or whatever, you can set it up to grab all your YouTube content, and then anytime you post something to YouTube, it'll pop up on Odyssey within 20-30 minutes, something like that. And it does that. It grabs all the stuff off of it, but you have to authorize it to go in and get all the info. They must use some YouTube API to do that. But that's a really handy thing that I like about Odyssey, especially if you're posting like shorter videos a lot. It's really handy. For live stream, you can just set up multi-streaming, so it's not a big deal. But yeah, for the short videos, it's really nice. Let's see. Adam says, I'm currently on my 7th day in the hospital. I have COVID for the 2nd time, valley fever, and MRSA. Thank you both for the entertainment. Well, I don't know how much thanking you have to do for us today. This is like the 4th day in a row of just brutally slow testimony to start. I mean, I'm guessing it'll get into it. I'm waiting for cross-exam because cross-exam is where prosecution's been doing terrible, and that's funny to me. But that being said, this has been torturous. I mean, opening up with that video, oh, that was awful. To the chat who may be wondering, I thought Drexel was going to come out tonight. Drexel will be out tomorrow. So there will be no Drexel stream tonight. I may not do a YouTube stream tonight. I may just do some Twitch and chill type stuff because, man, I could kind of use a few. I can't wait for this trial to be over. In all honesty, I really can't wait. But yeah. So next, Elizabeth White, welcome to Paralegal Status. Beast on the Run. Wait, I read that. I read this one too. I must have missed. I didn't recognize that COVID for the second time chat. I must have missed it earlier. Mike Misbach says the judge herself went and sat in the seat. Why not let the jury see the picture from the seat? Yeah, I'm surprised that the defense didn't bring that up. The judge went to the theater and sat down to give herself, a better perspective of the case. It's like, Judge, you did this. We can't, it's really impractical to bring all of the jury out to this theater and shut it down for a day. But the next best thing is we've got these photos. Let's give that experience to them. D. Payton 42 says the defense should just say we will keep calling witnesses until the jury says not guilty. That would shorten this whole thing up. It's a good plan. Nayland says, is it common for judge to have to look up law during court? Yeah. Well, typically, I shouldn't say yeah. Attorneys will usually be prepared for presenting arguments in case law. I mean, that's part of your prep is you try and anticipate what case law you may need to cite to. You have some citations prepared, but there are times that come up because you maybe didn't anticipate a particular objection or whatever, or you didn't know that you would have to make an objection. And so this thing comes up where you've now got a matter of law that you need to have some guidance on that wasn't there. Judges can, depending on the situation, a lot of times if it's not emergency or if it's not critical, they can just table the issue and have people submit written briefs, that evening, the next day, whatever the timeline allows. But yeah, judges sometimes have to go and look up law in the court because they can't know all of the law. It's too much for any person. They can have general sort of ideas and understandings. And that, to be quite frank with you, a lot of lawyers, they do have with their specific case that they're working on, they'll drill down and figure stuff out. But there are times where they're going to make objections and stuff based on kind of a feel, without knowing the exact specific reason or the legal basis. Maybe they read something that they only, remember a part of, but they know they got to get the issue out there. So they'll object on the grounds that they're pretty sure it's wrong and kind of work their way backwards.
Plus they get lied to a lot. I mean, I've seen it many times where one party will claim that case law means X, but if you go read the actual case, it doesn't mean that, or it's ambiguous, or it's dicta, or it's just nonsense.
Right. And we saw that just the other day with Law and Crime's letter to me, where the case that they cited saying that they had no one had access to media pool footage outside of a specific grant by statute from the government. And they cited a case that actually said that the Department of Defense could restrict media coverage during war for national security concerns to a particular media pool, which is a complete opposite proposition than what they were suggesting. So yeah, lawyers sometimes lie about what the law says, and sometimes they lie to judges. And if we're being charitable, they're not lying, they're mistaken. They have a different interpretation, but sometimes they're just lying. RPG or 90 says it's great to see the prosecution has consistently been bad with experts for many years. I was pretty much sleeping through the start and only really start paying attention to them when they tried for the gotcha. Power Keg Greg says you can link to Rumble too. I saw. Wait, are you saying Oh yeah, Rumble has an auto syndication thing, but I don't know. I don't know if it imports old videos or just brings in new ones. Because oh yeah, that's an unanswered question I have. I'll have to send that back to him and ask how that works.
Well,
'Cause
right
I
now
have
my
a-
Odyssey is linking several hundred videos from my YouTube channel. So
It could
I guess it works.
take a couple days for them to do all of it. But once it catches up, they're all there, and then each new one comes up right away. But yeah, I have so many videos, and they're so long. Well over 1,000 live streams that are all 3, 4, 5, 6 hours. So it takes a while to do that on mine. The Cancer Man says Nick would spoon feed Ethan Ralph cream corn. Would you spoon feed Ethan Ralph cream corn if your life depends on it? Only if it's on video. National Populist says it does make a difference if it goes in deeper. I think that was on the
knife into the skull.
Yeah, the knife into the styrofoam.
But it's probably a general truism.
It's true. Yeah, I think so. Deep Payton 42 says the defense should just say we will keep calling. Oh wait, I read that. Kyle Cowden says trying to reduce my daily screen time wrecked thanks to you. In other news, my daughter just received her first royalty check from streaming her music. Search Sable Breeze on any platform. Music to get you past CVs. There you go.
Sounds like a polite term for lady farts.
Very cool, Kyle. Thank you so much for sharing, and congratulations to her. I hope there are many more and even significantly larger royalty checks in her future. Jonathan Duger says, I'm not saying anything bad should happen to these people, but if gators came roaring in and mauled them all, I'd be excited. Britt Cormeyer, unless you give the jury corrective glasses that replicates the eyesight of the defendant, no one can ever reproduce what they perceived. Even then, older eyes are not the same day to day. Yeah, well, I mean, they were just being ridiculous. The idea is that here's what they don't want, okay? They don't want a demonstrative of someone throwing a styrofoam ball to demonstrate how someone was bludgeoned with a bowling ball, right? They don't want some obviously false representation of what happened or some fact or piece of evidence. They don't want some obviously prejudicial thing. Like if the prosecution's just sitting there throwing around this bowling ball and juggling it around like it doesn't weigh 15 pounds because it actually weighs nothing. I mean, it's not really a fair representation of what was used to dome some guy and killed him. So they, or I don't know why the prosecution would be doing that. Maybe the defense team. So that's the stuff they're trying to avoid. The obvious fake thing. What this idea that it's just there to make you replicate the exact facts and circumstances is nonsense. And speaking of exact facts and circumstances being nonsense, we have another guest to add to the stream. What up, Kurt?
I just want to say how deeply disappointed I am that Law and Crime's efforts to strike you from the YouTube have not been successful as of yet. And I continue to cheer them on in their ever-present efforts.
Well, welcome to the show. Thank you. That was really nice of you to be here.
Man, you're the greatest, Nick. You know that.
How's it going, man? How you doing?
I'm in good spirits today. I'm in good spirits.
It looks like it.
Yeah, I recently moved, started a new workout regime because my old apartment's gym really sucked. And so I've been excited about that, feeling good, eating healthier. It's quieter. I'm happier. I'm paying less for rent than I was, living in the middle of downtown Austin. So
yeah.
There's all that. So
yeah,
things
I don't
are
hear it. You've been on here for 2 minutes and I haven't heard police sirens yet.
Haven't heard police sirens or random music from across the street. I know it's different.
Oh man. Oh, I've got to send you the case that Law and Crime sent to me, by the way. Did you hear what I was just describing?
I heard,
a
yes,
minute
I
ago?
heard the description. I haven't read the thing though, because I was looking forward to covering it and mocking the shit out of that.
Yeah, I'll send you the letter that they sent and the and then you'd have the citations right.
I was
in there.
enjoying mocking the shit out of Josh Duggar last night because I decided to review the U.S. Attorney's response to "I want a new trial" because of all the unfair things that happened to me in my CP possession case. And it's just
Oh.
like I'm reviewing the U.S. attorneys, and I'm like, "Ha, Josh Duggar, just get wrecked."
Yeah, yeah,
You've got nothing. I'm so sad I wasn't able to call this other to implicate this other guy as doing the thing, even though he wasn't in the state at the time, and there are multiple eyewitnesses that say he wasn't. He was at an Apple store in a different state. But we have the receipt of his purchases, and the Apple store employees say, "Yeah, he was there." So it kind of makes it hard for him to also be at your place at the exact same time.
I don't know if you know the extent of need that he
Yeah.
had to access CP from Josh Duggar's computer, that he was able to be in two places at once.
Yeah, apparently. Yeah. So Josh Duggar, his motion for a new trial was hilarious, and it went absolutely nowhere. And this is one of the parts about law. This is one of the things about law that I don't like, because this is the frustrating part, because I just put myself in the place of the U.S. attorney. It's like, do I really have to write this 20-page memo about why you're just wrong? It's like, can we just skip all this crap? You know you don't have an argument. I know you don't have an argument. Do we really have to do this? Apparently, we really have to do this. And that's the part that I find frustrating, when it's complete bullshit. It's like, why are we wasting time?
Well, I would agree with you if it wasn't for the fact that that's a dirty Fed, and any agent of the state acting as, I think all work for prosecutors should be tripled, quadrupled, quintupled, and their pay should be reduced by 70%.
Yeah.
That's what they get for being a bootlick.
Sometimes people do illegal things, and sometimes they're bad people, Nick.
That's true. No, and I appreciate when they put those bad people away. But I'm just saying, as a matter of principle, they need to. The state wages need less, and they need more work.
Yeah.
Just think, if they paid them 70% less, how many more of them they could hire to do all the work, and then the workload would be reduced.
I mean, they're not paying prosecutors a lot of money.
No, I know. Yeah, they'd be making like 30 grand a year. It'd be perfect.
Yeah, I mean, prosecutors don't make a lot of money, especially for the amount of work that they do, and defense attorneys, especially the public defenders, don't make a lot of money for the work that they do.
Well, I'll tell you, in this case, in the trial of Curtis Reeves, whatever the prosecutors are making, it deserves to be less. They're not putting up a good show.
Yeah.
Yeah. That's my opinion. I don't know. Andrew may disagree.
Okay.
But I think they're putting up a pretty terrible show. They're getting the yesterday they had this a medical expert on, right? And he's talking about stippling, because the guy who's dead, he had stippling on his forearm right here, right?
Mm-hmm.
And so what the stippling showed, according to the medical expert, was that, or I guess I shouldn't say it was on his forearm. The bullet hit like a grazing wound, like right here. And so there's stippling like here and to here, but not on his fingers at all. And so he said that leads him to believe, with a degree of medical certainty, that his fingers would have been flexed into a fist, which is consistent with him punching, because they're stippling up to the knuckle. So if they weren't in a fist, there would have been stippling on the fingers, and there's none.
Possible. Yeah, that makes sense.
So the prosecutor was trying to get him to admit that if the fingers were in a neutral position, but if he was slightly turned or something, that the same thing would happen. He's like, no, it wouldn't look the same. There would be stippling there. And he's like, but wouldn't you agree this? He's like, no. And so then he tries to go back to the transcript from the prior hearing where he asked a question, and he wanted, say, first of all, he gets out the transcript and he says, "You said this, didn't you?" And he's like, "I don't know. Can I read the transcript?" No, you can't. So he's like, "I'm just wondering why you won't let me refresh my memory with the transcript."
From a
And then
hearing
it
from
gets-
5 years ago.
Yeah, and it gets into this weird like back and forth that the prosecutor had no business being in, but it really just looked right at that moment like there's something in that transcript that he does not want to come out. And so then he, the defense eventually objects and is like, why doesn't he just show him the transcript to refresh his recollection like we've done with all the other witnesses in this case? And so then the prosecutor does, and but he doesn't let him turn the page to see what was on the next page. And so then he's like, you read the transcript? And he's like, yeah, but I didn't get to read all of it. It kind of looks like I was confused about your question. Objection, Your Honor. He's not answering my question. Not responsive. It's like, why are you doing this? You look so terrible right now. It was great. That's the stuff that's the funny stuff in this case. The problem is it's like an island in the ocean, and the ocean is the Pacific. So it's
Guam?
Yes, it's Guam, but there are no islands between the states and Guam. Like there's no like pit stop at Hawaii. It's just Seattle to Guam.
But it's like the prosecution's getting high on their own supply. I mean, they come up with this theory of the case and they convince themselves it's true, and they don't take a critical look at it. They don't look at it from the other side. So suddenly when they're on cross and the other side says, well, no, there's another rational explanation for this other than the guilt of this defendant, they're shocked. They don't know what to say.
Yeah, it's wild.
That can be a problem, as everyone here will well know. It's very helpful to put your mind in the opponent's shoes, because you want to be able to try to at least think of some of the things they're going to think of. And in my experience, at least, I'm lucky to hit, maybe half on a good day, but at least I'm thinking about the stuff and I won't be completely blindsided.
What was the expert that tore him up the day before? Do you remember, Andrew? Because that was not they've had real trouble. Oh, no.
It happened with the wife.
Yeah, it happened with the wife. Similar thing. They tried to trip her up on something and they ended up just looking like a bully. And that was a dumb thing to do. But the other thing I'm remembering, it was the video that came out from the video expert that just sure looks like you see a phone fly from the guy's hand, hit Curtis Reeves, and then fall to the ground. And lo and behold, there's been plenty of evidence and testimony that Chad Olson's cell phone was recovered from between Curtis Reeves' feet. So that was a fact in dispute, because he had said he got struck by something and it kind of dazed him. But no one saw him get hit by anything. But when they zoomed in on the footage on the cameras, you can pretty clearly see some illuminated object, or infrared reflective object, if not illuminated, traverses from where Chad Olson is to strike Curtis Reeves and then fall down. And it's consistent with the cell phone that's at his feet.
And the state's made zero effort to explain away what that is. And it's consistent with the defense. It's consistent with an initial physical assault by Chad Olson on Curtis Reeves well before the popcorn incident, 9-10 seconds before the popcorn incident. That set everything off. And did they even cross-examine Koenig?
No, I don't think they did.
I don't think they did either. That would have been the opportunity. Couldn't that motion that looks like it could be a strike be something else? Couldn't it be this? Couldn't it be that? Couldn't it be, raise questions, impeach? They didn't do any of that.
Yeah, they've been really struggling with the experts. Oh, and the medical expert that they talked to, that was the other thing. He had testified about all these different places on the body where injury could occur, basically, like on the face, how it's, there's hard bones and so injury can happen there and stuff like that. And so the prosecution stands up to start their cross-examination of him and says, we've got a list of all these things that you talked about, and we're going to talk about them.
And he lists them.
Yeah,
he goes down a
lists
bullet list of them.
And then
so he could have
after-
broken his temple and his eye and his nose and his cheek and his chin and his teeth and his spine and his liver and his spleen. But before I get to that, I want to talk about the stippling. And then he tripped over his dick on the stippling stuff. And he never circled back to impeach all these injury hypotheses. So all he did was repeat the list for the jury without impeaching the list at all.
Nice tactic.
It's good.
so it looks like the state might lose this case, is what we're hearing, or what I'm hearing.
I mean, it's kind of looking more and more like they might every day.
That's depressing. The state is able to fuck it up that much.
Like, here's how ludicrous the case was. Even me, and I'm deferential to the defendant in 90% of situations, because I'm skeptical of the state. I thought the guy was probably guilty.
Yeah.
And as it's gone on, I'm like, I can't be there anymore.
And then yesterday, the defense calls the woman who was at the customer service counter when Reeves came up to complain about chattels and cell phone use, and the manager who was behind the counter when Reeves came up to complain about the cell phone use. And on direct, both of them say, no, he didn't look angry. He looked fine. He was, he wasn't irate. He wasn't mumbling. And then on cross, the state comes forth and says, isn't it true that he did not appear irate? And we're like, yeah, that's what the direct testimony just was. And that's good for the defense. What the state needs is for this raving lunatic to come up to the customer service desk. But the cross-examination testimony, which the prosecutor made sound like it was a win for him, was that Reeves was calm.
Yeah. Yeah, because the narrative of this case is that he was mad over the cell phone, and therefore, went to hassle this guy through the management. And when he couldn't hassle them through the employees of the place because they were just like, lol, get wrecked nerd to him or whatever, he goes back and starts an altercation and then ends up shooting this guy. But and the narrative is that he had to be so enraged about this phone that he couldn't let it go. And then all of the testimony is that all the testimony from these people is that he was very calm when he approached. No yelling, no screaming, no accusing the guy of using the F word or anything. He just literally walked up and said, "Hey, there's a guy using a cell phone here, and the movie's about to start." And the manager saying, we'll maybe look into it or something, and that's it. So it's been weird, man. This cross-examination by the prosecution has not been going well. Whereas consequently, the cross-exam by the defense in almost every instance was rock solid. I mean, very good cross-exam.
Well, like if they're able to screw this up somehow, it's interesting how you can get sidetracked by something where the stippling issue and you didn't quite get the answer that you were thinking, and you wind up on this track and you kind of forget everything else you had to do along the way. That's depressing, but that's the kind of thing that can happen, and you have to be aware of. So I'm partially sympathetic, because it's like I could kind of see myself doing that, on a bad day. So I'll won't mock him too heavily, but it's amazing the state is screwing it up this much.
Yeah, well, the problem is it's not a bad day. It's a bad every day.
Yeah.
But where it brings me to, and this is my bias, I know, coming through, but it brings me to this idea that, did the state ever have a case? Should they have brought it? Did they really think they could win? Why is this case here? Because they seem to not be able to sustain what they're saying. And then I start to get into, questions about the ethics of prosecution and how they're doing it. But
I mean, I think the state could have gone where they wanted to be, because I mean, the defense's arguments are there, but the state's arguments are also there. It's you assume the worst. You assume basically the worst that the evidence will allow you to do. The guy who was ultimately shot and killed is an initial aggressor. He's using fists. He's in a fist position. He's throwing popcorn. There's an earlier assault. there's an escalation pattern and all the rest of it. You can like basically assume all that as the state and still kind of get to where you want to be, because one of the end things that you get to is proportionality of force. And you have to have this idea of deadly force in response to deadly force. So you say, okay, this guy's antagonistic. He's a jerk. He's fighting. He's throwing popcorn. He's throwing a fist, right? But these are at least arguably non-deadly force, right? This is non-deadly force. It's not a knife. It's not a club. It's not a baton. It's not a gun. It's popcorn. It's a fist. It's maybe there's a cell phone or something, whatever. Like you can get all there. And then the counter by the defense is, well, he's an older guy. He's 70 years old. He's a frailer guy. And when you talk about proportionality of the force, it's always proper to look at the perpetrator versus victim. You can look at that in terms of their size, their age, their relative strength levels, and so forth and so on. So, it is in fact different if you have two 250-pound, 30-year-olds versus a 30-year-old versus a 70-year-old because of the medical realities. And you argue the case. But from what I just told you just now, it's not inherently obvious, at least what I just said, which way it should come out in the end.
Right.
It's not like, if that's the fact pattern, it's like, okay, there's an argument here. And which way you ultimately go is going to depend on a whole bunch of things. But so I think the state can get to a probable cause. I think they can get to a position which seems winnable, because if the jury, ultimately what you do on close basically as the prosecutor, of course, and what you do always as a lawyer, basically all the time, is you minimize bad facts and you maximize good facts. Right. So that's what you do. So one of the things you basically do ultimately on the close is basically be like, popcorn, really? Popcorn, people, really? There was some butter on it and some salt. He was assaulted by the salted popcorn, really? And for that, this guy's dead. He's shot and dead. That's what we're going with. That's the reason this is dead. We're going justification because of the salted popcorn. Seriously? That's what we're doing? And you just kind of, you go down that road of this, and you obviously dress it up more formally. You just like, this is, if in a fight, it was an escalation, but this is the guy who brought deadly force into it, and he needs to pay for it. So I think you can get to where you need to be based on all the facts.
I think someone can. I just don't think
can.
I don't
Not
think
them,
these
apparently.
prosecutors can.
Not them apparently, but someone could. It sounds like a plausibly winnable case.
Well, there's a narrative to tell here. I mean, for the prosecution, there's no question about that. There's, a number of elements of self-defense that are at least ambiguous. I don't think they're ambiguous to the point of being disproven beyond a reasonable doubt, but that's a subject call, right?
Yeah.
It's a judgment call to make. So there, you can certainly argue those points. Was the threat of Chad Olson a threat of serious bodily injury? Well, maybe because of the age difference and the strength difference and the nature of the attack, and Chad was standing and Reeves was sitting, but maybe not, right? Maybe people say, hey, I'm 71 years old. I'm still in pretty good shape. I don't feel like a thrown punch is enough to justify the use of a gun. But the state has to disprove one of those elements of self-defense beyond a reasonable doubt to overcome the legal defense. At least that's the theory.
Yeah.
Yeah, and that's the thing that has me actually bothered about this case is like with Kim Potter. I'm sitting here looking at this. I'm like, okay, they haven't done this. They're not doing this. They haven't done that yet. It's entirely possible that the jury goes away for 3 minutes and comes back like guilty. Put him in the chair.
Yeah, well, Kim Potter was so bullshit because the law, and as the judge themselves said, how many times they used the word mistake? Did anyone ever bother counting? How many times they used the word mistake, and they swallowed the one time they said reckless? And it's like, yeah,
she stuttered.
Stuttered.
But she knew it wasn't. She knew it wasn't reckless.
She knows it isn't, exactly.
She meant negligent.
But here at least you have, she used that word too, which is definitely not the same thing. But here at least you have a story that makes sense. Is you could attack subjective. You could attack it as the state on objective and subjective. Now, whether or not you get to proof beyond a reasonable doubt, I guess is in the jury's mind. But you can be like, this guy didn't really feel a subjective fear of death, or there really wasn't an objective fear of death. I mean, you can attack it either way. It's plausible. And then It's just a question of which story does the jury believe at the end of the day. But it's a triable case, at least theoretically. But then you get really bogged down on the stippling because the guy might be in a pinch in a closed position versus an open position. You get bogged down, and then you lose all this stuff because you could have been hurt here, and you just basically made the defense's case for you. So genius work, counselor. How you doing, Nate?
I think the real problem for the prosecution here is for 8 years, they've been selling the narrative that this was a simple malice murder over popcorn. And what the jury's hearing is something a lot more ambiguous than that. And ambiguity is supposed to go in the favor of the defense.
Yeah.
Supposed to. The question, though, is always, will it?
It's true.
Nate,
Yeah.
how you doing, Nate?
I'm okay. I'm just, I'm trying to hide out over here because what's going on Twitter. They're killing
Hide
me
out from the
bad.
soccer.
What's going on Twitter because of soccer? Are you getting some blowback because of soccer? Did you say some things? Are you getting blowback?
It's like let me tell some of the misogynist things I'm saying.
Mm-hmm.
The women got paid more than the men and admitted it. That is misogyny now. Saying that fact is misogyny, and I should be, tarred and feathered for saying that. And oh yeah, the next big one is that the Women's World Cup is not as competitive as the Men's World Cup. What? You're not playing against Ronaldo, and you're not playing against Messi. You're playing against some women they just literally pulled off the street and said, "Hey, you want to play for the national team here in Taiwan?"
Damn,
that's a different
Taiwan on life support.
Yeah, so I just love the way where, and this is for every case, when literally I'm sitting there arguing with idiots who are sitting there telling me the women were paid less. So today I was like, here is Megan Rapinoe. She said they were paid more, right? Don't believe me. Don't believe the judge. Don't believe the court doctor. Don't believe any of that. They sent me an ESPN article. The ESPN article was wrong. Here's Megan Rapinoe. And guess what they had the nerve to say about Megan Rapinoe saying that the women got paid more. Got paid more than the men. They said Megan Rapinoe is wrong.
Did they say she's a misogynist?
No.
It sounds like you're arguing with a drunk ex-wife, Nate.
That's half of Twitter. Half of Twitter's a drunk ex-wife. But you guys go through it too. Now they got the other cop. You guys saw the other trial started? The Breonna Taylor cop?
Yeah, I heard that that started up.
Yeah, so it's like they're live.
What's going on with Breonna Taylor?
Well, he's shot. He's charged with reckless endangerment for shooting into a neighboring property.
Oh yes, I vaguely remember that. I don't know how that flies legally because didn't he shoot him from outside? Then
yeah, they got him for recklessness because
if Kim Potter is guilty for recklessness, I guess he is too.
Oh, but anybody
throw that in there too.
Anybody's there. That's if I hope pray don't make any mistake.
Okay, I retract where I said it. I don't understand. I immediately understand. Okay, yeah, it's recklessness. He's doomed.
But this in Kentucky, what happens is the cops who were. At first, they were trying to get the cops who were at the door when the boyfriend shot at them, and they shot back. But nobody in their mind would charge those two cops, right? They're actually being shot at. So the returning fire, there's nothing there.
Did one of them get hit?
Yeah, one of them actually got hit and they returned fire. So, but they were trying to charge them. But then at a point, they said, "Well, you can't go too crazy with this." It's the cop. His name is Hinkleson. He was outside. He heard the shots, but he didn't have any target recognition. He didn't identify any targets. So he was outside and he heard the shots. And he just shot blindly into the apartment.
Okay,
so they're saying
that might be recklessness.
That might be recklessness. He had no target acquisition. Yeah, everybody knows you got to know what's in front of your target and behind your target. You can't just shoot blindly.
So what are we actually charging them with? Reckless assault?
Reckless assault, and not only the cops, not the cops who were in there, because he was shooting into. He didn't know if the cop he was shooting toward the cops, so he recklessly endangered them, and his bullets went through the drywall into other apartments. So he recklessly endangered all those people in other apartments. So that case I think is not a Kim Potter case. That case is he looking at a blank wall and pulling your trigger through a blank wall.
But if he had hit him, though, he'd be a hero, right? If he had made that magical shot.
He pulled up like in Snatch.
Yeah.
When Bullet Tooth Tony uses a Desert Eagle and drops Boris. He's like, that's what he was thinking of at the time.
I mean, if you're shooting and you don't have an identified target, it's one thing to shoot and miss. But if you're shooting and you don't have an identified target you're shooting at, I think the technical charge is wanton endangerment, but that's just a term they use for recklessness.
Yeah,
Yeah.
wanton's the same thing as
It
reckless.
sure feels like recklessness. I mean,
Yeah.
I'd like to hear his explanation, the defense explanation for
my
why
ears,
it wouldn't be.
my ears are so good that I knew exactly where he was in my bat-like way, and so I didn't need visual in order to target him because
thing
I'm
that
just that good.
The thing that got him all messed up though is that when the SWAT team came, they asked him on body cam, like, "Oh, when you shot, did you see anybody?" He's like, "No, I just shot into the heart when I heard gunshots."
See, what did we say about talking to the police? What did we say
He's
about
the
talking to
police.
the police? What did we say about talking to police? Don't talk to the police.
Terrible. Why would you do that?
He's talking. He didn't think he did anything wrong. But I'm like, I don't know any training on the planet that lets you shoot blindly into an apartment packed with people when you don't know where the targets are at.
No, I don't remember that one at IPSC. No, I don't
Yeah,
remember that one.
That's not the training they train you on.
So on that,
Well, on the upside, at least we'll finally have a case where people can stop screaming at me that I always defend the police.
Look, Kim, what do you mean? I've seen them haunt you for the Ashley Babbitt. Only thing you can say Ashley Babbitt, and that's it. You're a communist like me when it comes to Ashley Babbitt. Welcome to the side.
Oh God, I forgot. Why don't you two move to Canada and get married or whatever? Freaking commies. No, I just love the women's soccer case. First of all, like obviously the settlement is a PR settlement, right?
Yes.
U.S. soccer is sued by women's soccer, but it's in U.S. soccer's interest to not be focused on this and to be focused on women's soccer and men's soccer and promoting it rather than to be opposed. So they make the settlement and it's fine.
What's it worth to make the endless series of Sports Illustrated articles that you suck and are misogynist go away? 20 million? Fine.
Yeah, it was what, 24 million, something like that?
Fine. Money well spent.
It's not going to go away because as Nate and I were discussing the whole issue, and the New York Times points the whole thing out too. This is all contingent on there being a unified collective bargaining agreement between the men and women. The only way for this to work practically and is exactly what USA Soccer themselves is saying is for the men to give up a portion of the money that they are getting from World Cup or other competitions because the money is not equal between the competitions. So the only way, and the men and women teams are different. So the only way for this to work is for the men's and women's team to essentially unify, or at least unify the prize pool. And so the men would have to give up millions of dollars to the women. And it's like, what men are agreeing to this?
The idiots on the
men who already say they support equal pay. Let's see how much
idiots.
they support equal pay now. The way we're going to get to equal pay is, by the way, in case you ever win the World Cup, men, you were going to get $9 million, but we can no longer give you $9 million because we're going to need some of that money to pay the women. So we're going to give you like $3 million. And like, okay.
No,
what are the men going to do? They're not going to play. I mean, they don't control soccer. They're just the players, right? They may be a player union, but they're not actually making the decision of whether the women get these money or not. Their only option is to decide, well, what, they'll strike? They won't play soccer? Where else are they going to make even just the $3 million?
Well, no, but the men, and that's the issue. The men actually make their money from their professional clubs, Major League Soccer, Premier League, that type of those places, and they get, and their contracts are just on par with like basketball contracts and football contracts. When you talk about the men's soccer, so the reason why they are guns for hire for U.S. soccer is because they're like, we really don't care about this. You know, we'll play this just for fun, but our real money is in
So they
our
have
professional
options.
leagues. Yeah, they have options.
It's not like there's only one NFL.
No, but the women's team only has one option. That's U.S. Soccer. So that's why they want to get all their money from U.S. Soccer, because there's no real women's professional league. But the problem is that with this lawsuit, one of the more interesting pieces of it is that, and I was going to mention this tonight, I've just been researching this today. Only thing they did with this settlement is, number one, it's all bullshit. I'm going to say it publicly right now. The settlement is bullshit, and it's not bullshit because it's just wrong. It's wrong, but there's actually no settlement. Essentially, what U.S. Soccer did was put everything on the men's national team, because this settlement is contingent on the men agreeing to a collective bargaining agreement equal to the women's. Now, what that means is the men's national team has to give up millions of dollars in money for them playing Ronaldo and winning. They would get millions of dollars, but they would have to give 50% of that to the women's team, and they would have to agree to that for the women to get this $24 million. So what U.S. Soccer just did was say, hey, us and the women are for equal pay. Now it's the men's team. They got to agree to the agree. If they don't agree, then guess what? It's not on us. It's not on the women. It's on the men. And I'm going to say it. It's the men's own fault because they came out and said, we agree to equal pay. We agree to equal pay. Now they threw it right in their lap. And the men's and the men have already come out and said that they don't agree to this contract.
No joke.
This was offered already. This was offered already. And they already came out and said, we don't agree to this contract and we know what you're doing. You're trying to put it on us. You're trying to make us seem to be the bad guy. And that's all that U.S. Soccer did right now. This settlement is no settlement. The women aren't getting any money unless the men say we're also going to be giving up our millions of dollars to give to these women. And that I don't think is going to happen. So this case is still going to be going on after this.
Well, and how could they? I mean, the idea that if they could, if they do place well in a World Cup and make the amount of, first of all, the amount of effort that would take and fortune and good playing is astronomical. It's off the charts. It's out of the concept of the world's idea that the U.S. men will compete realistically past maybe a quarterfinal round, right?
Yeah.
And so if they were able to pull that off, they would absolutely deserve every single penny that they got because they're beating the literal best in the world, not the best. I mean, let's be honest. They're not beating the best women in the world. They're beating the best players in the world, and they're monumentally. It's a monumentally order of magnitude difference in ability, because of the nature of the sport favors men. It just does. So then having to give that money up to women who are already making more than them, for the same task is ludicrous.
Blows your mind. Listen, I'm all for equal pay and anti-discrimination, but goddamn, what do you expect? I mean, you're already paying them more. Now I got to give up half of what I'm going to get, and on top of it, you're giving them back pay. It's like, what the hell is what's going on? What world do we live in? And
I mean, if the women's soccer players are producing an equivalent product, why don't they just play in the men's league?
Come on, you know that's not.
That's cold. That's
cold, Andrew. Andrew's cold. He got right through the bullshit. Why don't they just play in the men's?
That's the logical. That's the logical result, right? If the Women's World Cup is truly the same level of competition as the Men's World Cup, which is the premise, and the women win the Women's World Cup, and they're the same level of competition by the transitive property, they'd win the Men's World Cup.
I mean, there's
so why
no
not just
rule
win the
that
world?
says a woman can't play in the men's league.
Why not
right?
just win the? Why not just win the Men's World Cup?
That'd
be great.
The only rule is that men can't play in the Women's World Cup, but women can play in the Men's World Cup. That's why it's actually not even called the Men's World Cup. It's just called the World Cup.
Yeah. I mean,
I think
I
think the U.S. women should enter it. I think they should go for it. They should show everybody. They should show everybody just how good they are. They can take it and stick it to everybody and show them the level of ability. I think they'll do fine.
Well, they got to beat the 15-year-old boys first. Let's not forget. The issue with the 15-year-old boys, like getting them 5-2. It wasn't even close.
It was awful. It was awful. They're like, we weren't playing hard. It's like, yeah, play it again. No.
They lost to a whole bunch of high schoolers bad. It wasn't even like it was just like they lost bad.
Has anybody proposed they play in lingerie?
We have that. We have the
yes.
football lingerie league, right?
Yes,
I mean,
actually.
I assume ratings would go up.
Ryan Long has a whole Man on the Street sketch where he asks people if they watch women's soccer, and then he'd watch them if their titties were out.
Oh my god!
To quote him,
wrong.
It's so funny.
That's
it's
wrong.
a beautiful video. Everybody should check that out. It's phenomenal. But yeah, no, it's well, actually, no, I would pay extra to have Megan Rapinoe keep her shirt on, to be honest.
Yeah,
let's be honest on that one. I definitely don't want to see her running around naked. But in general, it's just a ludicrous concept. We get paid more, but it's possible in some weird world that no one believes could possibly exist, that they might get paid more. So therefore they do get paid more. Here we go. What's this?
This is John McEnroe when he said the Serena Williams thing, and they were trying to get him, but he owns them right on the fucking show. Check this shit out.
All right, what's going on? Let's just start with the elephant in the room. That's right. Why was it necessary for you to say that anybody, Serena, couldn't beat the 700th player on the men's circuit?
As you know well enough, Charlie, respect Serena very much so, okay? And I was simply calling her on an NPR, which supposedly you're supposed, this is where you can say it like it is and you're going to get honest feedback. She's the greatest female player that ever lived. Then the lady said to me, I don't remember which one, but she said, why did you say woman? Why don't you just say the greatest, tennis player that ever lived? And so then I felt the need, however, unfortunately, I'm probably to defend myself. I don't know, just say what I really felt. I mean, which is about what I think she would be. I think you're referring to the fact that I said she'd be about 700 in the world.
Yeah.
I've got a solution, Gail, though, because I know that you're friendly with Serena, and I think at least until yesterday,
right now. I'm just waiting. Would you like to apologize?
No. But the offer is is because it seems in tennis, unlike other sports, that they're always asking about how women. They always ask me how I would do for someone. Why isn't this old bag John McEnroe? How would he do against Serena? Why don't you combine, just solve the problem? I'm sure the men would be all for this. The men and women play together, and then we don't have to guess.
But John, you didn't answer Charlie's question.
He's right. He's right. We don't have to guess. Just combine them. And it's like, oh, well, so.
Here's exactly where she's ranked. Oh.
And let's see if why wouldn't the women agree to that? Well, just ask Annika Sorenstam, right? In golf. Annika Sorenstam was like, oh, she's competing with the men. I'm like, she's competing with the men. She's getting like 57 in these tournaments. She's playing in a men's tournament. She qualified for some of them, but she was never a contender to win because the guys have 80 yards off of every tee box from her. It's silly why do we pretend about this stuff? Some sports favor male physiques and some sports favor women's physiques. That's just how that's okay. It's
just no one wants to pay to watch the sports that favor women's physique.
That's true.
That's true.
Well, and because they didn't foster, this is the reason why, which is silly when you really think about it, because I think something like 75% of spending decisions in the average American household come from the woman in the house.
Yes.
So the overwhelming majority of spending comes from women, yet they can't market sports to women. They've for some reason never done this, but the reason they have so much trouble is because there are generations of sports being marketed to men, and they're only just starting to try and market even women's sports to women. It's going to take time to break just the traditional ideas that people have. They're not geared to look for women's sports, and they're trying really hard. But what they want to do is
maybe it can't happen. I mean, maybe it just can't happen. Maybe it's not in women's. I mean, to the extent that modern sports is a replacement for combat, which in some respects it is, right?
Mm-hmm. Yeah.
It's where we can send men to compete with each other physically without having people kill each other. Women have never been as engaged in combat as men have been. And why would we expect that to change moving forward? We're still the same human beings we've been for 10,000 years.
Jake DeVita says, name the sport that favors women's physiques. Stripping. Which is a sport played in almost every town at a professional level, and women dominate it. What are you talking about? I did not know this. But
no, it's I don't want to make it seem like we're just bashing them, but it's a reality. Is a reality, and I hate the fact we live in a world where you can't just speak the truth. Like the first thing that they're asking him to apologize, And he's like, apologize for fucking what? I'm telling you the truth. She wouldn't be able to win, right? Serena says it. Serena went on Letterman and said, yeah, but he's right. I couldn't compete in the men's tournament. That's crazy. That's what she says. It's crazy. So, it's sad because that's where we're at now. Speaking the truth is racism. Speaking the truth is sexism. It's just like, no, that's the reality of the situation. It may hurt your feelings, but that's just the way it is.
And the idea that it would be bashing in general is silly. I'm not going to ever be a power lifter in my entire life. Yeah. I could train every single day and it won't happen. I don't have the genetics.
I believe in you.
I don't. I don't have the genetics for it. I will never be. I could have started at a very young age, but I have a long, tall frame that doesn't pack on muscle in the right way, and that's just it. That doesn't mean that I'm getting bashed when someone says, hey, "Yeah, you're never going to be a power lifter." Yeah, I know. And the power lifter guy, he would never be an Olympic level swimmer. No matter how many laps he took in a pool, he's not as weirdly shaped as Michael Phelps. It's just, that's the way it is. And that's fine. And yeah, so I don't know.
But they all would be great at dressage.
Dressage?
Yes. That's an Olympic sport. That's the one where they get the horses to prance around.
Well, but the horses are the athletes.
Yes, I know, but that was the point of the joke. Thank you for catching on.
I've never even heard of dressage.
So that's like a funny horse dancing.
Yeah,
it's like pole dancing for horses.
Why is that an Olympic sport? That's
curling. Let's not forget about curling.
I like curling because like random people who get together and like didn't they win gold or something, like the team from Minnesota?
Oh, did it?
I don't know if they won gold, but they got like really far or whatever. And it's like, I got the impression it's like, yeah, you guys just started meeting up for drinks and then you're like, hey, let's try this curling thing. And then they ended up being really good at it.
Believe it or not, they have the curling, the U.S. Curling Association or whatever they call it, has a very nice training building about 20 minutes from my house.
Oh, wow.
Just outside of Colorado. Yeah.
We're going to see Andrew up there in the Olympics right now, curling. You're going to have the
curling's a sport that favors women's physiques because they have to sweep. Right?
There's a lot of sweeping.
They're genetically better at sweeping floors than men. I mean, so
you're going to get us killed here. Oh, you know what? I one thing I also love too is now for the swimming, you did the transgendered NCAA person. Now
this destroyed everybody.
Yo, it's so wild. It's so wild. And the person did 2 years as a man, right? 2 years as a guy. 1-0. It was like, you know what? This shit ain't working. I'm now a woman. I ended up as a woman. Now let me see how it works out now.
I'm waiting for him to show up to the meets wearing like a fake great white shark fin on his back.
Her back, you bigot.
Sorry.
Yeah, went from I think ranked 431 to ranked number 1 in the women's.
Matter of fact, he won by such a big margin that they're like, and now the LGBT people are saying, well, you know, everyone has a genetic advantage. Everyone, so it's a genetic lottery. You know, Serena Williams won the genetic lottery. It's like, but she's still a woman. You know, she's still a woman. That's the difference.
Genetic lottery or no genetic lottery, Andy Roddick will destroy her. Or would have. I don't know if he plays anymore.
Do we have?
Speaking of people who didn't win the genetic lottery.
You won the Bud Light lottery.
Yeah, he can slam down a couple of beers.
Came in a free Floby.
Thanks, Terry.
That's a really nice
CBDX.com says, another day, another great stream. Just came to say that we love you and remind everyone that Nose at checkout is 20% off our legal THC products. You guys can check out CBDX.com and see if any of those legal products suit you. They are not an unlawful substance. They sell only legal substances. So thank you guys. Love having you here. Very much appreciated when you show up and hang out in the chat.
So we've had an hour and a half of this guy's testimony already.
Yep.
Oh, this is sorry, Nate. You prepare yourself, buddy. This is about to get boring.
Nate will just sign out. He won't hesitate to dump us. Eject, eject, eject. You're on mute, Nate.
You're muted.
Boomer.
You're muted, you boomer.
Yeah, I did. I got myself. You guys are on the marathon. I'm here to sprint. I sprint and sprint back. I still got some videos of shoot for the channel.
Thank you for returning. Were you all able to abide by my instructions during the recess? All right, good. We'll get started again.
She didn't wait for an answer.
Dr. Knox, you're still
I'm going
on
to turn
the
her
call?
down
Go ahead,
just a little
Mr.
bit.
Escobar.
Dr. Knox, I think we left out where we were talking about some of the things that you do as a crime scene investigator involving cases specifically, also in self-defense cases. What about the distance between the shooter and the deceased? Is that an important factor? And if it is, why is that an important factor?
Compound question.
Well, it's definitely an important factor because obviously the proximity of
Nobody's very rigorous on
Should be
form of
together
questioning or
goes
response in
to
this
things like
trial.
what they would perceive in
No.
terms of level of threat. What kind of
Well, the judge
You should
doesn't
have
understand
heard
what a
the 2
question
hours
is.
of leading questions yesterday.
whether or not a person is within range of being struck or
Nate,
things
did
like
you know that
So,
if you say
would be
agree or
important to take a
disagree
document.
before the
So what do
question,
you
it makes
do
it not
in
leading?
that circumstance to
What?
memorialize,
In this court,
Well, the location itself you would look at so that you could document, for example, here you have seating, which affects distance. Then, of course, you also could have things like
You have whole
physical
rows.
evidence that would point to where people were located,
These are
documenting that and measuring those distances. And
It's obviously
This
a
guy-
threat assessment. The closer you are, the more threat you are.
evidence, whether it be
this guy
video,
is the
whether it be
crime scene
autopsy results,
reconstructor
anything like
hired
that,
by
that
the
might also help you
defense.
to know what kind of distances there might be between people.
what about the
Everything he's saying that should be done, the investigators in this case did not do.
size of the two individuals? How do you memorialize that?
By taking actual measurements. So in the case of a person that's deceased, they get measured. At the time of
Basically, the
autopsy.
investigator showed up, grazed at the
Anybody
concession
given,
stand,
you
and that
can
was it.
go measure them. So it's not uncommon in a shooting case, for example, to take the person that fired the shot and then get some measurements of their body in order to have those measurements to know things like how far out could they have extended their arm and what kind of reach, how high they would be sitting, those kind of things.
Getting back just briefly to the issue of interviews, and in reference to the location of witnesses and the accused and the deceased, how intent are you in trying to make that determination as far as distance is concerned? How important is it to try to be as exact as possible?
No, I object to the relevance of how important it is to this witness.
You know, in crime scene investigations altogether.
All right, with that clarification, sustained, and we need that clarification. Thank you.
So that's one of the things that you are really focused on when you're doing crime scene investigations and reconstruction with respect to a shooting, is because obviously the distance between two people is very significant as far as what they could do to one another, as far as, what the person would see and perceive, those sorts of things.
Your Honor, we would tender him now before we start getting into what work he actually did in this case as an expert witness in the field of crime scene investigations and reconstruction.
I would object to the format of the question.
Approach.
Oh God. So Nate, this is how this trial has gone. The judge doesn't allow speaking objections, so it's always approach, and the amount of sidebar time that has been spent in this case is astronomical. They get up there and will talk for like 5 to 10 minutes straight through over simple objections. And we're like, what is happening here? It's horrid.
That's usually a judge that's been overturned because of something like that before. Because I remember I had a judge who it was like that, where it was like every single one. It's tedious, but it's because she was overturned. So she's like, because the jury heard something in the objection that they weren't supposed to hear.
As to the crime scene reconstruction and investigation.
That was the fastest one that they've done this whole trial. I'm not even
Sometimes they're
kidding.
20, 30 minutes. It's unbelievable.
They're insane.
For the objections? Wow.
Yes, that's the like. I'm genuinely shocked that we're already back to the trial. Of course, after I give that explanation to you, they do a quick one. You're welcome, chat. I sped that one up for us, but
You may.
Dr. Knox, I'm going to show you what's been marked as defense exhibit number VV and ask you if you recognize that exhibit.
I do.
And what is that an exhibit of?
This is a PowerPoint presentation that I've prepared in this case.
And does it
Looks like a
include
thumb drive.
photos, that you took and photos that you've also analyzed in this particular case?
Yes.
And do they fairly and accurately depict those photos that you considered in your work in this case?
Yes.
Your Honor, we would, at this point, as a demonstrative evidence, ask to publish.
I argued over these pictures for an hour this morning. Nate, the prosecution objected to the scientific validity of pictures because a camera lens is not the same as a human eye.
Not the same as this defendant's specific human eye.
Yes.
That's ridiculous. they must be losing then. So they're
that was an hour argument yesterday, and then it was another hour argument today after the judge had already ruled on it. It was this.
Okay, let's go to the next screen, please. Mr. Knox, if you
Please step down. He's like, let me step down. I want to step down. Get me out of this chair. It's restraining my girth.
Mr. Knox to step down, please.
Dumbass Mr. Knox to step down, please, on the closed caption.
Mr. Knox, I'll give this to you at any point in time you want now, or it's available to you.
Oh gosh, yeah, it's on low res.
At any point in
There we
time
go.
you want to point something out, or it's available to you. What is this particular photo in your PowerPoint? And I believe it looks like it's there's a little number 3 down here. I'm not sure if that stands for it or not. But what is that photo that we're seeing?
So this is an overall photograph just showing the outside of the movie theater, just for reference purposes, that this is where we are at this particular scene.
Okay, next man. And is this showing the Theater 10 lone survivor area of the entrance of the theater?
Yes, so you can see there are multiple theaters with different signs. Number 10.
So the Tampa Bay 10 stream of this
Next one.
has 66 people watching.
And this photo right here, did you take
6-6.
this photo, or was this a photo that was provided to you?
I believe this is one that I.
Long crime is the
so,
next highest, I
let's
think, with
talk a
like
little bit about
30,
you,
3,500,
going
someone
to
said.
3,500, yeah.
Theater. How many? How
Yep,
many
30, almost 3,800.
Twice.
Oh, okay. They're doing good
and,
then.
Let's talk about the first instance that you went to the Cobb Theater. What was your purpose in going to the Cobb Theater during the first instance?
So the first time that I went to the
We have
Cobb Theater was
6,600
to,
here, and I think another 1,500 on
see it,
Rumble.
to get
Ooh,
photographs
that's
and
nice. The
documents.
Rumble
Couple
numbers.
hundred, couple hundred on
As well
Odyssey.
as I had
I can't see as easy.
management show me the different
The
lighting
Odyssey
levels
number.
and stuff, so that I could become familiar with those things.
Okay. And
Rumble's
this
really
is a
blowing up,
photo
too.
that you took there.
Yes.
I'm
I think you
liking
took
it.
Something
Liking
like,
it a lot.
I think it was over 200 photos. I'm not going to go through all of them. Don't worry. Don't worry about it. We're only going to go through a few. What is this particular photo showing?
So you can see this is sort of a wide angle showing most of the.
We have
theater.
600 on. Oh, 644 on Odyssey. Holy shit!
And then this yellow circled area here is just
Nice.
showing the area where the actual shooting took place.
Damn.
Next one, Matt. Okay, what is
Sorry, I
what is this
was
particular
getting,
photo showing?
you know, like 150 on
one, you can see
Odyssey,
that
so
there
I
are
I didn't
images
know
showing
it was doing that
Actual
well.
seats
Thank you.
where Mr. Olson and Mr. Reeves had been sitting.
Now, as part of your investigation in this case, did you get a large volume of documents that our office provided you, police reports, for example,
Yes,
depositions, for example?
yes.
It's like a cross-examination now.
Yeah, they've been leading the whole trial.
Yeah.
You had a
And
large volume
when he
of
gets
information
objected to for leading, he'll just say agree or disagree. Agree or disagree. The defendant was correct in this.
of the cop theater. And did you analyze all of those documents?
Judge,
in an
I said
effort to
agree
be
or
able to
disagree.
do what you were asked to do in this?
He actually said that
He
too.
said
It's
that.
amazing.
I said agree or disagree, Your Honor.
And so this is a
She's
picture
like,
that you did not
oh,
take.
okay, overruled.
Tell me how you used this particular photo and why this particular photo.
I want to hear the sound of a beer can being popped open coming over
Well,
the
this
judge's
is what the
microphone.
area- This is one of the actual ones taken by the forensic investigators with physical evidence still in place. And this particular photo is it's a good view looking down because you can see the 2 rows of seats and see where the things are on the floor and around the area.
Okay, next. So in your measurement process, let's go back to that last one so that he can talk a little bit. In your measurement process, what is it that you wanted to do? Show the ladies and gentlemen of the jury what was important to you to document, to measure for your assistance.
Mostly I want to convince my wife that this is 10 inches.
Well, the main thing is just to have photograph or measurements of the different dimensions of the seat. So things like the seat bottom, where is it when it's pushed down and somebody's sitting in it? How high is it? What's the width between the arms and what's the distance between this seat and the seat in front of it? Those sorts of things.
Okay, Matt, next one. And so you go about doing that, is that correct?
That's correct. Yes.
Okay, and as you're taking these measurements, how are you memorializing it?
So you can see here that what I'm actually using is
I'm memorializing it by the photo that you're looking at, you
it has
idiot.
large numbers on it show up in the photograph, and so these measurements are all photographed, and then what I've done is added annotation so that you can see what that actual measurement is.
Before you use those measurements, do you take any precautions to make sure that the tools that you're using are forensically correct?
Yes, yes. So this particular tape measure that you see here, this is actually it's what's called a pocket rod, but it's sold by forensic supply places as well as places that sell surveying equipment, things like that.
Okay.
You got a tape
And
measure
so,
at Home Depot. That's
tell
where you
ladies
got
and
the shit
gentlemen of the jury
from.
What measurement you're seeing here at 1 foot 7 inches?
So this would be the measurement just with the seats in place, nobody in them, from the basically the end of the armrest on the back row of seats to the back of the.
He was a whole row over.
Okay,
folks.
An entire row over.
An entire row over.
Okay, this is a little different. Tell the ladies and gentlemen of the jury what measures 1 foot 3 inches.
So you can actually see here that this seat back has some recline to it. So when a person's sitting in it, actually can push the seat back a little bit. So what we did is pushed it back as far as it would go and then did the measurement again. And it reduces to 1 foot 3 inches.
Okay, and so you're doing the variables for preservation of evidence. Is that what you're doing by pushing that seat back?
Yes.
Okay. At the time of this incident, you don't know if the seat was back or if the seat was not back. Am I correct?
That's correct.
But you're providing those variables for someone like myself to understand.
That's right.
Okay. Next one, man. What's this measurement?
Here, this is a diagonal measurement from the top of the seat in the back row to the top of the seat in front of it. Again,
Actually, it looks like it's a measurement from the wall.
so this particular diagonal is.
You want to just have to.
That's sloppy work.
It's red. You should be able to.
Yeah.
Unless he actually measured
So this
the
particular
seat
one, you
back.
can see the measurement goes, it's 3 feet 8 inches, so measuring diagonally from here to here. And that, what that's basically doing is showing you how much distance you would have moving from the back of the seat at the top of the seat over to here along that diagonal.
Next one, Matt.
And then this is a similar measurement, except instead of measuring the top of the seat, measuring to the back of the seat. And you can see it's a little bit shorter distance, but it measures 3 feet.
You know, just,
2.5
I mean, it's just sloppy testimony, but in terms of the record, he's saying things like measure from here to here. No one's going to understand what that means in the record.
Yeah.
Yeah.
Okay.
And then here measuring the from the back of the seat on the seat itself, straight across to the back of the seat in front of it. And of course, I've included a measurement here. So 1 foot 5
He heard you.
1/2 inches.
He did a little better than that
He
one.
did it better that time, yeah.
Back of the seat to the front edge of the seat, and then 1 foot 3.5 inches from the edge of this seat to the back of that seat, and then the total distance from here to here being 2 feet 9 inches.
And is this something, this is a procedure that you would do in every crime scene investigation that you would perform? Is that correct?
Right, you take measurements of whatever's around there. So sometimes you're working a scene and it's in a bedroom, you're measuring all furniture.
Mandy Kravitz just says that's not a lot of space to masturbate. Look, you make it happen with what you got. I mean, that's the reality.
Is this the same process that you teach your students as well?
Yes.
And law enforcement throughout the country?
Yes.
Next, Matt.
And this is showing the width of the seat at the top of the seat back, 1 foot 8 inches.
Next one, Matt.
And then this is showing the distance between the armrests on the seat, which is 1 foot 10 inches.
Why is that that particular measurement of importance, the width of the seat?
To show how much room a person is sitting in the seat has to move around. So how far can you move from one side or the other?
Next one, Matt.
And then here, this is showing a height measurement. So coming up from the floor to the top of the armrest, right here at the front of it, at the cup holder, just slightly over 2 feet, 2 feet and 1/2 inch.
Next one, Matt.
And then this is showing
Thanks,
going
Matt.
from the floor
Matt's a
to
bro.
the seat bottom where you would be sitting on it. And you'll notice there's a hand here, somebody's actually pushing the seat down because, again, just like the seats that recline back, the seat does go up. And so we want to make sure it's pushed down the way it would be loaded if somebody was sitting in it.
Oh, please get to the silhouette pictures. I want to see the state
So
object
this is,
again.
Showing the distance here between this seat bottom and the top of the armrest, which is 8.5 inches.
Okay, Matt.
And then this is just showing some measurements showing the height of the wall here. So this wall, the tape measure behind her is actually on the floor, and you can see that this wall behind that seat is just over 5 feet.
Okay. That's your
That's
close up.
That's the close-up that actually shows you the measurement, 5 feet 2 inches.
Okay, next one, Matt. Okay, let's stop there for a second. You took far more measurements than what we showed here today. Is that correct?
Own.
That's true.
Okay, you took measurements throughout that particular theater. Is that correct? At the different locations throughout the theater.
I did. I took quite a few different measurements.
Okay. Now, Matt, let's go to the next one. The documentation of items there at the theater at the time of the shooting, is that an important thing to do?
Yes.
Okay. And now that you've taken measurements of certain areas, are you able to certainly understand a bit better where those particular items may have been, as far as distance is concerned?
Yes.
Okay. And so what do we have here in this particular photo?
So this is just showing again, going back to that overhead looking down on it, this is the evidence, the way it was documented by the forensic investigators. But you can see where there's a popcorn bag on the floor here, and there's popcorn, and this is the seat that Mr. Reeves was sitting in. So this would be right, basically between his feet, and then this would be off by his right foot.
Okay. Next one. And that's documenting.
That there's a cell phone right here on the floor.
Okay. Same documentation.
Just a different vantage point with the camera, but yes.
Now, what is this photo? What is that depicting?
This is all showing the same area, just a different angle. And I point out that the fired cartridge case from the pistol is documented right here.
Now, this photo was taken by their forensics, is that correct?
That's right.
And some of these identification marks are, that was hard to read, it looks like. Is that depicting the actual seat number and row?
Yes, that's the way I understand it.
Thank God this lead counsel, defense counsel, doesn't know how to buy a PowerPoint slide advance remote.
This would be
Or Matt would be out of work.
Mr. Reeves would have been seated. Is that correct?
That's right.
Next, Matt. I think there's a better one. I may be wrong.
Matt, could you
There
do
was
better?
A fired cartridge.
Mom
case
told me I should have gone to
on
medical
this case.
school.
Yes.
Was that the general location of where it was found?
Yes.
And Matt, could you give us the next one? I believe it's a easier picture to see. Is that a photo depicting the cartridge of the bullet, or spent casing, I should say, not cartridge? Goes to show you how much.
So how was work today, Matt?
Casing.
It was awesome.
That's right.
That's right.
I was in charge of the PowerPoint.
You are not right.
Before we get to the next series, did you also see the autopsy photos and the wounds of Mr. Olson?
Yes.
Okay, and
They said tomorrow I could carry the
also see,
briefcase.
the wounds of Mrs. Olson.
Yes.
Okay. I know
You know,
that we will go through
If I'm watching this fresh,
Thank you.
I wouldn't be able to tell if this was direct or cross. I wouldn't be able to tell. It's that bad. It's crazy.
Oh, dude, the whole trial.
I'm just
not-
joshing Matt. Don't take it so
now,
seriously.
Let's talk a little bit about and
We love
I want
Matt
you to
here. What are you guys talking
stay
about?
standing here before we ask you a series of questions on this. Describe to the ladies and gentlemen of the jury what.
Right.
The whole testimony was cross examination. The guy hasn't even asked an appropriate question. The whole thing. I objected a whole series of questions.
That's not what they're going to do, though. It's that would kind of make some sense. They're not going to do that. It's going to be something dumber. We'll never know what it was. It's the worst part of how this trial is conducted. I do not like the sidebar off camera thing. I get sidebar out of the earshot of the jury or whatever for these things, but man, off camera or off mic for the courts, I want to have access to it all. I want to hear their bad, stupid arguments. I want to hear their bad faith arguments because they're making them. Both sides, by the way. I'm not isolating that to the prosecution.
I like it when the state goes objection and they just shrug. Objection, shrug. Your Honor.
Objection. My skin suit is falling off. Oh. Have you ever seen The Hills Have Eyes, Nate?
No, I haven't.
Oh, one of
It's
the
gotta be on my wish
prosecutors.
list.
One of the prosecutors looks like he's, in it. By in it, I mean one of the cannibal family members.
Yeah, that's on my bucket list. I gotta watch that movie. I love all the horror slasher movies too.
Well, after you watch it, you have to watch the important Cinemax spoof of it, The Hills Have Thighs.
Ooh, Skinamax.
Yeah, well, not anymore. It's
Yeah, I
they don't
know.
do those anymore.
Those were
They
great
stopped.
back in the days.
I know. I loved them. They're so funny. The titling of
Okay,
them
so
was
let's talk a little
clever.
bit about back.
They don't do that anymore?
And explain to the ladies and
Nope,
gentlemen.
Cinemax and HBO do not do adult
that
softcore
okay.
content anymore.
Back when they used to call it Skinamax.
Backlighting
Yeah.
behind it from the back. So, if you, most of us probably taking a picture of somebody outside with the sun, there's a bright sun, or bright sky is behind them, and you take the picture, and then you.
So why do we need an expert for silhouettes if he just told the jury you've all had this experience?
That's an example of backlighting.
Well, that was the argument from the state.
What we're interested in any kind of crime scene is what sort of lighting conditions could be there and what sort of lighting, backlighting would be present that could affect how somebody sees it.
And so we're going to go through a set of photos here.
It sounds like the defense has been told they can't keep critiquing this crime scene. That's why he keeps saying, well, for any crime scene, you'd want to do this.
Mr. Reeves actually saw on the day of the incident. Is that correct?
That is absolutely correct.
You're trying to show the actual effect of backlighting in certain positions when someone is in front of that backlight.
That's correct.
Okay.
Counsel, just over to the side.
Okay.
No. I guess Rosenwasser must have thrown his hands up. A thrown hands objection.
Just hold a second. Court's going to be reading an instruction that's appropriate during this period.
Oh, this is what it is. They agreed on this instruction.
The jury will disregard this expert testimony.
Ladies and gentlemen, this testimony is being offered only to demonstrate the concept of backlighting, and that's what you're to consider it for.
That'll work.
Yeah, the jury definitely took that instruction, understands the evidence that they haven't seen yet will be only to apply to backlighting.
And for no other purpose.
He does look like a smoothed out James Carville.
About how you set these photos up in order to show the backlighting effect. This individual that we have here, what is that?
So that is it's a forensic mannequin.
And you use that mannequin and you place that mannequin where?
So the mannequin is placed on not the back row, the row in front, staying in front of the seats facing back toward the back row.
Okay. And at the time of placing the mannequin there, did you have a camera?
Yes.
Okay. And at the time of placing the mannequin there, was there backlighting, and where was the backlighting coming from?
The backlighting, as you can see, this is actually coming from the movie screen.
Okay, and so you place the mannequin in various positions in order to do what?
To show the effects of that light.
Sounds kind of personal.
Objection.
Knew it. I knew they would object to the silhouette.
You got to, because this could destroy your case. Especially it puts the jury in that moment and say, well, it's hard to see.
They've already lost on this objection after two times, an hour each of discussion. One of them just before this this witness got up there, and so now them objecting again is great because this has already been ruled on, and I don't think the defense has gone outside of the scope of the ruling here because they're asking about the silhouetting. They got the limiting instruction. That's where the limiting instruction came from, was the objection before. So this is great. The next question, they're going to object again.
A little tape recorder inside the mannequin says, "Fuck you, old man." Die.
Trying to talk to my fucking daughter. You can talk to my fist. After I kill you, tell God I said hello.
I'm here to eat your popcorn and beat up old men, and you're all out of popcorn.
Oh my gosh. Oh, okay. Let's see. What? Where were we?
We're an hour and 45 minutes into this guy's testimony, not counting the breaks.
God, it's so freaking long.
So that's like 3 hours in human time.
Where? Oh, damn it! Thing just jumped out.
No.
I'm trying to find the super chat where we were.
4 hours in human time. I forgot about lunch.
Mystery Box Guru sent a message, but it's retracted. Andrew Clark says, "Kurt, will you?" He left. Will you cover JXC reaction content video? Maybe with Nick. Previously, Hassan Piker argued that it's okay to chair stream a video because he needs to make food when his mom can't bring him his chicken nuggets. Yeah. You have to do something to transform the content. Hassan was just sitting there, or well, actually, in many cases, not sitting there for like an hour at a time. So he was. He's got some issues with his.
Okay, Dr. Knox, we're going to be going now through a series of photos of the mannequins in different positions.
The mannequin does look pretty threatening there.
No, it's only 5'9". It can't be threatening.
Go ahead, Matt.
I don't know if I'm going to cover the YNW Melly case. I haven't looked it up yet.
Talking to me, old man.
Amen. That's it. You can.
Oh, Matt. Poor Matt.
That's it.
Sorry, Your Honor. I made you come all the way over here. We're just.
It's those 3 pictures
She's
of the
getting all her
silhouette.
steps in today.
Two hours
Dr.
of
Knox,
argument over those 3 pictures.
Do you agree or disagree that
Here we are.
you with an issue concerning 2 items in this case? One being a light that was either reflective or emanating. There were 2 items that.
It's a leading question with multiple subsections.
And telling me what that light source was. Correct?
That's correct.
Remember that? That was in the video.
Yes.
Is that correct?
That's correct.
Your Honor.
Yes.
Oh.
Do you agree or do you agree?
We think this is agree or disagree, Honor. This is leading. That's what I would do. That would be my objection after she kept sustaining or overruling him. Agree or disagree, Your Honor. This is a leading question. Oh, I cannot believe those silhouette pictures. They objected to that hard. They were really nothing. Hours of time. So Andrew Clark says, Kurt, will you cover JXE reaction? Oh, wait, I read that. I forgot I read that all the way through. Susan Swenson says, poll time. I am on the fence. We could probably do a poll in a second here. CS says, did Kurt get a girlfriend? He's way too chipper lately. If so, congrats. Happy for you. Sad for me. Aw. Stephen Cooper says, sounds like a deal family court would make. Not sure what that's in response to. Mandy Karaviches says, I think I'm actually stronger than all 4 of you. How do you feel about that? I feel great about that. I'm very happy for your women's empowerment.
Go ahead.
Andrew H says, start a women's chess league and Formula One league so they can get paid more like women's soccer. And then the Scarlock says, does poker, the card game, count as a sport? There have been females that have done well in the poker world, Vanessa Selbst, etc. I have no idea. I don't know what's a sport anymore. Because like all sorts of weird stuff has been added. That's that. John Mack says, why is this case going on for 8 years? America has issues, big issues. Well, a bunch of reasons. A bunch of reasons. 2 years of that is probably related specifically to COVID. But there was a pre-trial mini trial over a stand your ground hearing, but calling it a hearing is a little selling it shorter than I sold Odyssey's numbers earlier. It was a 2-week mini trial that they did over the stand your ground issue in Florida. And so they've already done the trial then. And then once that got denied, there was an appeal process that happened over a rule change that occurred at some point. And then there's been some requests for continuances. So it's long. I mean, the reason most cases don't take 8 years when you have the person there. Now, 1 to 2 years often.
Dr. Knox, back to
But this one, I think they wanted him to die before it went to trial.
Source. And you remember taking Mr. Reeves' shoes that we had obtained from court order?
Yes.
And you remember taking an iPhone?
Yes.
And you remember going to the theater at, you agree or disagree, what, 2 o'clock, 3 o'clock in the morning that we went there?
It was about that. That's right.
And did we bring Mr. Koenig and Doug Lacey from Beck Tech with us?
Yes.
And you agree or disagree, we did that in order to try to replicate and find out what the source of that illuminating or reflective light was that we see in the video?
That's correct.
And you agree or disagree, when we went there, the entire system had been changed?
That was my understanding. That's correct.
And you agree or disagree that we could not perform that analysis because of that reason?
That is correct.
You loving these leading questions, Nate? But he said agree or disagree every time.
I have no further
There it
questions.
is.
Thank you.
Wow.
Cross.
Thank you, Your Honor.
I
No
didn't
cross
know.
at this witness.
Are we using the screen anymore?
I can move it.
That'd be great. Thanks.
Can we move it?
Yeah.
Agree or disagree counter is up to 77.
Maybe they just don't know what leading questions are. Maybe just like you can't say yes or no. All right, so agree. I don't get this.
I just have no idea what a leading question is. Oh my gosh. Welcome back to the frame, Eric. Get your phone out immediately. Start screwing around. You no longer have to worry about that PowerPoint. All right, back to Candy Crush.
My job is done.
Slaying it on level 1132.
Good afternoon.
Good afternoon.
I'm assuming you were billing in this case.
Yes.
Okay, and what's your hourly rate?
$12.50 an hour.
For this case, I think it's at $250 an hour.
Okay.
Nice.
And you charge for travel?
I do, yeah.
And how much on top of the 250 do you charge for travel?
Well, the travel I charge at half rate, so for actual travel time.
So 250 an hour, and then for each hour that you travel, $125?
That's correct.
All right. And how much have you billed so far in this case?
I really don't know the numbers for that. I mean, I've obviously done a fair bit of work, but I don't know what the numbers are.
Okay. You keep records of that, I'd imagine?
I do.
All right. And you've testified, I think you said, in other cases?
Yes.
Okay.
Yes.
And I would imagine that when you testify in other cases, one of the first questions the opposing counsel asks you is how much you've billed in the case, right?
Sometimes I get asked that.
Okay. Well, when you say it's a great majority of cases, because that's something that people normally bring out with the opposing people that are testifying for the other
He's still mad that the other expert
Uh,
didn't know how much he'd been
Sometimes yes,
paid.
sometimes no.
Okay. Well, my question to you is, don't you think it's a majority of the time?
Objection
Has
relevant.
to answer it.
I don't know. Just say I don't know
It's
if you don't know.
position you've taken, people ask you, right?
No, I mean, not always. No, I get quite a few cases that's not really the.
Right. I'm not asking you about all the time. I'm just saying most of the time.
Yeah, I mean, I don't know. I couldn't give you the numbers. I don't know if it's most of the time, half the time, or what.
Okay, we're going to move on. The only reason I'm asking you is I would think that you would anticipate that question would be asked of you today, so that you could come to court prepared to answer that.
Calls for speculation. Like this guy's just breaking all the rules.
This is
Yeah.
just badgering.
Here comes the objection.
Because he could have subpoenaed Justice Tico if he wanted that question asked. He's giving some indication that there's something wrong with
I'd
it.
object to the speaking.
All right, all right.
I object to the speaking objection with my own speaking objection.
The measurements that you testified to that we saw up on
We will
screen,
send the lollipop guild to you.
those are just basically measurements. You're not.
This looks like a
presenting
scared cross
saying
or an
these were
angry
where
cross to
people
me.
were at any particular time.
When you're starting with the
They're
amount of
measurements
money
in seats.
Right,
and being
measurements
mad
and seats just show
that he
the
doesn't
different
know the
variances
exact
and
amount
stuff,
he's
so-
billed to this
So
day.
like what I was saying, it's not supposed to give this jury the impression that's where anyone was in any particular point in time.
That is correct. You're correct.
Remember, they hired this guy 8 years ago. How much have you billed in this case? I don't know. His first stuff they recreated.
Let's just talk just a little bit about backlighting. Now, just to make sure this jury understands, because this is important, the presentation that we all just watched, the only purpose of that was just to demonstrate the concept of backlighting.
That is correct. To demonstrate the concept, I'm not trying to demonstrate that that's what anybody saw in that theater that night.
Okay, and the object you chose was mannequins, because I guess it made sense, but in reality, you could have chose any object to demonstrate what the backlighting was.
No, not really.
Yes, I mean, I use mannequins because you have at least a human-like figure, because some of the issues with lighting is things like shadow. And so
Right.
obviously the shape of your face may cast shadow differently than another object might.
And again, we weren't using those mannequins to say that was Chad's shadow or anything at all like that, right?
That's correct.
I would have said no. Chad was much bigger
when
and
you say
scarier.
backlighting, like in the photo that you showed to the jury, there was a white background, correct?
That's right.
All right. And you're not telling this jury that that was the background that was going on at the time of the shooting, right?
That's correct.
All right. So really that picture doesn't depict what was going on at the time of the shooting, like you already indicated.
Right, right.
And when you talk about
Those
backlighting,
pictures were
obviously
nothing.
The nature of that is it's the back, right? I mean,
Right,
you saw the screen.
It's a tactical mistake because he's making the picture seem more important than they are.
Overhead lights that were on, correct?
It was
Well,
three pictures
when
they
those
spent
pictures were
30
taken,
seconds
the
talking
lights were
about.
set at mid-1, which is the setting that they would have been at the time of the actual shooting.
Okay. And there was also the screen though itself would be moving and having a
It was
different.
also the light of the gunshot,
Right.
wasn't
What
there?
was played at that time was just it was a different trailer. It's not the same trailer, so I don't know that exactly what was on the screen at the moment of the actual shooting.
Okay, and you would agree with me that
Did
the
anyone
camera
look at
lens
those?
cannot adequately represent what the human eye sees.
Yeah, that's correct. Because for one thing, it's a two-dimensional image as opposed to the three-dimensional that you'd see. But you're correct. It is a picture of it, not what your eye actually sees.
Right. If there's no technology out there in reality, there may be in the future probably, but as of right now, there's no.
Well, no, there's technology out there that can take 3D pictures like the
So we're
eye.
just looking at a picture that's demonstrating some light in the background that wasn't the movie at that time, correct?
That's right.
Did any of you in the audience see those pictures and go, "Oh shit"? I mean, now it's definitely justified.
Nothing further. Thank you.
Any redirect?
Oh my God. That's,
All right, thank you.
talk about much ado about nothing. Spent half a day prepping this guy for his testimony.
All right, Dr. Knox, you're free to go, but if you get called back, you have to come back. I'm sure they'll allow you. to
Half
come
the day
back
we spent.
Against notice if need be.
Yeah, five hours, 4.5 hours.
Yeah, I mean, we've been here since. I mean, they started.
We
Well, I
started
got on at
6:30,
7:50.
Right. Oh, well, we'll use your time, and then because you slept late as usual.
Yeah.
And then they had the doctor on video for 90 minutes.
God, it's terrible. They have more legal housekeeping. How is this not done yet?
This is what happens when you rush to trial, Nick.
Yeah.
After 8 years? After 8 years, you're rushing to trial?
Please remember my instructions.
They're rushing to
during
trial in a
recess,
Ford
and,
Fiesta.
We'll call you back pretty quickly.
We had no idea this trial was coming up.
Oh, God.
He's like, we started this in high school. Now look at me now.
So yesterday they dismissed the jury early, around 3 p.m. And then the prosecution and the defense had a conference, and then they all came back into court and argued legal matters for another hour and a
Okay,
half.
So what do we got? Stuff on Dr. Bedard?
Yes, judges. The next witness is Dr. Bedard. I know that certainly had an offer hearing. The ruling was that he testified.
Speak up a little.
Yeah.
We had Daubert ruling. Certainly the ruling was that Mr. Bedard, Dr. Bedard, able to testify as to his expertise in the field of defense tactics, use of force, and human factors. And I know the order says something to the effect of subject to the normal rules of evidence. So I know that the state approached me with some concerns. One of the concerns was because, the deposition.
Let's be quiet in the galley, please. We're trying to hear.
The deposition was very wide ranging. I understand Mr. Martin's perspective. Dr. Bedard didn't write a report, so we just wanted to find out what his knowledge of is, and then potentially what he would be testifying to. And so one of the issues was a kind of a narration of the video. We agree that Dr. Bedard is not going to narrate the video in any form.
Okay.
Another issue, as I understand it, was that there was some discussion as to whether Dr. Bedard thought that Curtis Reeves acted reasonably. He gave his opinion because he was asked. I think he prefaced it with something to the effect of, I can't say that in front of a jury. Certainly, that's not going to be brought out in his testimony. One of the issues is I think it's an objection as to curativeness, because we had Dr. Cohen testify as to age-related kind of self-efficacy. A person realizes they're vulnerable and all that. And so I know that that's something that one of the things Mr. Martin wants to address. So the court knows what my perspective is. However, we stopped short of allowing her to do a threat assessment. In fact, that was one of the things that was objected to. So when it came down to making certain choices of doing things because of that perception of vulnerability, she wasn't allowed to do that. So it's not cumulative in that Dr. Bedard's going to testify that that's a factor in terms of threat assessment and risk assessment, which Dr. Cohen was not able to testify to.
Okay.
Judge Lewis's order, as you know, indicates as to whether any specific facts or data underlying Dr. Bedard's opinion or any specific testimony will be admissible at the trial will be a decision for the court at the time of trial and subject to any objections on that trial. So I have numerous objections to numerous parts of this testimony, and it includes
numerous
not only
objections.
what I presented and my previous motions have been thoroughly briefed and you've had a benefit to read, but also statements that he made in the very lengthy deposition. So I'm going to begin with the issues that I brought forth in the motions that I filed.
Okay.
And if we could just be able to address one at a time.
Yes, one at a time.
Damn. Well, this is great because I got to go pick up my kids. It's almost 3.
So, you lucky bastard. Oh, my gosh.
Yes, picking up children versus hearing his laundry list of objections. Good luck, guys.
Why, Nate, 8 years. How have they not resolved this?
This should have been on the papers before the trial. Here, it's not like they just found this out like today. I don't know. It doesn't make sense.
A judge just has not ruled on this. I got the idea that this is actually submitted pre-trial.
This should have been a motion to eliminate for sure. And okay.
It's important that I ferret out exactly where we're
I'm surprised it's not on the papers though. Why is he speaking about them? He's like, throw them on the papers and I can just answer them. I don't know. This is just crazy. That's good luck, guys. I'll be back.
See you, buddy.
But this is how the video was used by Dr. Bedard. He used the video to interpret, he used the content of the video in making certain interpretations. One, he used the video solely for his conclusions regarding certain points of interest. You might recall I listed out about 6 points of interest, and they included whether or not Mr. Reeves was hit with an object before the tossing of the popcorn, the relationship between the parties, the number of attacks, whether or not Mrs. Olson was holding him back, was Mr. Olson leaning or standing over, and whether or not Mr. Reeves uttered the words, throw popcorn. All of those points of interest were his
Volume
analysis
up.
of that was solely based on
There.
the video.
Why?
So when we start talking about, well, I determined this or I determined that, he could be interpreting the video. And there's no way around it. So my objection is that those points of interest, that's for the jury to decide based on the video. He can't come in and say, okay, my review of the video, Mrs. Olson was or was not holding her husband back. See what I'm saying? So if he comes in and goes through those points of interest, relying solely on the video, well, that's for the jury to make the interpretation, not for the expert. You can understand the weight that was carried, and that's the problem that we have. So that was the thing with the video, not the running narrative. But if that in fact is proper, or he does that analysis based solely on the video, then that's for their determination.
And that's not a problem, Your Honor. Our intent is not to have Dr. Bedard comment on what he saw in the video or make any kind of conclusion, base any kind of conclusion based on the video, except for one. The only issue is going to be there is he's going to testify as to perception reaction time. And so the issue is going to be just the timing of the video. And I spoke to Mr. Martin. He's not opposed to this. The question will be not, did he watch how long and all this stuff. I can give him time references and say between this time and this time was the firing of the firearm in response to the throwing of popcorn.
Oh.
I think that Mr. Martin agreed with me on that yesterday, and that's the extent of his use of the video in terms of being able to testify to that. And that's all we're looking to use it for, not that, I saw, from my view, I saw Mr. Olson coming across a seat at 13:25:36. We've shown that video.
Mm-hmm.
We put photographs in. And the court has seen it as well. The first attack, he's not going to say there were 2 attacks and all that. If he's pushed, if somebody's going to ask him, well, how did you come up with this or that? Then they're opening the door for him to say that. But I'm not eliciting that. That's not my purpose in having him testify.
What about that portion? I remember that portion pretty clearly, that, the breakdown of how many seconds it takes to do this, or milliseconds, and
And we've had that testimony.
not here in the trial yet, have we? Where was I? It's like,
No, we had not. And so to keep it from going as.
That witness did it last time. Yeah.
Last time.
Previous hearing. You're right.
Oh,
You're
okay.
right. It wasn't off.
Okay.
You're right.
In terms of having.
Look, that's included. I can handle that on cross.
okay, so that part is okay. The frames from the popcorn toss to the shoe is.
So he said they already had testimony on that?
The whole grabbing, all that.
Right.
And Mr. Martin is.
I think he meant at the self-defense immunity hearing, and he doesn't have an objection,
Okay. so
as
we
opposed
don't
to saying
go beyond
it happened earlier in the trial and it would be cumulative.
Okay.
Okay,
that
so he was saying
all right,
it-
so Mr.
Yeah,
Dr. Bedard
he's
is
saying they
not
don't
going
have a
to,
problem with that.
I think that's what he's saying, but no one's speaking very clearly.
But it's not gonna be like one of those civil police shooting cases where he's gonna say, I looked at the video and I saw this force being applied, or that sort of thing that you typically see in civil cases. That's
Right,
not-
I've read some of his,
And frankly, if you ask him the question, he would refuse to do it because he understands it's the province of the jury. So he's not going to do it.
Okay. Go ahead.
The other issue was that based on his examination of the video, there's missing frames. There is no expertise on that.
I don't know how I'm suddenly being super loud to you guys. My volume is not changing.
Agree that he has the expertise to make that determination is cumulative. So I would object to that, and that was in his second deposition.
Yeah, I turned up the court feed, so StreamYard probably compensated trying to boost my mic.
12 seconds before the popcorn attack, or what turns out to be a popcorn attack.
So, this is the fucking shit I hate with
his,
StreamYard.
Hypothesis was potentially, well, I don't know what's happening there. Maybe the camera's not capturing something, but we know that maybe it is.
Good. I'll yell louder. Fuck you.
He's not going to testify in terms of what if that could be happening and this could be happening. You know what I mean? So the only time that would come up, the state asked him, well, you see nothing happening before that. It's just a popcorn. How can, they're not going to ask that question. So I'm not, I know. So I'm not going to ask him, about missing frames. And we've seen that there is parts of what happened missing because of the inadequacies of the temperament of the cameras and how they were set.
Okay.
So that's not a problem.
All right.
He also indicated in his second deposition that he has watched the video and his interpretation of the video will be most consistent with what story Reeves has been telling. So to compare that to his statement in any way.
Right, I remember that.
That's not a problem. He answered the question that he was asked. It was elicited of him. And again, I'm not faulting the prosecutor. His words, bobbing for apples. I get all that, but that's not the intention. That's not proper. Dr. Bernard isn't going to testify to that. And again, because of his integrity, he wouldn't if you wanted him to.
Okay.
So that's not coming in.
All right. So that's not coming in.
He also speculated and
I'm coming
interpreted
in.
what he did not see.
I'm gonna come.
And as an example, in the first, all in the first deposition, I learned that there's a lot we can't see, so it's hard to validate what Mr. Reeves says or invalidate it. He also says
Investigations, and then I
What
took
the fuck?
another one on.
Damn it.
It's
Hold on.
titled Injury and Death Investigation.
something, perhaps a fist with a phone. We can't see any of that. And then at the previous hearing, Reeves testified to a segment of what I've heard. He says, I don't see that. So when we're looking at what Mr. Reeves said previously at previous hearings, and then on the video, he's commenting, interpreting, and either giving credibility or not credibility. So that's just improper for him to interpret the video and then say, well, I can either confirm or deny Mr. Reeves' statement. So I object to that.
And again,
He did a lot of that, as I recall. That was his method of validating things and,
Yeah, the null hypothesis.
Thank you.
Because those questions were asked of him. I know you want to read, maybe the whole,
I
there were
did.
hours and hours of deposition.
I did. I read
And-
hours and hours of stuff.
I know. And so, Mr. Martin is very good at asking questions. There's various ways of asking the questions. So it became a philosophy, almost a philosophical discussion between Dr. Bedard and Mr. Martin. And so he said those things, but again, it's not our intent to pretend him to say that he finds Curtis Reeves credible, or that he finds him credible because he can see it on the video. That's obviously not for him to testify to. That's for the jury to look at and decide.
All right.
He's not going to do that.
That's because that sort of dialogue did concern me as well. Him commenting about Mr. Reeves, basically in a nutshell, about Mr. Reeves' credibility.
And I understand.
And there was a lot of that.
And I wish the rules of evidence allowed me to do that, but I know they don't, Judge. So I can't testify.
Okay.
Judge, the last thing regarding the video is this 6 to 8 second gap that you've heard that term used, throughout the trial so far. And what I'm objecting to is, again, he's commenting on what's not in the video. And this is the way he does it. And this is in the deposition. I don't think so. I would have, again, some of what's missing is the initial attack that Mr. Reeves described. That would have been a point of interest.
is still a point of interest, but it seems to be not captured. So again, he's going back and giving credibility to Mr. Reeves that 8-second gap, giving credibility and saying, yeah, believe Reeves, what's that? So again, it goes to the credibility, and so I would object to that. It goes on, it's just a personal opinion about all the things that may or may not occur, but that's the most important thing because he specifically says, I believe Mr. Reeves.
And again, Judge, we're back to the missing frame things. I have my hypotheses of what occurred during those missing frames as well, but I know that certainly, if I were to testify, I couldn't do it. And I don't think that Dr. Bedard intends to do that. He's not going to talk about the missing frames. He's not going to hypothesize on what may or may not have occurred, or that he expected something to occur or not to have occurred during that time frame. So that's not a bone of contention here.
All right, so let me just clarify real quick about these missing frames. Are we talking about the blue and the black?
Yes, Your Honor.
Yes.
Unrecorded because there was no detection of movement.
Or because the sensors were set in the camera was pointed in such a way as not to detect movement. There were several reasons given as to why that.
But there's all of which are basically because it wasn't the greatest system in a short way of saying
System
it.
worked as it was designed.
But
No, it worked
there's no
exactly as
indication that
designed.
Somehow, as I didn't hear anything from the expert witness about the missing frames. It's not like somebody came and altered it.
It was an unartful way for me to make that statement. I should have said the unrecorded.
Okay,
It's my fault.
thank you.
Right, and the expert explained that it's because of the sensitivity, the settings of the camera. The expert also testified, well, we'll never know what those are because we never got the hardware and all of that. But that's what we're talking about.
Okay.
Those unrecorded frames.
Okay. Unrecorded moments.
Judge, the
Unrecorded
next one
moments,
is,
a courtroom drama.
is a little more complex.
Okay.
Because we're dealing with the
Viewing.
this self-report method to prize COVID, self-efficacy. It's along the same lines as Dr. Cohen testified to. She even testified that that individuals will in fact make decisions based on what they know their limitations were, whether it be mental skills, physical skills. That's the way we go through life, and as we age, those parameters may differ, but our decisions are based on what we know about ourselves. So when we talk about self-efficacy, which is what Dr. Bedard wants to testify,
Oh my God.
about, he read my section in Daubert about that and all the literature. Okay, I don't need to go into that, but here's the main point. First is cumulative to Dr. Cohen. Second is that in order for that to be admissible with an expert under 702, it has to be helpful to the juror. And this is what Dr. Bedard said in the second deposition on pages 28 through 30. Do you agree or disagree that it is common knowledge of adults, if you will, who have certain life experiences, that in making a decision that they will weigh their individual limitations in making the decision on how to complete a specific task? That's pretty common knowledge to everyone, isn't it? Yes, I think so. So we have a situation where we're putting on an expert who has acknowledged that he candidly says, yeah, that's basically everybody knows that. So that would be the cumulative would be the second. He's already acknowledged that it would not aid the jury. And then get to the right page. We talk about the self-efficacy. He identified certain things.
Come on.
That Mr. Reeves knows. But again, he acknowledges, just like he did when we had a brief discussion about it, that this is all common knowledge. It's when you make a decision, we take in our limitations. So I would suggest to the court that we not only have a cumulative argument, but we also have, as an expert, designate the jury. So I would suggest to the court that you consider that and whether or not he's going to go into this litany discussion about self-efficacy and decision-making process, go on and on, when we've already had one expert very succinctly say, yeah, that's the way it is, and now we're going to do it again? No, that's just cumulative. And he already admits, everybody knows.
All right. I remember much of Dr. Bedard's testimony about this. And he there was definitely separate.
There's
over
definitely
and above,
something.
if you will, beyond what Dr. Cohen testified, more in the context of combat almost. Can I take him, or should I take him, or am I able to take him, or something along those lines. So what about that? What about Mr. Martin?
Prosecutor Martin does sound like one of those bubble fountains.
In terms of cumulative, it's not cumulative because it's definitely in a different context. Certainly, Dr. Cohen was brought up short of being able to put it into context. In terms of the objection, sounds like a Dauber-like objection that it would aid the jury because the person questioned saying that that's pretty common to everyone. But again, it's within context. We all know probably that if it's dark, it's more dangerous. We all know that if it's loud, we can't hear as well. If it's dark, we can't see as well. But what we don't understand is that put together, these factors
Maybe you don't
can
understand.
have different meaning to somebody who is trained properly. That's where the whole risk assessment thing comes in, right? You have the threat assessment, so you identify the threat, risk assessment dealing with human factors, and this is one of those human factors. So really it goes more to weight than admissibility, because really that's what we're talking about in Dauber. This isn't something that's so far within the realm of the common knowledge. I mean, Dr. Bedard, I don't know what he thinks about the common person. What we tend to do in this profession as well, we tend to think that people know what we consider very simplistic ideas in our profession. For instance, objection. I see lawyers do it all the time. They'll come into court and they'll speak to prospective jurors.
Ask leading questions on direct.
What we're talking about. Some of them do, that's true, but not everyone. So just because his opinion at that time was, well, it's pretty common knowledge, we have to look at it in context. So I don't think it's definitely not cumulative, it's in a different context. And secondly, will aid the jury in understanding the concept, the human concept, human factors concept of risk assessment.
All right, so what you're saying is that you want him to testify about
What a
threat
trained
assessment and
use of
risk
force
assessment in the
person
context
would know.
of someone who's been trained.
Yes, Your Honor.
All right, and
That's not this issue. I mean, training, I'm not talking about training, I'm talking about physical limitations. And
okay, but
self-efficacy.
in the context of someone who has this training, that's what I'm getting at. Because if
Just shut your mouth, Martin.
then I
Shut
tend
your
to
dirty mouth.
point that
Shut your
it is
receding
common
jawline, you
So,
idiot.
In other words, what I'm hoping to
If you would please
avoid
stop
is that you
burbling at the bench, counsel.
just regurgitate or have him
Regurgitate.
that Dr. Cohen indicated.
If I could address that, Your Honor?
Yes.
There's no amount of training that can change the infirmities that come with age. So it doesn't relate to training. It has nothing to do with training. We're going to get to this point in our lives and we make decisions based off of our. That's not any type of professional training. It's apples and oranges.
Well, I'm speaking about what I've gleaned from Dr. Bedard's testimony, that's what he's indicating, that because of his training, he's going to react this way, or a police officer would
I
react
think
this
that's
way.
threat assessment, that's another area.
Well-
No, it's more, well, they kind of bleed over to each other. Threat assessment, you're looking at what's presented to you as a threat. Risk assessment, you're making a decision based on, in this case, one, your own limitations, whether that be physical, whether it be psychological, and physical includes not only, being older, but they not necessarily, that was Dr. Cohen's testimony. Physical assessment of oneself could be that I'm not that strong. I don't have to be 71 years old to know that, if I'm a 92-pound weakling, that I'm not going to be able to
Oh,
date somebody. So it
everybody who's
doesn't
92
necessarily
pounds
have
just
to
got
do
called out.
100% with age. It has to do with size and a lot of different things. So, part of the training is you have to assess your situation, including your own limitations. So I think that, for that reason, put in context, the jury should be able to hear that. That's part of the program that's being taught by Dr. Bedard.
All right, so let's keep it from not being cumulative to Dr. Cohen. And
Right, but we're not talking about.
Joshua Tureen, no, they're not arguing that training doesn't matter. They're arguing that training is irrelevant to the factors of aging.
And before you move on,
It's like
Mr.
a half
Martin,
truth.
Before I forget, I remember multiple times an exchange between you and Dr. Bedard about what you would say. So you want to tell this jury this, and Dr. Bedard would say, I don't want to tell them anything. I'll say what I was asked. I'll answer what I was asked. Can we avoid that to some extent?
I don't know, because I don't know if I ever got to what he's going to be asked, because the analogy is I was bobbing for apples. I have no idea.
Well, just rephrase, is it your intention to testify if asked? Because it
Just
it
don't
was
say, so
clear
you're trying to
me
tell
what
this
the dialogue
jury.
and what the offense was in Dr. Bedard's eyes, that he took offense that you indicated he wanted to tell the jury things. So that, I saw no less than 5 or 6 encounters like that.
She's
in
just
the
asking you not to be a dick,
can't
Martin.
afford that type of
Tough.
banter. But
It's
and I'm
very,
not
very
trying to
difficult.
limit- I know, and I'm not trying to limit, obviously, you have your strategy, and maybe that's part to.
Maybe being a dick is your
raise the
strategy.
ire of the witness, I don't know, but let's try to, not do it
I apologize.
multiple times.
I have no idea where the court's going with that. That's not going to come up in the courtroom. That's deposition. That's not proper process.
That was deposition, Dick.
Right, because if he says something like that in the courtroom, he might not like the answer that
Yeah,
the witness gives him. So if he wants to say it, have
I
that.
didn't, okay, maybe it was an awful way to try to figure out exactly what was going on, but that's not courtroom stuff.
All right, well, that's what, you want to tell the jury, you want to tell the jury, you want to tell the jury. Okay, all right.
So he just said that exact line in the previous testimony. I think she's talking about the deposition that they did, right?
I'll give you a
Yeah. But in the previous testimony, he said, so you're here to tell the jury this. Like it just
That
happened.
did not relate to the video, was that Mr. Bedard did in fact interview Mr. Reeves. And I don't know if they're going to attempt to get in it. There's a whole different argument.
We're not, he's not talking about an interview with Mr. Reeves and his opinion based on that interview as to what occurred or didn't occur.
Okay.
This is not a forensic psychological examination.
Okay, but one of the issues that came up that I'm concerned about, and I don't want to get blindsided on it without discussing it with the board, is that for the first time, Mr. Reeves said, oh, by the way, I heard patrons.
They're this concerned about this expert because they don't believe the facts in the law are on their side. They believe they're on the razor's edge or losing. And this could be enough to push them solidly into losing.
Litany of,
If they'd had a robust prosecution up to this point, they wouldn't be this concerned about every word the expert might say.
he goes into his reasoning about, well, that might make sense, that not make sense. See what I'm getting at? I don't, if we're not going to talk about anything about the devil, then this doesn't come in. If this is coming in, then we got a whole different argument. So I'm.
Are you talking about the part where he said, he comments on the statement, you threw popcorn and how the timing of it?
No, Mr. Reeves says he heard patrons say that. He didn't say it. That's what he told the dog.
Okay.
That's the first time that's ever been said. So I want to know if that's an issue that they're going to bring up, because it is to me about the argument.
It sounds like hearsay to me, but I
Well, it does to me too.
I didn't think of trying to get that in.
But now that you mentioned it,
All right. Anything
I
else?
think it's a valid theory though.
Judge, there's the one about,
Oh my gosh, this is tedious.
he has a section of knowledge that we discussed dealing with people involved in a stressful situation and artifacts that may indicate and verify that the event was in fact stressful. You might recall that in the definition. We talked about artifacts. Those artifacts being reaction time, different perceptions, cognitive perception differences, television, remember he had a list of all those things. Then what he says is, and I asked him, well, did you see any of that, Mr. Reeves? Very candidly. He said, no. He said, I didn't see a lot of this. As a matter of fact, the only thing I saw was some memory issues. I think that demonstrates that at some level, fragment memory also occurs under high arousal. But he also said that that he did not see any of those except maybe fragment memory that went to in the law enforcement statement, I don't recall. If he didn't see any of that, that's what he testified at the testimony, then it's not relevant. You just don't put something before the jury and say A, B, C, and D when it doesn't apply to the defendant. So if it's a non-issue, why would we go through and educate the jury on something that doesn't exist in the case? So it's not relevant, and I would ask that that be excluded because Dr. Bard very candidly said, I didn't see any of that.
So I'm trying to wrap my head around this. On one hand, the prosecutor said, we can't use the interview because that's not legitimate to use in this sort of trial. It's not a forensic examination, my words, but we cannot use that interview. We can't say what Reeves said. Now they're saying, well, based on that interview, and again, we don't know how complete it was. We don't know exactly what questions were asked of Mr. Reeves, that somehow we're going to decide that these artifacts of stress, in other words, what happens when an individual is under stress, again, that Dr. Bedard not only trains others in, but has studied extensively, that he can't educate the jury on what these stressors are and what the manifestation of those stresses are. That makes absolutely no sense. The jury can decide if Mr. Reeves was under that stress or not, if he suffered some artifacts of stress, if they want, but certainly it's not irrelevant. It's relevant to the whole idea of human factors, the whole idea of risk assessment and making those choices.
human factors, that's all that For Science Institute stuff.
This would be different if
I took that
the
class.
presentation was, these are the
Was it any
manifestations
good?
of stress, and these match up with ones that Reeves,
Well,
that he didn't have. We're not doing that.
a lot of it is just common sense type stuff. A lot of it is research they've done, like with human subjects, where eyeballs track things like that. I think that's all very interesting. No one else does anything close to it. But I have to say often, I mean, so I did my graduate work in biology at Harvard, and part of that was epidemiology and methodology. And the methodologies used by For Science Institute, I think, are really often underpowered. So I think the data you end up with is questionable. But they may be underpowered. I think they are underpowered because there's no good way to do them well-powered, so you get good data. So I think the studies have a lot of shortcomings, but I'm not trying to be critical of them because I'm not sure it's possible to do it better.
That's true.
Gotcha.
But in
That makes
using
sense.
All of those, he did
And I
not-
give him a lot of credit for at least making the
He did
effort, because
those
no one else is even making the effort.
You go to the deposition that was taken on November 19th on, it's basically page 101 through 104, where it's kind of lengthy.
To be fair, I like it when it gets a little bit
Okay.
lengthy.
I want to turn to the residual effects that we've been talking about. And then on page 104, so the artifacts, when I usually look for them, and let me preface my answer by saying I didn't find a whole lot of artifacts. I guess I was surprised. And I think, partly, I think during the deposition, why I wanted to interview, and that's when he talked about that. He said, here's the problem with Reeves, and I can tell you, see, he knows all of these things. And I mean, if he wanted to fake it, he's aware of tunnel vision, he's aware of auditory exclusion, he's aware of, I can't pronounce those, vast oscillation and vast constriction. So he basically said, I didn't see any of it. He never either in the law enforcement interview or at the previous community or anywhere did he say anything that would suggest that he had tunnel vision, narrowing reaction. So
Why do I have a feeling that this testimony is going to just not be that big of a deal?
Reeves looked at everything and said, I don't see anything except for the fragmented memory. And so it's not relevant.
And I don't know if this prosecutor misspoke or not, but when he quoted the deposition, he said that what Dr. Bernard told him was, I don't see a whole lot of artifacts. In other words, he's not saying I didn't see any that was presented to the court. And frankly, if he's going by that interview, well, we know about the interview by now. It wasn't the greatest interview in the world. Probably Dr. Bernard, if he's asked, will tell you that when an officer is involved in a shooting, usually they wait a day because of these issues. So, I don't see where the prosecutor's coming from in terms of not being able to at least
All right,
stress.
from what I'm hearing, I'm gonna overrule as to the artifacts of stress.
Good.
So what the prosecutor is worried about here is that Reeves knows what to say. That would indicate stress, and he may fake it.
What I've been marching up and down.
Which is ludicrous because your knowledge of something doesn't that goes to just general credibility. And that's a determination the jury has to make.
And we're going to have the testimony from Dr. Bernard indicating that as a law enforcement instructor, he's aware of how law enforcement is taught. He's aware of the teaching tool known as a force matrix model or force continuum. And I know that might be a foreign concept to you, so may I approach and I'll show counsel what I'm going to handle.
Actually, please stay away from me. I'm issuing a restraining order. You must remain 40 feet away at all times.
Approach.
Oh my gosh, this argument over the testimony is brutal. This should have all been done a long time ago.
Judge, there was a time when
Yeah, it was 2014.
prevalent in the agency's policy. I've had this discussion with Mr. Bernard, so I'm kind of parroting what he told me to. It's no longer in the basic recruit manual as of 2007, I believe is what it said. But they were used as a teaching aid. The court recalls that since 1989, law enforcement's use of force has been governed under the Fourth Amendment, under constitutional law. And so someone came up with an idea of how we're going to try to explain these concepts to law enforcement. Now we use simulators, we do a lot of other things. But
Simulators.
This is what came out. So what he has done since when he teaches civilians to help them understand certain parameters to give guidance, drawing the line in the sand, when you're going to shoot or not shoot, he uses these models as an example. Look, if A happens, you can respond this way. And you might be in pretty good shape. If B happens, you can respond this way. You'll probably be in pretty good. It's just a tool visually to help understand so people in their own minds can draw the line in the sand when they are or not going to use a particular type of force.
Okay.
It is not appropriate to use it to educate the jury. And the reason for that is the way he explains it is that
So this would be relevant knowledge not commonly known to a jury, and you can't share that with the jury either.
Go straight across or up or down, whatever, and if you do A and B, that's reasonable. That's what he's going to tell the jury. And that is not.
He just doesn't want him to
And you're
testify.
following my
They don't want
discussion,
anyone to
in
testify.
pleading, we talked about even in
There might be evidence that'll destroy their case.
objective reasonableness is you can't decide it in a mechanical way, and that's exactly what this attempts to do. And you can understand why agencies would do it. All right, they want to hold accountability somewhere for the officers or whatever, but that's not the court of law. Our jury instruction will be given 3.6 per NF. You're going to give that to them, and in no way does that concept apply. It's a reasonable man standard. You just don't go, put.
No, but he's conflating two different concepts. You can use deadly defensive force to prevent a threat of death or serious bodily injury. That's the legal standard. The jury doesn't get to decide whether or not that's the legal standard. They might decide the threat was not one of death or serious bodily injury, and that's fine.
Right.
But if it was a threat of death or serious bodily injury, it's not questionable that it's reasonable to use deadly force. The law says it is.
Just like we've had some things come up that we didn't want. I have no idea. So I need to bring this to the court's attention that I object to any explanation whatsoever as to what's reasonable. How do you determine what is something reasonable? He can go, look, these are factors for threat assessment. This is factors.
If someone's trying to kill you, it's reasonable as a matter of law to use deadly defensive force to prevent that.
But we don't pigeonhole it with this force matrix.
What may be subject to question is whether or not the threat you were facing was one likely to kill or maim you.
Mr. Reeves isn't a police
The other argument here is that the continuum of force or force matrix that he's talking about is part of police training, which Curtis Reeves would have police training on a continuum or use of force, which would change his present sense impression of what is reasonable, of what is an actual threat.
And it is a reasonable model for understanding the element of proportionality in the non-police context too.
To that as being how he explains
It's not just an administrative training mechanism.
how to respond to a certain
Yeah, the reason it exists is because it's determined to be an effective model of the thing.
Of the law, of the underlying legal principle.
I assume about
Felipe
the
Mouve, I am
subjectivity of
having
it,
a
and of
stroke.
course, the one that can answer the question would be Reeves. I'm aware of what Reeves said, so taking Reeves as true, I would be able to comment on the subjectivity of it and put those behaviors of Mr. Olson in categories of threat and show the straight line appropriate response. And that would be going back to the objectivity and hindsight. See what he wants to do? That is totally inappropriate. So I object to that.
Well, that's not what I want to do. Frankly, in terms of that portion of use of force from Dr. Bernard, it's going to be very similar to what the state elicited in the Draca trial. It's going to look a lot like that. There he drew what was essentially a force continuum on a piece of paper. He's going to probably do it on the whiteboard here. He didn't make any comments as to whether it was appropriate or not.
The short prosecutor here was one of the prosecutors in the Draca trial.
Curtis Reeves.
Yeah, he just got called out.
Former police officer who was trained, so I think it's important that the jury understands his training in terms of talking about the Fourth Amendment or objective reasonableness or something. Those issues are not coming up. He's not here to tell the jury that's objectively reasonable under the standard for law enforcement. He's not going to say that it's subjectively reasonable for Mr. Reeves because of his training in law enforcement. That's not going to happen. He wants to be able to explain, number one, that there's certain categories of use of force, and number two, that there's certain.
That would be deadly force and non-deadly force, the element of proportionality.
So tell that Mr. Rosenwasser address that Draca issue.
The only reason that we brought, I mean, obviously I prosecuted the Branca case. So the only reason we brought it up was in the defendant's interview, he was using those terms. He was the one, meaning Draper used the terms force continuum and force multiplier. So Dr. Bedard was brought in just to explain those terms so the jury understood.
Oh, that's right. And Dr. Bedard was the state's expert in Draca.
The chart that was drawn was only because that's what the defendant was
This is a
referring
great,
to. Now, in this case,
good for the gander, not good for the goose.
and the chart really wouldn't apply because if you're a police officer, you can one up level to get compliance from someone, but a citizen can't do that. That's more law enforcement, which is then when you get the bleeding that Mr. Martin's been talking about, that we can't put Mr. Reeves in the position of a law enforcement officer that can, because law enforcement officer can draw someone down at gunpoint. Now, obviously, if a citizen does that, that's an aggravated assault. So you can't mix and match those two things because the defendant's not a police officer in this case. He's just a regular citizen. So
He's not using an apprehending force.
It's to show the jury, get an idea of Mr. Reeves' training.
We're not talking about him putting someone into custody.
Mr. Reeves was never asked. So let's say, using the state's example, let's say the detective questioned Mr. Reeves as to his knowledge of the force continuum. And then he says, yes, I'm aware of the force continuum. So now we get to use the expert because Mr. Reeves used those magic words to show that he either did or didn't know what to use. No, that doesn't make any sense. And I appreciate that the prosecutor is, and it's creative to say that, we're using it just to define these terms, but the court may have seen the testimony of Dr. Bedard or may not have. But frankly, he wasn't just up there to say, no, that's not what force continuum means. He got up there and drew a chart to show exactly what it meant. So it had a dual kind of effect on the jury, I'm sure, but we're doing it strictly for the purpose of educating the jury as to what law enforcement is taught by Dr. Roy Bedard, who is a police trainer.
I think they're taking the wrong angle here, the defense. The element of proportionality applies to civilian use of defensive force.
I mean, I don't disagree.
You need to understand the force continuum so you understand what proportionality means. Force proportional to force.
But that and this issue are completely different.
Well, can't that be brought out on cross?
Yes, of course
As
it can.
opposed to excluding it altogether?
I mean, the reason that I would say not is because it really is, like, we all understand this because this is what we do for a living. I think for a lay person to understand that is going to be very difficult.
Yeah, you normies are just too dumb to get it.
It really would be confusing. They don't understand force continuum.
What does this guy know? He can't even grow to 6 feet.
And what citizens can do. And we don't really need that mixing and matching because he's a civilian in a civilian case.
So if I understand that argument, it's confusing to give the jury information. It's not confusing. It's somehow more enlightening to tell the jury in this vacuum that Mr. Reeves was trained for all these years as a police officer. And although he's not being judged by the standards of a police
Curtis
officer,
Reeves is allegedly going to testify sometime in 2038.
Part of his belief as he was, and I know that the court heard a million times, standing in the shoes and sitting in the seat, but it's true. And so, that's why this is necessary, just to give them a glimpse of the, you can't just say, well, this person was a professional dressage jumper. Well, they may or may not even know what dressage jumper is, and certainly they might not know what it feels like to be on the back of a horse or to get the physical training or anything like that. So
How?
I just don't see
How did that just come up?
The jury about Mr. Reeves.
I've never heard that word in my life.
We're
Kurt
not
dropped it
saying
a few minutes ago.
This means that Mr. Reeves acted. That's for argument. They can argue, and certainly they can cross-examine as the court suggested. This is about gatekeeping. Certainly, he's going to be there for cross-examination. If they have a problem with that, they can go after Dr. Bedard and say, "Hey, what you showed applies to police officers only, doesn't apply to civilians." Let's see how he answers it.
Well, I know it's going to answer because civilians don't have a model. I adapt it and I tell civilians this is what the law is. That's what he's going to say because I've asked him in the depot, and I don't want that in front of the jury. So am I going to ask that question? No. So here's the problem, Judge. We're not saying he can't say, I know behavioral cues. I know reaction time. I know to keep my distance. I know he can say all of those things, but when you say all those factors and then
pigeonhole it in a chart and have him say.
Fury, Nick R., I'm
straight
biased
line
for the
across,
defense
that's where the
entirely
problem is.
due to
That
the
doesn't-
actions of the
I'm not trying to
prosecution in this
prevent him
case.
From saying he doesn't know how to judge whether or not something is a threat based on his training. It's the chart that says if you do this and this, it is okay. That's where I have the problem. That's why the chart doesn't come
The
in.
law says if someone's trying to kill you or cause you serious bodily injury, it is okay to use deadly defensive
All these
force.
behavior cues and how he knows when there's threat and all the things they look for, you just can't put it up there and say linear across, this is okay, because that's for the jury to decide.
And I don't think he says that it's okay in a linear fashion. He says, this is what you're presented with. These
All
are the
right,
decisions.
what's the relevance of the use of force continuum?
Oh my God. Not one of these people read my book.
Part of his training.
And the matrix.
And just a way to explain it in a visual way to the jury that there are different categories of use of force and that there are different levels of use of force. I mean, that's essentially what's being used for.
How is that relevant?
See, there is no.
How is it
national
relevant?
standard
He used a
for
particular
civilians.
level of force.
So.
And a
he is
particular
civilian.
category.
So this is based on Fourth Amendment considerations, and to, contrary to what Mr. Michael says, clearly
No,
he
it's-
said, Mr. Olson, I would be able to put Mr. Olson. in
This force
category
continuum is
of
taught to
threat,
civilians thousands of
level
times a day,
threat,
every day of the year.
and show the straight line appropriate response. That is just totally
He's
wrong.
not asking to do, we're not asking him to do that.
I agree, that's not proper.
This is an objection you handled during
So-
examination.
I'm gonna agree with State on that.
So tell me then what he can do. Certainly consider different levels of force.
I knew you were gonna ask that.
Well,
Well,
on them jumping up.
All right,
I've only been able to
so-
say 3 words in 3 weeks here without them jumping up.
There is no level of force that are, quote, standardized for civilians. Therein lies the problem.
Yes, there
What
are.
is- what is
Yes,
unique
there
to
absolutely is.
The law enforcement officers are the cues. How, if you look and saw A, B, and C in a person, posture.
There is a level of threat that has to exist before you're privileged to use deadly force in self-defense.
They can go.
For
with
civilians.
that, that's fine. As for if you're going to take, if you look at say A, B, and C, then maybe you'd be aware and it would heighten your awareness and you would want to be more cautious. That's fine, but to say, okay, based on his training, he got this, and I'll call it archaic because it's not taught anymore.
Folks, I remind you again, you might want to consider the Law of Self-Defense Platinum Protection Program. So you have me on your team if you're in this situation, so you're not getting railroaded like this.
All the behavior cues are consistent.
Because don't assume your defense attorney is going to understand how to argue these issues.
Right, so I'm saying, can I say, are there various categories of use of force? Are there various levels? You won't draw a chart if that's what they don't want him to do. And he'll just say that and we'll go into the cues and all those other things they talk about.
How is that relevant? Because you're gonna go through.
You can learn about that Platinum Protection Program at lawofselfdefense.com/platinum.
Non-aggressive. Okay, non-aggressive, then you can use a pepper spray. See where I'm going? The levels, no, we're getting back to the same thing. We're just orally describing the force matrix. The civilians have no level.
Yes,
It's
they
either
do.
reasonable or it's not reasonable based on their.
That's a
subjective
level.
Perception of what they saw, period.
Of reasonableness of which civilian? A civilian who has no police training or a civilian who is extensively trained in the police department? That's
All
the-
right, so there's gotta be a happy medium here.
No,
I-
I'm sorry.
Go ahead.
As of right now, we don't have really any evidence of his extensive training. The only evidence is in his taped statement. He just says he retired from the police department. There is no evidence, because the defendant hasn't testified, about some extensive amount of training, zero.
Well, Your Honor, I think the court may remember there was a big motion regarding all the certificates and all of Mr. Reeves's achievements. So I think the court is well aware of his extensive training going all the way back to a late
The
60s.
state wants to pretend he doesn't have training as a police officer after he served for what, 27 years, 30 years?
Started the SWAT
SWAT
team.
Sit here right now in this trial, there is no evidence. That's correct.
No, his statement that he started the SWAT team is in evidence.
The evidence didn't come out, or the question of Bedard about what he knows.
Okay, so I'm gonna glaze over that right now.
We're all glazing over. You mean
The
gloss
happy
over.
medium that I'm talking about is I believe that the defense is able to elicit testimony regarding how, police training.
Unbelievable.
But that's about
The police
it.
training argument is the wrong argument, folks.
You can't project that over.
And she wants to solve this not by making an informed decision, but by cutting the baby in half, coming to a compromise.
So is the court all right with me saying, we're going to hear about his extensive training of police forces from United
This so much reminds me of the Potter trial and the Arbery trial, where at the last hours of the trial, a legal decision is not made by a judge and it results in an injustice.
these police forces and various security forces in the field of use of force, right? I can do that. He's going to say yes, right?
Is that to imply that because Curtis Reeves is a police officer, we're Bedard trained him? I mean,
That's silly, but anyway, Judge.
well, right, but I'm saying, what was the point of what you just said?
Because he has he trains police officers.
Well,
Mr. Reeves is a 27-year police veteran. That's going to come out. The court can be assured. If it doesn't come out, then guess what? Now they have something to argue in closing. Why did they put this guy up here? He doesn't have anything to do with it. The same thing I argued in terms of opening. I shouldn't have argued, but I did argue a bit in opening in terms of, the prosecutor's opening statement. So, I mean,
It's funny because I brought it out and then I'm trying not to make it personal, but Mr. Michaels then said that was silly, but he actually agreed that's what the argument was he was making. Bedard does all this training. Curtis Reeves is a police officer. They're trying to overlap the circles that now we know what kind of training Curtis Reeves has. We don't. There's no testimony or evidence at all, other than the fact he's retired.
So I'm thinking the defense has decided not to have Reeves take the stand because he could just take the stand and testify to all this.
we had Dr. Foley in here earlier today giving his opinion over some x-rays that were presented to him. There was no evidence presented prior to this that he had arthritic knees or anything else. That evidence came in because that's an expert's opinion. So I don't see how. So now we're going to exclude. It sounds like
Because he could just say right here, Your Honor, we're going to have the defendant testify about his training. That will be in evidence.
One simply say, what's the typical amount of training a 27-year police veteran would have on the use of force to the expert?
Right. The prosecution is trying to pretend that he doesn't have training as a police officer.
Law enforcement curriculum Reeves received at the Tampa Police Department. That's the first deposition, page 133, lines 18 through 20. Specifically,
But again, it doesn't really matter because this element of proportionality, degrees of force, applies to civilians as well as police.
21 through 25. Bernard acknowledges in the 1970s when Reeves received his law enforcement training, a standard curriculum was only in the developmental stage, and academies were free to develop their own curriculum.
But police have ongoing annual training requirements. So even if when he went to the academy, it would be different than 27 years later. He has 27 years of ongoing training on use of force.
Page 134, lines 15 through 19. In response to not knowing the specific of Reeves' training, he stated if Reeves was an instructor, he would know the material. But again, he doesn't know the curriculum of what that was. He candidly testify, I have no idea. So what he's saying is, okay, I have no
Borowski
idea
would
what he
literally
taught.
bring in
And
crosses
back
and
then,
crucify
it
these
wasn't
people.
Tampa PD, they had their own academies back in the 70s. St. Pete PD and the agencies here, we were at the Botex Center down in Pinellas County. So everyone had their own thing going. They could write whatever they want. So there's no way that Bernard knows exactly what training he received because
Nothing was standardized, not until later on when we finally get FDLE involved and they write the curriculum. He admits he does not know the training, Mr. Reeves.
Which is wonderful for cross-examination, but not a legal reason to exclude this testimony. I have a good faith basis to ask Dr. Bedard, and he has a reason for his testimony. And so the state can certainly cross-examine him about that. And that's kind of where we're at. It's not a reason to exclude him.
By the way, if a judge is ever saying there has to be a happy medium, it is that there's cross-examination.
The good faith basis, frankly, Your Honor, is knowing that my client has served 27 years at Tampa Police Department, that he's had training from the very beginning, that he's trained other officers, that he started the SWAT department, that he has extensive training in the use of force. He's trained men in the use of force. So that's my good faith basis, Your Honor.
If he testified and all that came out, maybe it's a different story.
That's different than good faith basis.
I mean, but there is none. I mean, there's no good faith basis there. His good faith basis is because they know Curtis Reeves and they know his background. That's good faith.
The state elicited his background with their statement. They introduced his statement to the police officer in which he mentioned.
He doesn't know it.
He mentioned his history on the police department.
Certainly simpler than that. He just doesn't know it. There's no foundation.
Back then, when he was doing all that, there was no standard curriculum. Tampa PD could do whatever.
So what are you arguing now?
Huh?
What are you arguing now? That he can't testify at all?
No, he just can't testify to his police training because he doesn't know it.
It went back to that. We were talking about how
The matrix.
and then they said, "Oh, I just want to draw the matrix," and we're like, "No, it's all about the whole concept of the matrix," and that's how we went to. He should be able to testify to the matrix because he is a trained law enforcement officer. And then we segue.
They're asking the wrong question, so they're getting the wrong answers. The right question is, did he have a subjective belief that he was facing a threat of death or serious bodily injury? Was that subjective belief objectively reasonable? The jury makes those calls, but if it was lawful.
That he trains police officers in the subject of use of force. Right? He's not going to draw a matrix. So that's how this whole thing started. I think that he can testify to that.
All right, the matrix is definitely not appropriate, I think. No chart.
It's no less a piece of demonstrative evidence than is the mannequin.
Visualization of the chart.
Yeah, the levels are with the argument that I've got before me.
Florida statute defines two levels as a matter of statutory law, non-deadly force and deadly
In
force,
light of,
and sets different conditions for each.
it appears from prior testimony that Dr.
I guess maybe it's reasonable to say that the force continuum has a greater stratification of levels, right?
Fine. So limit it down to two.
Wasn't applicable. So.
Because I can assure you, at closing, the state will argue that, sure, maybe he had a right to defend himself, but not with a gun.
Interview Mr. Reeves right now. Can you give us a 10-minute recess so that he has that knowledge, Your Honor? Because frankly, I mean, I don't understand the state's argument. I don't understand it.
And again, the use of force matrix is for apprehension of a suspect, detention. That's not what happened here.
Talking about levels and responses and matrix. It doesn't matter.
It's really
Yeah.
just backfiring the defense testimony.
What I'm looking at in this chart is stuff that if this is what Mr. Reeves taught and used every day.
You don't need the stupid chart, but there are statutory levels of force.
However, the relevance is tempered with the fact that he retired 20 years ago plus. So, but the fact that.
Well, if he retired 20 years ago, then he forgot everything
He was trained
that
in
he did
this
every
and
day.
He used this and this is like riding a bike to him, then I don't see the relevance. So.
Then I can ask this, Your Honor. You know, I know, that he trains police agencies, police officers in the use of force, right? That Brian Bedard does.
Mhm.
And part of his training involves something called a force matrix, a force continuum. And he says yes, and then I move on and we talk about other things. Just so later on, should we have the testimony to back that up? Now we can link it up, and at least we had Dr. Bedard say, yes, he teaches that.
We're back to, it doesn't apply to civilians. This is a tool to teach law enforcement.
All right, I got that. That can come out in cross. I'm gonna allow that limited area of questioning regarding the
I'm just-
continuum and the matrix.
Her decision making is inane.
Circumstances.
It's
Completely
simply not
inconsistent.
well structured thinking.
Clearly, that doesn't apply to civilians.
The one
So
most
I'm
frustrating
done. We're done.
category
We're
of a
done.
judge, in my opinion, is
It's been,
inconsistency.
over an hour.
Because how do you develop legal
And,
strategy if you
we're
cannot
getting
have a
nowhere
consistent
fast.
decision maker?
So that's that. All right. Done, right? We're done, that's it?
You told me I was done. I'm not standing up.
What else do you have, Mr. Martin? What other objections?
Yeah.
Objections, I know what his response is going to be, because, yeah, it does, because there's no standard model for civilians, so we use this. So I'm not going to be able to ask that question. I'm not answering that question.
All right,
So that,
then that's fine.
Then you're-
that's his
then good.
his answer.
Okay,
So
okay.
that's not, it's just not helpful.
I think the board's asking if Mr. Martin has any further objections other than the ones we've already spoken about.
Correct. All right, then let's take 10 minutes ourselves quickly, a fast 10 minutes.
Well, Judge, after these rulings, I need some time to
I know.
sit down with Dr. Bedard. I don't want, something to happen that shouldn't happen.
Well, don't sit down, just stand and tell me. How about that? Let's,
Well, you just
get
told
that
a use of force expert he can't come in and
Obviously,
testify
we're not
about the use of
finishing
force.
today,
Like what?
But we're certainly not quitting at 4 o'clock.
Just, can I, on another note, just real quickly introduce the actual pictures that from the thumb drive. Remember I told you I would introduce the thumb drive?
Yes,
And so this is just VD1.
okay. Good enough.
That's an easy one.
That's an easy one.
She's gonna have to put both cigarettes in her mouth at the same time on this break.
Another judge that doesn't like to do the job of being a judge.
Yeah, just don't be a judge then. It's that simple.
That was over an
Design.
hour.
And it's like this half job decision that doesn't make any sense. Obviously, the use of force continuum, though it may not have been codified when he exited the academy in 1970 or whatever, he would operate for 27 years under an understanding of a use of force continuum for police officers, right? Because even in the barbaric times of 1986, a police officer did not respond by just shooting someone who was loitering. They would have to go up and things could escalate all the way up to deadly force. Sure. But they had to escalate. The use of force continuum was a codification of the sort of common practice that police had developed in dealing with people. What is your response? And in those types of curricula, I don't know about this one specifically. I'm talking out of my ass a little bit, but I'm pretty sure I'm right. This type of curriculum is determined by asking and surveying law enforcement officer veterans how they handle particular situations. What is proportional to a fist? What is proportional to a knife? What is proportional to merely resisting a handcuff? What is proportional to someone using a gun? That's how this thing works. And that's how they develop this stuff and then they standardize it. But it's standardizing because that's a prevailing practice that is working out. So to think that this guy doesn't understand the use of force continuum to some degree is nonsense, in my opinion.
And frankly, it doesn't matter. It doesn't matter. The Florida self-defense statute explicitly says you can use force except deadly force under these conditions, but before using deadly force, you have to meet these additional conditions. That's 2 levels of force defined by law, and it doesn't matter whether you know the law. Those are the 2 levels that apply.
Right. But I think what they want to get in is his present sense impression of what is happening as someone who is trained to know that When someone's in the dark and they're coming at you fast, you're in more danger than if someone is 10 feet away from you, just raising their fists in the daylight, right? Like, I don't know that training is particularly required for that, but that's what they want to elicit out of him. They want to get his present sense impression as someone who has seen the result of someone who's been punched in the face repeatedly in the dark, because they've had to go and drive that person to a hospital or administer first aid or watch them die on the floor, whatever it may be. Anyway, yeah, I'm kind of curious if Reeves is going to testify now, because it's the way
It
they're
seems like he's
talking.
not, right? Because if he was, if that was still the intent, I think the defense would have been saying so right there.
Yeah. But I think the defense missed an opportunity, because some of this stuff was elicited in the recorded statement that the state introduced, that they argued at the motion to the dismissal motion after the state rested.
For people asking, can that come out on appeal? There is no appeal here. If the guy's convicted and goes to prison, he's not going to be alive years from now to have an appeal.
Yeah. But that was, they made a big deal out of that statement that the state introduced. Well, that recorded statement, he said that he was retired police. He said that he opened the SWAT team. Like, that was in the statement. That's in evidence. The idea that the person who founded the SWAT team doesn't have some training on the use of force is nonsensical to me. Yeah, anyway. What a waste of an hour of discussion. Okay, here
somebody
we go.
in the comments asked if we ship law self-defense ships books to Canada. We will. I mean, we sell books all over the world. I don't know why, but I'll caution you, the shipping gets expensive. So we don't have a standard order page for that. If you're interested, I would encourage you to contact support@lawofselfdefense.com, and they can let you know what it would cost.
C. Neal says, off topic, but can someone explain how the mayor of DC can call up the National Guard to protect the Capitol from trucks? I thought that was just for governors of a state. I figured that someone in the law squad might know. Well, the mayor of the district is effectively the governor of the district. District of Columbia is not under state law, so they are effectively a sovereign. A sovereign district,
separate jurisdiction.
It's under federal law. So they get a different level of authority. Like you're not subject to the laws of Maryland in DC or Virginia if you're in that part of DC that I think now overlaps Virginia. But yeah, so that's why, long and short. Larry Franchek says, in 1998, 203 ranked men's tennis player Karsten Brach beat Serena Williams 6-1 and Venus 6-2, allegedly after an afternoon of golf and drinking beer. Yes. Back to that discussion. Yeah, it's well, again, and I've talked about this before. Men's tennis and women's tennis are two different sports. They're not comparable at all. When the average serve is 10 to 20 miles an hour faster on the men's sport, they're going to be acing women constantly because their reaction times are not tuned to that, no matter how good they are. Even no matter how physically fit they are, it's about what they're used to hitting.
It's almost impossible to imagine what a really good serve is like when it's coming at you if you haven't experienced that. I had a friend in college who was a college level player, and his serves were frightening.
Yeah, they're I think the top ranked men are serving 130 miles an hour or something like that. It's ludicrous how fast that ball is coming. Gino Fast says, why do they ask experts their hourly rates? Are the attorneys inferring that they are biased? They want the jury to get that impression. But since everyone asks every expert every hourly rate, I think it kind of nullifies out for the most part.
I don't know. A jury doesn't know. They don't see that in their life, right? They're only jurors once, maybe twice.
Well, if there's experts on both sides.
Oh, yeah. Well,
that's what I'm saying.
Although a lot of times the state experts are state employees, so they're not asked.
Oh, yeah, that's true. The other the other issue with the experts is, sometimes they do charge a whole lot if they have some particular specialty or are particularly sought after expert on a thing, and that can raise some eyebrows when you find out that you paid $50,000 or $60,000 for someone's testimony or something crazy.
Yeah, one of the experts in Potter was paid $30,000, right? Was it the slip and capture guy?
Yeah, he was paid quite a bit. Lancelot 652. Oh, and interestingly, of course, it was him that got her. Right? According to the jury, anyway. It was his testimony and his notes. His notes of his interview with her that they found inconsistent statements or something was part of it. So she paid to put herself in prison. Lancelot 652 says, we've spent all day on one expert and arguing back and forth on nothing. This has been a complete catastrophe of a day.
You'd think the shooting happened a week ago, and so they didn't have time to get around to these issues before now.
And I believe that these motions have been sitting there and that the judge just didn't rule on them. Because I don't believe that the defense and the prosecution have been, whatever you think about their arguments or the trial strategy, they're not springing this stuff up. They mentioned the other day that there was outstanding motions that had not been ruled on from pre-trial. These are those. Because it was in regards to the expert testimony. Felipe Mouve says, Nikki, the only thing more boring than these chinless guys is your haircut. Please don't look how much money COP is. Believe me, it is a lot of money. Yes, I know. Thank you. Thank you for the 40,000 pretend things that you sent. Gene Jeffries says, I'm starting to get the impression that the state railroads people more often than not, or at least tries to, going by the cases we've watched with you. Well, the issue with most of the cases, the reason these cases are being watched is because they're not obvious. Or I shouldn't say they're not obvious. Kyle Rittenhouse was obvious, but it had a lot of media hype. But like the Kim Potter case, not obvious. I think it should be, because I think mistake is pretty clear in there. But a lot of people don't feel the same way about mistake, even though it's kind of codified in the law that way. But this case is not obvious. He either acted reasonably or he didn't. This is the quintessential jury case. But most cases are fairly obvious, which is why most of them plea out. They just do. And then a lot of them don't get covered because most defendants end up being guilty. And that's the nature of the system that they have, because the state has to determine that they're pretty sure they can win before they bring charges in the first place.
Usually, unless they're politically motivated.
Right. Yeah. They're supposed to. That's what probable cause, the probable cause standard is that they have a reasonable belief that based on the information that they have, they can convict them of a crime. Gaddison says, I feel like in every case we have watched, the judge has rules against allowing a use of force expert to testify on the use of force. Rittenhouse, Potter, Reeves. What is the point of having one if judges seem to hate allowing them?
Well, they're supposed to be able to talk about some things and not others. They're not supposed to come to fact conclusions in the case. They're not supposed to say that action by the defendant was reasonable. But they can talk about what makes a threat deadly. Is a rock in the hand a deadly force threat? It is, because it can cause death or serious bodily injury in these various mechanisms. That they can talk about. Then the jury has to decide whether or not that rock was being wielded in a way to cause those kinds of injuries. If they decide it was, well, then as a matter of law, it's a deadly force threat against which deadly defensive force is permissible.
Right. And the question of whether a particular rock, even though a rock in the hand can be a deadly force threat, if this particular rock was a deadly force threat, is it in the hand of a child? Is it in the hand of someone incapable of generating enough force to strike with it?
Or is the other party at some distance or whatever? There's variables that come into play that would fall within the expertise of a use of force expert, but not be in the common knowledge of a jury. But a
Right.
lot of defendants in the old days, I have to tell you, 15, 20 years ago, it was not uncommon to have use of force experts come into court and make flat statements that this was reasonable or that was reasonable on the
Sure.
part of the defendant. And,
And that's what
the
they-
courts are just averse to allowing that anymore.
Right, because it's highly prejudicial to the
Sure.
state. And even though I disagree with that term, it is. But well, that was one of Dr. John Black's funny moments in the Rittenhouse pretrial hearing was they were asking about skateboards, and he said, "I could find a way to kill someone with a skateboard," right? Like, he's a use of force expert. But that doesn't necessarily mean that Anthony Huber's use of the skateboard would rise to the level of deadly force, because a lot of people carrying a skateboard are not a deadly force threat to anyone around them at all.
Yeah, I mean, that's a better example than my rock example, because the state there was trying to say, hey, he was unarmed. He was just riding a skateboard, as if a skateboard could not be used as a weapon. And a jury might believe that. So you want to bring a use of force expert to say, no, actually a skateboard has the mass to cause serious bodily injury if it's wielded in a particular way. And then the jury has to decide, well, do they believe it was wielded in that way? That, sure, normally it's a skateboard, but in this manner of use, it was being used as a weapon.
Right. And so that's what they need the use of force expert here. He's supposed to come in and talk about how the hands of a person who's 200 pounds can cause significant injuries very easily, especially to, and also talk about, the type of maybe a use of force situation that an elderly person might want to particularly avoid or might be particularly vulnerable to. But he can't say that Curtis Reeves was particularly vulnerable or that Chad Olson was particularly dangerous. But yeah.
Right. So he could argue here, for example, he ought to be allowed to argue that, hey, a sustained beating with bare fists from someone who's 6'4", 220 pounds and towering over you, that would be reasonably perceived as capable of inflicting serious bodily injury. He can't say that's what was happening. The jury has to decide whether they believe that's what Chad Olson was doing. But the jury might be deceived to think, hey, fists can never be deadly force. That's not true.
The other thing they would want to elicit is if a cell phone, for example, could be used as a deadly weapon. And I mean, you don't think of it that way.
Figure out how to kill somebody with a cell phone.
Well, you don't think of it that way because most people are not reasonably thinking they're going to hit anything because they're like, oh, fuck, I'd have to replace that phone. It's going to cost a whole bunch of money. But when you think about it, I mean, these things are 1.5 pounds. Like they said, it's the same weight as a cue ball. It's made of aluminum and glass. I mean, if I take this thing and cram it into the side of your head a couple times, we're talking serious bodily injury.
Crush the larynx.
All right, are we ready?
Born ready.
Take that as a yes. Okay.
Already just incessantly clicking that pen.
Yeah. And just a reminder to everybody, please, folks, don't get into fights you don't need to get into because you could find yourself here.
You could be in front of Judge Barthel, bungling decisions about whether or not, which will impact whether or not you go home or go to prison forever. Or it's Florida, you could get a death penalty. Is he charged with intentional homicide here, first degree? Or is he charged with manslaughter?
Second degree. It's not. If it was manslaughter, he'd have. If it was a prospective capital case, he'd have to have 12 jurors.
Oh yeah, that's right. That's right.
Please be seated. I'll do the present accounting for Your Honor.
Thank you, Deputy. Ladies and gentlemen.
Eric Funderburg was 9 when this guy got shot.
Thank you for returning.
I'm
We're
joking.
ready to
I'm
begin.
joking, guys.
Thank you, Your Honor. The defense calls Dr. Roy Bedard.
That Friday finish just got pushed to Monday, I believe, in my brain. I mean, the judge didn't say that, but I'm saying that we just took a significant delay.
Please come this way for me. All the way around this way for me, okay?
This guy looks like a Fed.
Do you solemnly swear or affirm that the testimony you shall give in this call shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Now we're gonna have 90 minutes of CV.
This guy looks like Sean Hannity if he did push-ups 18 years ago.
Go ahead, Mr. Michaels.
Please state your name.
Roy Bedard,
Spell your last name, please.
Bedard.
And what is your current profession?
I am a law enforcement trainer.
And how long have you been a law enforcement trainer?
Oh, I think 35 years.
We're going to get into that a little bit more. Let's go over your education. I called you doctor, so you have a PhD?
I do.
And where's that from?
It is from Florida State University.
And what is your PhD in?
Educational psychology. My major is sports psychology.
And what was your dissertation?
It was on decision-making under pressure specific to law enforcement officers.
Now, you have a bachelor's degree from where?
Also Florida State University.
Okay. And I see an MSc degree.
My master's is also from Florida State University.
And what's your master's in?
Also in educational psychology.
Okay, now you listed on your CV something called Lively Law Enforcement Academy. What's Lively Law Enforcement Academy?
So it doesn't exist anymore. When I went to the police academy, it was run by a vocational school called Lively. And the law enforcement academy was one of the divisions.
I'll be right back.
And curriculum of that vocational school.
Okay, so let's talk about police academy. So were you a police officer?
Yes.
Tell me about your history as a police officer.
I began as a police officer in 1987. I worked for the Florida State University Police Department. I moved to the Tallahassee Police Department in 1990 and continued in full-time service until 1996. I went into the reserve status in 1996 and continued with the Tallahassee Police Department until 2015. I retired from the agency, and then in 2019, I believe, I became an administrative reserve for the Tallahassee Community College Police Department.
Okay. And so you're still active in that particular role?
Yes.
Now let's talk about this Lively Law Enforcement Academy. There were certain affiliations you had with that academy. For instance, I see one that says CJSTC. What does that mean?
So in the state of Florida, the Florida Department of Law Enforcement commissions a group of commissioners to govern criminal justice. So the CJSTC is the Criminal Justice Standards and Training Commission that writes curriculum and otherwise interacts with basic level students as well as agencies for in-service requirements. So they sort of oversee law enforcement. They also issue the standards by which law enforcement officers are permitted to be employed.
And when you say curriculum, are you talking about manuals, books, that sort of thing?
Yes.
And you were an instructor?
Yes.
Okay, so at the Lively Law Enforcement Academy, you were instructor?
I'm in charge, but muted. Indeed. I don't know if this guy, I saw a comment suggesting this guy might have gone to the FBI National Academy. That's
as a firearms instructor.
It's kind of a academy the FBI runs for senior law enforcement around the country. I've lectured there several times. It's, but I'm not sure this guy was ever senior enough in a police agency to, frankly, qualify for a National Academy slot.
About the Florida Criminal Justice Executive Institute. What's that?
The Florida Criminal Justice Executive Institute is also run by FDLE, and it is a executive institute that mostly does advanced and specialized training to administrations.
I miss any objections?
Law enforcement.
No.
Okay. And were you an instructor there?
Yes.
And so one of the things you instructed, I see elder abuse investigation. Tell me about that.
That actually was a class that I took from that. I did not teach that one. It was precisely as the title says. It was about investigating elder abuse.
You ever investigate an elderly person beat up in a movie theater?
Now, you currently, in addition to being consultant, do you own a marketing business as well?
I do.
Tell me about that.
I have a company that is called Rapid Rotation Baton. It has a flagship product that is a police baton with a specialized holster. I also make other types of equipment, including handcuffs and other holsters and belt systems and things like that that police officers.
Are any of them made of leather, lined with fur?
Wear. The corporation is a DBA, RRB Systems International, which is the DBA for Rapid Rotation Baton, which is what I mostly consult under.
Okay, now, you're a consultant, so prosecutor always likes to ask, so let me ask you, are you getting paid for your time here by the defense?
Yes,
And how much are you getting paid per hour?
$300.
Okay, and let me ask you this, we're going to get there, but you testified as an expert for the state of Florida, right?
I have.
Not too long ago.
That's true.
This same very office.
Yes,
In fact, one of the prosecutors that's here was involved in that case.
correct.
And did you charge the state of Florida for your services?
I did.
And what was your fee?
Same fee.
Now, let me look at
Was
some
that
of your
Dreshka?
other experience. I see 2005 to present, Lazarus Mining LLC. Tell me about that.
This was a mining corporation. I was hired to provide consultation and actually boots on the ground services for in terms of their security. It was actually in not the city of, but the country of Colombia. It was a alluvial mining operation.
And so they requested your expertise
Yes.
in what, training, security? Tell me what you did there.
Actually involved in setting up a security system, which did involve training as well as various security analysis of that particular area.
And was that to protect the assets as well as the individuals? working there?
Exactly.
Now, you have a title in your CV called Achievements and Titles. So when I see subject matter expert in instructor techniques assigned to reviewing and updating state general instructor training curriculum for FDLE, what does that mean?
So the Florida Department of Law Enforcement Criminal Justice Standards and Training Commission assembles a group of subject matter experts from throughout the state of Florida who sit together and design curriculum. At times they update curriculum, and it's an ongoing process, a work in progress. And I am one of the identified subject matter experts for the state of Florida for developing police and corrections curriculum.
Okay, and so that's general instructor training. What about this? I see same FDLE subject matter expert assigned to updating state defense tactics curriculum and state instructor defensive tactics. Same sort of thing, helping?
It is. There's been many iterations. I've been doing this since the 90s. And so as the state.
This didn't exist
either
in the
updates
90s.
Or sometimes completely tears down and redesigns courses.
By the way, that was
I'm often called
kind of a core argument of the state just a little bit
assistance
ago,
with those
that this
projects.
didn't
And it
exist
looks
back
like
then
those
when
were
he
from
was
2014,
still a law enforcement officer.
2013. You have several more instances where you were tasked with aiding Florida Department of Law Enforcement in creating and updating curriculum. Is that correct?
That is correct.
I see one from 1999 to 2003, FDLE, again, Florida Department of Law Enforcement, subject matter expert in defense tactics. So again, you were assigned to drafting state defensive tactics curriculum and state instructor curriculum. Similar sort of thing?
Yes, that was under what we call a CMS curriculum maintenance system that was used back in the late 90s and early 2000s.
And part of your consultation career has not only to do with being a consultant for litigants in court, whether it be an accused in a criminal trial or the prosecution in a criminal trial or civil litigants. In addition to that, you also did some instruction and consultation and presentation internationally. Is that fair to say?
Yes.
And I see you've listed, there are several listed on your CV here. Internationally, I see 2019 Dubai Police Department in the United Arab Emirates, non-lethal technology for law enforcement. You're a presenter.
Yes.
Now, how do you end up in the United Arab Emirates?
I work with particular equipment, and oftentimes if there's an order on that equipment, for example, with that one, it was the pepper ball system. I wrote that training manual. So I went and presented it to them in a course that involved field applications.
And I see you presented in Spain, Poland, the Virgin Islands, Israel, Colombia, Madrid, Brazil, Germany, and Scotland. Also, Jamaica, St. Martin, and England. So you've been around the world.
Anywhere there's a
and
beach,
united
really.
In terms of sharing your expertise and training people.
I have.
Now, you also trained here nationally as well, right?
Yes.
Locally and nationally. So let's look at some of these. 2018 Allied Universal Security Services. You were the curriculum writer for Use of Force and Defensive Tactics program for the largest private security provider in North America.
That's correct.
Tell me about that.
So there's a large corporation that employs many different security officers throughout the United States and abroad. And their Use of Force and Defensive Tactics program, I was commissioned to write that for them.
Okay, and in your notes here, you have between 150,000 employees and over 20,000 psychs.
Yes.
You've also been a lecturer at the FBI National Academy graduate meeting, right?
Yes.
Daytona Beach. There you lectured on Stand Your Ground.
That's correct.
You
Oh,
also
Daytona
did
Beach.
a Florida High Liability Police
That's not the real gig. The real gig's at
Quantico.
Quantico.
Florida Public Safety Institute. What's the Florida Public Safety Institute?
They flew me to Quantico.
Organization that is now at the Pat Thomas Law Enforcement Academy in that same location in the city of Tallahassee. And the Florida Public Safety Institute is providing services to law enforcement agencies throughout the state of Florida, as well as other states that may come do training in that area.
Okay. You've also presented to the Florida High Liability Police Trainers Conference, investigating Stand Your Ground, a presenter there as well.
Yes.
Now I see Florida Public Safety Institute. That's up in North Florida.
Yes, that was the one we just talked about. That is there in Tallahassee. It's actually in a city called Havana, but it's just at the outskirts of Tallahassee.
And I think up there, because I went to school there, they call it Havana.
That may be so.
Now that says lead instructor, FDLE, CGSTC, Defensive Tactics Instructor course. What's that?
To be a defensive tactics instructor in the state of Florida, you have to go through a course called the Florida Defensive Tactics Instructor course. Now,
For the person in the comments, I was at the FBI Academy at Quantico. I believe that's on the that's on the Marine base. I wasn't at the headquarters downtown.
Many different occasions.
You also educate, for instance, the Public Defender's Office.
Yes.
At least I had to go through Marine security to get to the academy, so I
Fort
presume
Myers
it's on the
Self-Defense
base.
and Combat Stress.
Correct.
You also spoke to these lawyers in 2012 in Naples, Florida Public Defender's Office. You were presenter for the Self-Defense, Defense, Stand Your Ground, and Castle Doctrine.
Yes.
These are all pages of when you presented and some of the instruction you provided. So I'm just looking through them. We went through the fact that it was international as well as national. So it was not only in Florida, you also have conferences in St. Louis, for instance, all throughout the U.S.
That is correct.
I see something that says karate competition resume. So tell me, were you involved in the martial arts?
I was for most of my life, still am.
Okay. Tell us about your competitive career in the martial arts.
My competitive career, when I was 18, I
kicked Chuck Norris's ass. Yeah.
And
Took Bruce Lee to the prom.
Throughout various parts of the world, competing in various competitions. And I think I have those listed as well.
And in this case, you also, I should say on your CV, you've also listed some publications and productions that you've been involved in. Publications, you mentioned your dissertation already. I'm looking at one that says Florida Criminal Justice Standards and Training Commission. That's that FCJSTC we've been looking at, right?
That's correct.
And it says instructor curriculum, defensive tactics, use of force, and survival stress. Tell me about that. What'd you do there?
Again, this is the curriculum that every police officer in the state of Florida and correctional officer has to go through to be able to get their police standards. So I was on the subject matter expert team in writing that curriculum.
Okay. Now you've helped write the training manual for ground defense for FDLE.
Yes, you're talking about the ground fight course?
Yes.
Yes, that was a corporate course. I have presented it throughout the United States.
Okay. Now you have been qualified previously, have you not, in the field of use of force?
Yes.
defense tactics,
Yes,
human factors,
yes,
okay, among others, right?
yes,
And have you testified in state and federal court?
I have.
And both for both sides?
Yes,
Now, let's talk about use of force. Use of force is something that you train police officers on.
yes,
Both police officers that have experienced police officers.
yes.
Do you also train, for instance, I don't know if rookies is the right word. What do you call it when you're recruits?
Cadets?
Recruits, yes.
And in fact, right now, did you come here breaking away from some training you were providing somewhere else?
Yes, in Seminole County.
And so what were you doing there?
I'm teaching actually a legal course to what we call a crossover class. These are officers that are currently in corrections, but are crossing over to get their license for law enforcement.
Now,
He's
let's
teaching them
talk
how to
first
misinterpret
about
the
this,
Fourth Amendment. Good
the
man.
Subject of use of force. Can you give me a three-word definition for use of force?
A three-word definition for use of force.
Yes.
Oh, I don't know about that, how complete it will be. It is the philosophical underpinnings of force I used for.
Okay. Maybe it's a clumsy. Is it response to threat?
It is response to threat, yes.
All right. Now let's talk about. You've already established that that's something that you teach.
Finally, are we getting to something substantive?
These agencies, you teach civilians as well.
Yes.
Is the training the exact same? Oh, just ask. Just do it. Just
Now,
do
that
it.
Use of force. Does it always involve the firearm?
No,
Okay. So could it be something other than a firearm?
it can. There are a lot of different tools that can be used by individuals to defend themselves.
Okay. So it could be
What might some of those be?
Yes,
of some sort other than a firearm
yes,
or some other object,
yes,
and it may be even a fist.
yes.
Now, let's talk about.
But it may also be a
use of force.
firearm,
So
right?
There's use of force. There's a kind of a threat assessment involved in the use of force. Is that true, or do I have that wrong?
No, you're correct.
So tell me what that means, without going into any sort of model or explanation, aside from what does threat assessment mean?
Threat assessment occurs with individuals who are situationally aware anytime.
My mind is kind of on the motorcycle.
In any given location.
I was wondering if you were going to see that.
For danger. It's a natural human instinct to constantly monitor for danger. And if something happens in an environment in which a danger signal is noted by an individual, they will begin the threat assessment to determine what level of threat that would be. And it would offer
Your Honor, I am
variety of different
It's coming.
cognitive features, in fact, even some physiological features. If the challenge perhaps turns
Did you
into
say a 6'4" man is a threat?
And without commenting on what a proper response may or may not be, when you say certain cognitive, would you use cognitive?
Yeah, some cognitive features. I mean, things.
Tell me about some of those cognitive features.
Well, for example, strategy. Like if you feel that there's a threat in the environment, what is the strategic best thing to do at that particular moment? That is a rational determination of what is my appropriate response to the threat that I happen to perceive or the challenge that I happen to perceive. And those are different things, challenge and threat. If you, for example, are very close to someone who you think is a threat, a positive cognitive reaction would be to create more distance, for example, or it may be to raise your hands up to protect the vital areas of your body, including your head, your throat, accordingly. So those are features that are taught, they're learned. In some cases, they may even be slightly instinctual. I think we do draw these things from our instincts, and then we codify them in coursework.
And you said certain physiological features?
There are a lot of physiological features as a challenge evolves to a threat. And the basic distinction is when you have a challenge, the assumption is you have the proper coping mechanisms for dealing with it. And those coping mechanisms may be environmental, they may be weapons oriented, they may be the way you talk to somebody, perhaps in a form of what's known as de-escalation. But when those features are overcome and the challenge evolves to where you no longer have the coping mechanisms. For example, the attack has started and you're not able to avoid the attack, to run from it, to perhaps even fight it, because maybe there's differences in size or difference in the availability of weapons or things like that, then that challenge becomes a threat. And when the threat occurs, there are physiological features that start to happen as part of our natural system for self-protection.
And so before we get there, let me go back so I can understand how it progresses. The situation progresses from situational awareness, which means, correct me if I'm wrong, that kind of what it sounds like, you're aware of where you're at, your surroundings.
Right, that's correct.
And somehow just being there with another individual or some other
being there
something
together
else
in that
environment
space
that could cause a threat.
That would be your threat assessment. When you identify a threat, of course, we are very visual creatures. Most of the information we gather from the environment comes from our vision. So as we're situationally aware, we're paying attention to different things in the environment that may be harmful to us. If we start to attend to a particular thing and identify it as a threat, then we go into threat assessment. For example,
how do we identify something as a threat with our situational awareness? What are some of the cues? What are some of the things that we should look for?
well, sights and sounds for sure. I mean, for example, if you step out into the street and you hear the rev of a motor, your threat assessment would perhaps be to get out of the street. So you can hear certain features in the environment, you can see certain features in the environment that would dictate
shove
to you
more
that there is
food
an
into my
appropriate
face.
response to
What
try
about
to
SWAT,
avoid
spider sense?
danger? For example, moving close to something. When a rattlesnake shakes its tail, it's usually
Would you
good
determine a
advice to step
6'4" man to
back
be a
away from
Prius
that. So
or a
that would be
revving
a threat
Bugatti?
assessment, and it would be a reaction to that threat by trying to minimize the chance of harm.
Okay. And when you talk about a physiological aspect, the physiological aspect of this threat assessment, tell me what you mean by that.
I think a lot of times when you teach use of force and defensive tactics, there's a tendency to think that everything is rational, everything is cognitive, and we're capable of thinking about things as if we were sitting at a desk, perhaps learning about it. But in the real world, to use a cliche,
As Mike Tyson says, everyone's got a
there are other
plan
things
until
that
they get
are
punched in the
happening. There are things
face.
that are happening physiologically, chemical and electrical.
I like
signals
Jeep
that are
Gunman here in the
reacting
chat.
to
Feel
your
the
environment
heat
as well,
of the
things
engine from a
that you
Kia
don't have
Soul.
control over, often referred to as fight-flight syndrome. This syndrome changes the way you perceive things. It changes your abilities, your competencies. It can shunt blood from one part of your body to another part of your body, changes the way you see. It can generate things like tunnel vision. It can even turn off your ears, something we call auditory exclusion.
And those are kind of artifacts of stress. And I'm going to talk to you a little bit when we talk to human factors, but those are the kind of things that we're talking about. And as I'm talking to you, I can understand that threat assessment kind of boils over into a risk assessment. They go hand in hand. Do I have that right?
They do. So once you identify your threat and you start to make cognitive features about that, then you have to do a risk assessment to determine what your best course of action will be.
Okay. Now, when you're identifying a threat, you talked about environment. So for instance, do you train that, and it almost sounds like, we should know this, but certainly, do you train regarding the light available to assess what is a threat now?
Yes, again, being visual creatures like we are, light is critically important to being able to make an accurate determination of what a threat is.
And so when you say an accurate determination of what a threat is, does that mean, at least at this level, trying to determine what the appropriate response is?
Yes.
I saw someone in the chat
Now,
say,
so when we're
so
talking
the
about
defendant
light
might not have perceived the situation correctly.
you
Right.
said it because we're visual.
That's permitted.
Tell me about that. Why
Yeah, the question is not whether their assessment was accurate, but rather whether it was reasonable under the circumstances.
presents more
Being
of a
wrong can still be
threat.
reasonable.
If there's another individual that now is becoming a threat, how does that cause that to be more of an acute threat or more of a threat?
Well, at the most extreme with light conditions, if you can't see it, certainly it doesn't figure into your threat assessment. So if it's incredibly dark, for example, you may not see something that is very harmful, and you may not know to do anything about it. As the light improves, you may still have an impoverished view. You may not be able to see things clearly.
Don't call me
But for
impoverished, you
example,
bigot.
somebody who uses a training firearm, it could be painted blue. You wouldn't be able to tell if you were, for example, a police officer pulling up on two people playing with blue firearms, whether or not they were actual firearms or not, because the blue color is only available to you when it's light outside. So as light starts to improve, so too does our acuity, our ability to actually determine what something is, what it means, and it will figure into our risk assessment, our threat assessment appropriately. We do have what are known as mistake of fact. These mistakes are usually when we either don't have enough time to see something or we're seeing something in an impoverished way. We don't have a full picture of it.
And that doesn't mean the person was wrong in what they were thinking, right?
No.
And let me ask you this. So we talked about dark, pitch black. That's an easy one. You can't see it. It's more of a dangerous situation to use a layman's
That is
term.
correct.
As it gets a little more, as there becomes more light in the environment, if it's dim light, does that still affect one's ability to perceive danger and to properly assess the threat? Or to assess the threat?
It can. I mean, obviously in police work, we have tools to make adjustments, for example, flashlights. But of course, that's not always the case when you're dealing with, for example, a civilian set who may not run around with a flashlight. So we try to mitigate the problem as best that we can.
So here you go.
But
Here he's
anytime you
testifying
don't have a
to
complete
something that
visual
could
picture
be a
of
fact
something,
of the
it
case
could be
if
said that
the
you don't
jury
fully
believes
understand
it.
Okay, so a police officer has a flashlight. Are they taught, well, if you're not sure, if you can't really see or it's dim, go ahead and light them up if you can?
Yes.
Now, you talked about the idea of, using your senses to do this kind of risk assessment. What about hearing? How does that affect your ability to assess the threat or to perceive a threat?
Well, hearing is interesting because it's probably earliest of our evolutionary features. We tend to hear things oftentimes before we see them. We can hear things at great distances and usually only see things as they get much closer to us. So our hearing tends to be a little bit more acute, especially when you're dealing with things like reaction time. There's been many studies that show that reaction time is faster when it's auditory.
Approach. And Dr. Bedard, could you slow down just a little
I'm
bit?
sorry.
You're probably killing the court reporter.
Well, she'll determine I'm a threat and kill me back if she took my course on how to kill threats. Real quick, Church of Failure says, as Richards, Your Honor, Matt comes home from a long day of changing slides for the defense and then has to spend all night, how do you say, pleasing Jack Murphy's wife while Jack watches? It's not fair, Your Honor.
Matt, we were talking about how the sense of hearing could affect the perception reaction time. And so I don't want to know what studies said. I know that you have a great deal of experience in this field, that you have a great deal of education in this field, that you educate others in this field. So tell me from your knowledge, how does that affect perception reaction time?
Well, of course, word choice matters. If you can't hear proper word choice, you might not understand a threat in the way that it was intended. There's tone, there's inflection, there's loudness that has to do a lot of times with threat assessment. It's often said that in threat assessment that all creatures will, when threatened, become bigger, they'll get louder, and they will turn colors.
Nipple rub.
Humans are no different. We tend to do that. We pull our shoulders back, we start to holler, and we
I doubt it.
turn red. So those threat assessments are part and parcel of the risk assessment. What do I do now? And so when you have somebody who's standing in the dark, for example, and perhaps there is some type of a problem with your ability to hear what they're saying, you can't fully understand the threat. And oftentimes these, what we refer to as dymatic threats, where somebody's hollering at
If
you,
you
for example,
perceive a
doesn't really hurt you,
threat,
but
is it a good
speaks
idea to
volumes
say,
about
take your
what
swing?
perhaps is coming next? And if you can't focus on those dymatic threats because you simply can't hear them, you will not be able to make an appropriate evaluation of what that threat is.
And what we're talking about now, up to now, that's something you teach. Is that something you teach in police academies?
Yes.
And is that something you instruct civilians on?
Yes.
Now, you talked about the auditory and the visual. When we talked about environment, because you said the first step is environment. And so environment obviously includes the senses that we're talking about. And does it also include the place that this takes place? And what I'm getting at is this. Is it part of threat assessment to take as a cue of a threat or a potential threat behavior that would be out of the ordinary in a certain situation or environment? For instance, if somebody came down the aisle, sat in the front row of court and jumped up and started yelling, would that start your threat assessment of that individual?
Yes.
Why is that?
Because everything has a baseline. So, for example, if you walked into a church and somebody was jumping around and acting differently than the rest of the otherwise quiet church members, that would be a violation of the baseline. You would attend to that and try to figure out what that meant. To the contrary, if you walked into a club and everybody was really quiet, you would wonder what was going on.
What about a
under
theater?
that circumstance? So
A stage
baselines
theater,
are
not a
contextual.
movie theater.
And when you're dealing with the context of an environment, you're mindful of those baselines. And what calls your attention normally to things as part of your threat assessment is that something is out of the baseline.
Now, we talked about environment, so let's, that's kind of bigger macro. Let's micro it a little bit. Does it matter one's proximity to a threat?
Yes.
Okay, and tell me why that's important. How close you are.
Proximity, in terms of the angles that you stand at, for example, affording yourself an escape route, those are proximate.
What if you're stuck in a
decisions that have
theater
to be
seat,
made as part of your threat
reclined?
assessment. But also the nature of how close you are to somebody, which is, I think, how you concluded your question to me, will matter because of reaction time.
And so do you look at kind of nonverbal cues to make that threat assessment?
Verbal and nonverbal, yes.
This is what I'm getting at. I see a lot of police reports and the police officer will say, well, he was blading.
By the way, I had backtracked a little bit, and
Blading is,
the judge had
sort of a
said that
pugilistic
they're
or
going to
fighting
continue
posture
with
that
Bedard
somebody might
tomorrow.
take by
So
placing one leg
maybe she's
back
planning on
and
stopping at a
leaning the
reasonable
other leg
hour.
a little bit closer to you.
Yeah, probably in
This
about
is
15
typically
minutes.
done
That would be
Yes.
sweet.
as a preparatory stance, and it also is to minimize target area.
Okay. And so that would be a threat, even though there have been no blows thrown.
Yes, that would be what we would call a pre-fight cue.
Okay. Now, what other cues are we looking for in that
Oh, I got a
environment? So we
personal
have
message from
close
Odyssey.
proximity, we
Yeah?
have
I know it's personal because they tell me they're loving my segments with Nick.
lighted. We have some sort of
How about that?
auditory,
Very cool.
interference.
Is it from Thomas? Thomas is cool. He's a good dude.
It's by Odyssey herself.
I can approach.
If she
She's
doesn't know
become
I'm married.
aware.
I could say that if this, that, and
Well,
that.
I uploaded all that
That's the
content.
question.
All right, I'm going to overrule.
All right.
No objection.
It seems that I screwed up the sync
Those,
process, so they're going to fix it on my
cues,
behalf. Very nice of them.
Are they cumulative? In other words, the more you have, does it add up to make the situation more of a threat?
Yeah, we would call it the totality of the circumstances, and they are cumulative. When you start adding them together, they're more meaningful than when you take them individually.
So tell me, when you say totality of circumstances, I kind of know what it means. Tell me what it means in the context of what you instruct.
I kind of know what it
police
means. You're a
officers,
defense attorney. It's
soon-to-be
literally where
police
you
officers
live.
and civilians. What do you mean by totality of the circumstances as it relates to this idea of threat assessment?
So it encompasses everything that you've talked about so far. What is your environment? For example, it's not a good idea to fight on a slippery floor or perhaps a gravelly floor. You want to have better traction, so you'd want to take note of that. If you're about to engage somebody, it has to do with the lighting conditions, whether or not you're capable of seeing. If you have a tool to your avail, for example, a flashlight, you would probably use that. If you don't, you may choose that this is not the best time to go down that dark alley. There are circumstances about vision. As I said, there may be a case of where an individual is partially hidden and you can't quite see what they're doing. And so that would figure into your threat assessment as well. And then there are also individual features, what we call subject factors, like, for example, how old are you and how capable of you are fighting? Are you bigger than the person? Do you have martial arts experience? Do you have a weapon on you? All of those kind of things would be taken into account when you're trying to examine whether or not this is merely a challenge for which you have the appropriate coping mechanisms, or it is a threat for which your coping mechanisms are now exceeded.
And when you say that, these things are this is part of the totality of the circumstances. In other words, that applies to able-bodied people as well as people that are invalids.
Yes, they're just in a different place in their evaluation. I mean, depending on what, as I said, your individual features are, you would perceive things very differently. You could have two people standing shoulder to shoulder viewing the exact same thing and would assess that threat very differently.
And that's sort of on the risk assessment side that we're going to get to. Would you agree with me?
Yes.
They're definitely related, but it's more properly in that section.
Yes.
All right. Now, one of the things that's interesting that you talked about, well, if you're capable, if you know martial arts, now, I know that you do. And so I know that I don't. And so if you got close to me and I perceive you as a threat, I would be very threatened. You not knowing me or whether I knew martial arts, you know martial arts, so you probably think you can handle yourself. What I'm asking you now is, if there's an individual that you don't know anything about them, how does that factor into this threat assessment? In other words, all these things we talked about, darkness, out of place behavior, close proximity. So if you don't know anything about this person, does that make this person less of a threat, more of a threat, or still a threat because of the totality?
I think more of a threat. I think, if the attack is on, now we're talking about threat assessment.
You have to assume that they know
an advancing threat.
more.
You generally assume the worst.
There you
And
go.
you don't know, for example, if this person, whether they know martial arts or they don't, or they're bigger or smaller, might possess a firearm, which would, of course, be the great equalizer. So you would want to consider the worst case scenario. You'd want to watch the hands, for example, and make sure that they aren't reaching for things perhaps that are now concealed to you.
Well, they're conflating different things. You can't just assume somebody has a gun and treat them like they have a gun.
Yes,
But
for
you can
sure,
certainly watch their hands and see if it
evaluation
appears they're
of
reaching for a
all
weapon.
of those circumstances under threat.
The reaching for a weapon is actual
make
evidence
you
from which you're making
assume
an
the very
inference.
worst
It's
and
not a
prepare
mere
for the
speculation.
worst. Sometimes that preparation may be running away if you have an outlet. Other times it may be that you're forced to engage because there's nowhere else to go.
Okay. And you talked about martial arts, and I know your background in martial arts. So I guess you know the answer to this question. Can a fist cause an injury worse than a bruise?
Oh, yes.
Can it cause a laceration?
Yes.
A cut, in other words, how about a broken bone?
Yes.
Can a fist kill?
Yes.
And does one necessarily have to be trained in martial arts to be able to inflict those sort of injuries on another person?
No.
The risk assessment, what does that mean?
Risk assessment is really trying to determine what the risks are regarding the actions you're about to take or that you feel that you've settled on. And so there are other things that we started to talk about that need to be taken into consideration. For example, maybe I decide to engage in a fight because I'm left with no other options. Can I take you? Am I capable of actually prevailing if the two of us were to engage in a fight? I'd want to look at how big you are. I'd want to look at how big I am. I'd want to take a look at perhaps your apparent knowledge of fighting versus what I know about myself. I'd want to think about things like injuries. If I have an existing injury, or sometimes the injuries are temporal. For example, let's say we start fighting and you throw me to the ground and I break my arm. I'm certainly not the same person that I was just a moment ago. Now I may choose that I'll disengage from the fight and run away because I don't have that same competency that I had just seconds before. So all of those features that are not only intact, like, for example, your age, your size, but are also temporal, like, for example, your fitness level and your
My fitness
injury
level is
at
not
the moment,
temporal. It's
have to be
permanently low.
weighed into the risk as to how you will proceed with the very next step.
So once you've determined, based on the totality of the circumstance that we talked about, that a threat is present, now we're doing a risk assessment, as I understand it, correct me if I'm wrong, we're doing a risk assessment to determine what the appropriate next step is.
Right, what your next course of action will be that will result in the best outcome for you.
Now, when you talked about, you gave that example about, well, you know martial arts, and so you're aware of what your capabilities are.
That's correct.
You also said something to the effect of, you also may know what your limitations are. For instance, yes, I know martial arts, but I wrecked my shoulder in the gym or something like that, so I know I have some weaknesses. So is that what's called self-efficacy?
Yes.
What does that mean?
Self-efficacy.
You just explained what it meant.
Is the belief that you are capable of handling a task or not, and to what degree you're capable of handling that task. So people have a certain feeling about themselves when they take on any task, not just fighting, but any task, whether you're going to climb the big mountain or you're going to go on the bicycle race or any other, for example, sporting event. There's always a level of self-efficacy that should be improved if you're going to engage. And if you're not capable of improving it, you are at a disadvantage.
Okay. And is that, I heard the term perceived limitations. What does that mean?
So everything is based on perception. Everything that I spoke about is based on what your calculus of, for example, the environment is, what your calculus of the person's abilities are, what your calculus of your own abilities are. Certainly no one has a crystal ball in this. No one knows how this is going to end. So what we do is we calculate what we
Every
think,
gypsy in the room just groaned.
will give us the best advantage in any type of a competition. If that competition is for medals or that competition is for life or death, it is pretty much done the same way. If I'm going to engage in this, I want to make sure that the advantage goes to me. And so I want to look at the efficacy of myself to determine whether or not I'm up for the task.
Okay. So now an individual is doing I guess, kind of a risk assessment on his own situation. That's something you teach in police academies?
Yes.
Okay. And to civilians?
Yes.
And what's the purpose of kind of, I don't want to say setting a formula, but of giving these criteria, because certainly they're flexible. Is that true? Do I have that right?
They're flexible. Yes.
Why do you teach these things?
Well, it's a dangerous world. It's a violent world. And a lot of times people find themselves in very dangerous or violent situations. And if they aren't prepared for that, they can be terminal situations. It may be the last thing they ever do. So I think
Terminal A, B, or
instructors
C. I need to catch a
are
flight.
not attempting to teach people how to fight or even when to fight, but what to do if they find themselves in a fight. So it's generally what we refer to as defensive tactics. It's defensive in nature.
So is it fair to say the closer a threat is to you, that you
Like
are in a
whole entire row?
An entire row ahead, an entire
the distance
seat
has always
over.
been the great equalizer when it comes to advantage. Even with a firearm, if you get far enough away, then you won't be shot. It's very hard to hit a target that's much smaller, for example, that's off in the distance. Certainly, as you get closer, if we put our weapons away, for example, and we start to use hands and feet, we certainly want to be outside of the range of those hands and feet so that we're not subject to the reaction time principle of being able to recognize the threat and be able to properly respond to it.
And so with a shorter distance, now it sounds to me like what you're telling me is that there are more options for the threat to cause harm. In other words, now the hands are an option if they're close enough, right?
Yes.
And we've already discussed that can cause serious bodily injury.
Objection, asked and answered.
Okay.
You should get there again.
Yeah,
Make
I would
them
get there
object
again.
Make them object that fast every time.
Yep.
Tell the jury.
Let's talk
There's ways
about
to get there
the
again.
action distance gap. What does that mean?
So, based on your experience and training, what's the manner of death or from a barehanded attack?
About 0.25 seconds. The
That's
amount
not
of
asked and
space that
answered.
you can cover in a given amount of time based on that constant is the baseline for so much of what we do in self-defense and defensive tactics. For example, in law enforcement, it takes time to draw a weapon out of a holster. You want to make sure that somebody is at an appropriate distance. If you're even going to attempt to do that, that you can actually get the weapon out before being completely consumed by that person because they've closed distance so rapidly. In other
What if there's
occasions,
a
if it's
theater chair
hand-to-fist
between you and
fight,
them?
as
Does
I
that
said,
buy you
wanna
extra
make sure that you
time?
turn every action into a two-step process, not a one-step process. What I mean by that is if somebody throws a hand at you, you want them to have to shift their body close enough to cue you that that hand's coming, to give you the reaction time, because it's going to take about 0.25 seconds to even realize they've moved. At that point, you can assess that movement and you can incorporate the appropriate defensive response because you've given yourself enough time to do it. If you stand toe to toe and there is no forward movement, the first recognition of being hit is usually being hit.
Okay. And I know you talked a little bit about stress factors, and I know that your study, your dissertation had to do with that. Tell us, in a situation where there's a threat has been perceived, tell me how stress factors into that.
So again, it goes back to what your coping mechanisms are. If your coping mechanisms are not adequate to deal with that particular threat, your body will start to do things that are not within your charge. They will start to, as I said, excrete various hormones, stress hormones in your system, catecholamines we call them, that will change the way that you feel. It will change your perception. It will, in some cases, give you more endurance. It will oftentimes give you more strength. These things that I think laymen call adrenaline dumps. That's really an epinephrine or dump that is a chemical response.
Same thing as adrenaline.
To fear. It's usually motivated by a part of the brain that is out constantly monitoring for threats. And so those physiological changes will start to occur, and it'll oftentimes change your ability to do things like, for example, think.
Okay. And are there certain physical manifestations of stress?
Yes.
Can you tell me about some of them?
You're talking acute stress, not chronic stress. I mean, chronic stress is a different
acute stress
area. Acute stress that is sudden, ongoing, and the expectation is that it will be over soon. Some of those things that will occur, and I'll keep it on danger. We'll stick with danger. Is that you will, for example, have a narrowing of vision, something we call tunnel vision.
Let's talk about that. What does that
mean? Oh,
it means
please.
that your eyes actually start to close in. The acuity of your eyes start to see the threat acutely to the degree that you can't see anything around it. It's often been described by people who are in very stressful
It's amazing how
situations as
boring
looking
and expert
through
witnesses
a
can be.
paper towel holder. I think that's perhaps the best image of it. I know that there are circumstances where individuals have been so stressed they've described it as looking through a soda straw. So when it's a
Who
problem.
looks through a soda
for threat
straw?
assessment, when your eye can no longer see things outside of that direct threat. And it has everything to do with the amount of arousal, is the word we use, that you're experiencing based on that threat. And so that would be one of the features.
I am aroused by threats, actually.
Impacts somebody's perception.
Yes.
I'll impact your perception after I get aroused.
In terms of anything else, such as narrowing of attention, what does that term mean?
Well, attention means, of course, when you are doing your threat assessment, you want to be as attentive to the environment as possible. You want to see all things. You want to be able to analyze what's important in the environment. You want to be able to gate out the unimportant things, the things that are not threatening to you, so that it's not distracting. It doesn't cost mental energy. It doesn't cost attentional resources, is what we call them. And once you can focus on the important things in your environment, then you become more acutely tuned into those things, but at a cost. And the cost is if something changes in the environment and you are already starting to experience
Not
tunnel vision,
boring,
you may
shut
not
up.
see it, depending on your level of
Past
arousal.
couple days have
So
been
there's a
pretty
fine balance
slow,
between
just
wanting to
saying.
be very focused on the threat that you understand and the ability to vacillate things in the environment that might also be threatening to you, that you'll want to see in the event that they suddenly turn into perhaps the bigger threat.
Okay. And the term distortion as it relates to manifestation of stress?
Jimi Hendrix.
So perceptual distortions means that you'll actually see things differently, you'll hear things differently, you'll feel things differently, you'll experience things differently. For example, you may experience slow motion timing in a very stressful situation. In some cases, you may experience that things are farther away than they seem. In other cases, you may experience that they're closer than they seem. So your brain kind of plays these tricks on you a little bit and gives you these distortions in perception that other people are not experiencing around you. And you'll see very different, for example, testimony that comes from individuals, the one who is actually under the threat versus the one who is merely observing the threat. They
How
will
about
explain
that?
that circumstance very differently.
So that doesn't make it any less
How about
real
what?
to the person that's being threatened.
No,
Different people will have different perceptions
Now,
under a stressful event.
Oh,
right?
yes.
Like the,
To prepare for this case, you reviewed materials like reports, interviews, videotape.
Yes.
Let me talk a little bit about that. On the videotape, you could see an event that appeared to be the throwing of popcorn and the firing of the firearm. You remember that?
Yeah, among other things, but yes.
That's fine. And then between the time that the popcorn bag was thrown towards Mr. Reeves' face and Mr. Reeves fires a shot was approximately 0.72 seconds. You remember that?
Yes.
And so in looking at that sequence, let me ask you this.
0.72.
You've looked at the video with the timestamps, right?
Yes.
Okay. And have you formed an opinion as to whether or not Curtis Reeves discharged his firearm in response to Mr. Olson throwing
Objection.
the bag of popcorn at him?
I did formulate an opinion.
And what is your opinion?
There it is.
Sorry.
Approach.
Knew that was coming. Oh, they definitely don't want him to testify what he's about to testify, that would be too fast for him to draw or to react, draw, and fire. He has to perceive the threat, which he's already said is about a quarter of a second. Then he has to draw a gun, aim it, and fire. And it's all happened in less than 7/10 or in about 7/10 of a second, I think he said.
well, that would be about right. That would be quick.
Yeah, well, he's going to say it can't happen.
Right. Yeah, so the objection is going to be, well, he's trying to read Reeves' mind, that Reeves shot in response to the shotgun. He's going to say, no, I'm trying to show that the time in which it happened is too brief for the popcorn to have been the cause, the driver.
Mm-hmm. And
Which
the
is not
judge is
reading
gonna.
Reeves' mind.
The judge is gonna roll a 6-sided dice, and if it's even, she's gonna smoke a cigarette, and if it's odd,
She'll
she
eat
might.
it.
Yeah.
I'm gonna swallow this magic 8-ball, shit it out, and see what it says.
Oh God. You find it interesting? I find some of the stuff interesting. There's just with expert witnesses, there's so much that is not interesting that to get to the interesting nuggets. This guy's been no exception. I'm also exceptionally tired, and the first 3/4 of this day was really boring. Oh. Curtis is like, well, here I am again. I'm just going to stare at this bailiff until the trial's over.
Hey, baby, call me maybe. This may sound crazy.
Yeah. I just shot Chad, and this is crazy.
Do you have an opinion as to whether Curtis Reeves discharged his firearm on January 13th, 2014 in the movie theater in response to Mr. Olson throwing a popcorn bag? Do you have an opinion as to that?
Yes.
And what is your opinion?
That's not why he discharged his firearm.
What do you base that opinion on?
Yeah. That's it.
Wow.
Nothing further this time.
Nothing further at this time.
They didn't want to explore that.
Yeah. Do you want me to, are you going to go outside or you want me to?
No, I just need to scoot around here.
Okay. All right.
Well, that was that went a lot faster than I thought it would. I thought he would go into the timings, explain the timings a little more thoroughly. They just wanted the punctuation, which is probably fine too. What do you think? I think I would have gone further though.
Yeah, I don't know. I mean, we don't know to what extent he's limited because we can't hear these sidebars. But I definitely would. I would have asked him, "Why do you say that?" And so there's a rationale for why that's impossible, because certainly the state's going to argue the opposite.
Right. And well, can you read his mind? How do you know that? What is it? No. It's
The
just
state will get up there and say this expert can't read his mind.
Right. And he needs to say no one can make that shot. It's too fast. You would have to be an expert already moving for your gun. He would have already made the threat assessment if he's able to draw his gun that quickly in response to that stimulus.
Yeah, I would have made it much more concrete.
Cynic says he wasn't allowed to explain why. I mean, well, that's speculation. Maybe he wasn't, but that doesn't make sense. If the judge is going to allow that question to exclude any potential follow-up, that'd be crazy. It's not impossible, I guess. This judge is weird. Does weird things. So now we get to see them brainstorm. Okay. Martin.
Still afternoon. When did you start training police officers?
In 1987
You must have said this would be short.
at the
Hard Cross now.
and Lively Law Enforcement Academy.
And then subsequent to that was in service at the agencies you were at?
Well as I continued on with what later became the Pat Thomas Law Enforcement Academy. I continue to teach there.
And where is that?
It is in the same location. It is actually the same building. It was just simply taken over by the Tallahassee Community College rather than the Lively Vocational School.
And when was that?
I'm sorry?
When was that?
Oh, God. 89, maybe, in the late 80s.
And the teaching that you did was at those particular universities that you previously discussed, along with the agencies that you were with?
You're talking about the earlier testimony? Yes, I've taught all over the world.
No, I'm talking about the earlier testimony when you began teaching.
When I began teaching, I began at the Lively Law Enforcement Academy, and I continued on without break as it transitioned to the Pat Thomas Law Enforcement Academy. I still teach there.
Pizza Girl, the judge was asking if he wanted to go outside because she needed to know if she needed to dismiss the
Will this
jury.
witness be released?
Yes, Your Honor, he's on standby.
Okay.
That was it?
That's it.
You're free to go. If you get called back, you have to come, but I'm sure they'll give you plenty of notice.
Okay.
Thank you.
I called it. Not very hard to predict, admittedly, but
Counsel approach.
They're going to dismiss the jury. We're going to be done for the day in just a minute. I'll finish up reading super chats. Andrew War Snowboard says, the reality is the only woman who's ever had the upper hand on a man in athletic competition in China of the WWE. Yeah, I don't know about competition. Lido Enchanted says, Nick, what are you talking about? You power lift that nose every day. Eli 580, did I miss anything today? Well, I mean, again, it's another day with 8 hours of nothing and then a half hour of something, is at least how they're feeling to me lately. But what we just got there at the end is good stuff. The expert saying, no, he didn't do that. But I wish they would have gone further into it. Because I think, the jury can just say to themselves, and they could anyway, but jury's like, has no idea why he would make that or what his expertise has informed him about that assessment that he made. So I don't know, but and the prosecutor didn't cross on it at all. So I think they're not so worried about the statement either, which is weird because they were concerned about absolutely garbage in other places. Randall McCollum says, this is a 21st Amendment issue. The stupidity makes me need a drink. Racket's missing taste buds says 74p in English coin chin chin. Oh, wait, dropped a chin somewhere. Okay. I don't know what that means. Let me get back to where I left off in the chats. Okay, come on. Where are we? Oh my gosh. Okay, here we go. Very close now. Caligulov says, I have a feeling that this prosecutor hasn't been punched in the mouth.
All right, ladies and gentlemen, I don't know about you guys. Maybe it's just Wednesday, but I feel more tired than if it was like 8 o'clock already. But it is 5:16, I believe, according to that clock, a perfect quitting time for this long day. So we will start up again tomorrow at 8:30, and we are in good shape all in all, as I indicated it for our finishing by the end of the week. So, all right. Remember my instructions during the recess, please. No independent research. Don't talk to anyone about the facts of the case. Don't talk about the facts of the case amongst yourselves or anyone else, of course, and don't watch the news. And have a great evening, and I'll see you in the morning. Thanks, everybody.
All right. There we go on that. I'll leave that up in the background just in case anything happens. Okay, I'm going to burn through super chats because I think we've all been here long enough. I don't know about you guys, but I'm feeling like the judge, very, very exhausted. And I think, it may have had something to do with the, 2 hours of argument they had over that, the other witness. And then the hour over this witness.
Yeah, an hour over Bedard.
God, it's insane. Ben Ogle says $5 for you to do a quick Google search of Sig Hansen from Deadliest Catch. Video makes it even better. The same mannerisms. I get it. Looks like the judge. Mad Count Mark says crying video. Did that. Black Tiger 001 says the judge has Steve Irwin's haircut. It does. Yes, she does. Backgoat says it's -2 in Prior Lake. Boom shakalaka. Yakimo says, how do I get an I Doubt It shirt with the picture of your inaugural Rumble thumbnail on it? I need to talk to the guy who made that, my editor who made the graphic, because I need a higher res version of it, but I'll see. Healthy Papa, Healthy Palapa says, you all make me laugh, although after some days of watching, I have to go to confession. I just can't stop watching. Have a wonderful day, you filthy animals. Bad Weather Biker says, Andrew Branca joined Law of Self-Defense yesterday. I am recovering K-bike owner now on a Super Tenaire. Safe riding.
Nice bikes. I like the K bikes. They're super fast, but my bike's an R1250 GS Adventure.
Stephen Cabrera says, just had a fire of police report. Apparently someone broken a bunch of cars in my neighborhood and mine was one of them, but didn't get anything for me, but got a gun down the street.
Please don't leave guns in your cars, folks.
Udai Manista says, ever noticed after months together, You guys never say each other's last names correctly. Andrew.
Ricada.
Ricada.
I got it.
Ricada.
It took me a few months, but I got it.
And I say Branca now
That's
as much as
fine.
possible.
Yeah.
I sometimes say Branca, but I try not to. Ride safe, Andrew. Ginger Hermit says emotional damage. Torque Hammerwolf says, since you have their ear, can you tell Rumble to add PayPal support? I hate putting my credit card into websites. Citation, give, send, go, data breach. I can recommend it. I don't know if they'll be able to do that or not. Daniel Turasevich says he looks like the guy from Hannibal. Barry Dworak says, has Branca ever said folks of the jury? Michael Kennedy says, I think Chinless just wants to use a blow-up sex doll. Very possible. Torgo the White says, judge actively decomposing Steve Irwin. Matt Hagen, what year do you think the judge lost her last brain cell? Richard Tybold says, if you don't know the defendant's perspective, how do you disprove self-defense or even charge in that matter? It's a good question. Akikira says, starting to sound like Matt Harris. How dare a Binger say mannequin and womanikin is representative of a RoboCop blacklighted cell phone throwing Chad. Aiden Ramos, it's a standard Andre the Giant mannequin, Your Honor. seven feet tall, 368 pounds.
Animatronic.
There will be no survivors. 200 Watt Studios is Michael Knox. Common spelling, but my wife calls me Hard Knox, if you know what I'm saying. William Andrews says, Knox in box, Fox in socks, Knox on Fox and socks in box, socks on Knox and Knox in box, Fox and socks and box on Knox. Thank you for that. Preston Barnhill says, this guy kind of looks like and has the mannerisms of Ron Soye. Gross. QGG639 says, maybe the clicking is her making someone's good behavior like I do with my dog. Hawkins 75 says, think the clicking might be a way of telling the lawyers to move along. No, I think she's just distractible.
I'd feel better about it if it was.
Expos Fatso says, Parker Brothers retractable. No judge can click just once. Kate 4394 just ordered 6 hard books and 3 different state DVDs.
Wow.
I'm so hard that I don't know what to do with myself. Also, click, 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 click. Very cool, Kate. Thank you.
Well, if you stay hard more than 4 hours, you know what to do, right? Order a mug. lawofselfdefense.com/mug.
Grammartron 3000 says 380 is for weaklings. Real Chads use 50 BMG. G says, tell Branca it's literally snowing in Dallas-Fort Worth today.
It'll be warmer next week.
Wolfgang says, question from at T3. Can you explain jury of 6 versus 12? Did they choose it? Pros of 6. The defense likely did not choose it. Florida only has jury of 12s in capital murder cases. Otherwise, you get 6. Ex post fatso says there's no pro of having 6 jurors as a defendant. You always want more jurors.
Always.
Ex post fatso says, when is sentencing for Theodore Edgecombe? I don't know. Mars R1970 says, this will not be quick, nor will you enjoy it. This is Sparta. Cole Jewell says, Branca is the Dr. Drew of LawTube. Kyle Bogue says, let me see if I have this straight. So nobody did their jobs investigating this incident properly. So send a 78-year-old man to prison? Seems fair. Justin Filson, thank you for the donation. Ryoji Mata says, in Chew voice, if you ask one more sidebar, I'm going to bend you over and shove this gavel where the sun don't shine. Kevin Speaks on it says the sidebars have to be in hours overall. Effing nuts. Borowski got mad over a grand total of 13 minutes of sidebar. He's like, can we go to your chambers, Your Honor? No. Do it here. Get it done. I'll send the jury out. I'll send anybody out. I don't want to move. Justin Filson says, imagine Chu on trial for making a mistake on her rulings in the Kim Potter trial after Kim is killed in jail and they use her own rulings as precedents. Yeah, except judges have immunity from the results of their judging, I guess. Not applicable says, I love Galaga the way Rontoye types, the way Rontoye loves penis a lot. Viking Hundle says, does own the law of self-defense make any defender weaker? No, it makes you hard to kill, hard to convict.
You do have to read it.
Really? Is that my problem? I thought you just like taped it to your body and it stopped bullets.
I don't care if you read it, but if you want to benefit, you need to read it. I only care if you buy it.
Rumble username sucks says, redo the Chew gavel comment in Borowski's voice. Embellish as you please. If you idiots ask me for one more sidebar, we've had hundreds and hundreds of hours of sidebar at this point. I can't deal with it anymore. I will bend you over and shove this gavel right up your ass and make you eat the fish in the lunchroom so you die from it afterwards. Don't do it again. I'm tired of it. Your paralegal is out. Get her out of the courtroom.
Ashley,
now.
Get the fuck out.
Kevin Speaks on it says, Juviw had JUVIW had Oregon Trail. Buddy had Leisure Suit Larry. Petey Warren 0829 says, when the prosecution loses, is there a way for the widow to seek damages since her lawyer isn't what's wrong here? She already sued, I think, years ago, right?
I don't know if she sued Reeves. She sued the movie theater manager, and I think one other entity, but I don't know that she's sued Reeves yet. But yeah, you can lose a trial. Reeves could lose a trial and still be subject to civil liability. Sure. Look
I
at
think
OJ.
she's got to be beyond. Unless she noticed it and they've continued it out, she's got to be beyond the statute. Wrongful death, Florida, 6 years, or is it 10?
No, but I'm sure she would have put him on notice. She would have told the statute. She's not going to. I assume.
You'd hope, especially if they had the other trial.
If her lawyer failed to toll the statute, she'd be suing him.
Right. Volpe Fox says, congrats on Mr. Beast and condolences on the Parkinson's. Love you. That wasn't Mr. Beast. Not applicable says, get some rest, buddy. Don't burn out. Well, I'm not going to burn out. I'm just going to fall unconscious when the testimony is like it was today. Whew. Or well, there just wasn't testimony. There was Martin. It's him. He's human Ambien mixed with depression. Oh God. Distro 32 says the testimony will continue until the verdict improves. Not applicable. Don't exercise. Too easy to fall off. Walk first. Tyler Mueller says Branca. He spelled it Branca, Brenka, is 380 similar to the Russian 9x18 caliber?
I think so, but I'm not sufficiently familiar with the Russian caliber.
Colin Helmuth says, could postmodernist teaching be part of the prosecution's problem? There is no truth except for their truth, of course. No, I don't think so. They're just trying to win. Wolfgang Deo, if you want to find out, if you want to fight and I do not, then I will end it as quickly as possible. This is civil society, not a boxing ring. As such, not guilty. Salty Pop. DCV Titan says, I was starting to lean for Curtis being innocent, but now I'm firm guilty because this agree or disagree means it's not leading. Judge still lives. Kakasha says, in my opinion, if Curtis tried to get up or leave or engaged in first fight, Chad would have severely beat him as he tried to stand up. Yeah, I think that's pretty safe assessment. Jonathan Anderson says, I get that he's the popcorn shooter, but has anyone really been far, even as decided to even go want to look more like? Very important. Trashman says, my problem with Kurt's hypothetical is that you don't need it to be deadly force. It's deadly force or great bodily harm. Blue-eyed roof. I don't think Kurt was making that problem. He was arguing as how the prosecutor should approach the issue. He wasn't making the statement himself. Blue-eyed roof Korean base says, I find the lack of trans representation in U.S. women's soccer disturbing. Who is allowing the transphobic women to gatekeep the U.S. women's soccer team? Eldridge Blasted, the entire men's soccer team should transition to women and then play as the U.S. team in the Women's World Cup. I'm with Drex. These women wanted this. AWM Fishing Gaming says, have the women's soccer team play Iran's men's team in Iran as their first quest for the cup. Wolfgang Deo says, BS Nick, as a sailor, I sweep better than a woman. You know what they say. ATN Falardo, welcome to Paralegal. Jordan Wolf says, wake me up at closings, lol. Tim the Ancient, is there a financial incentive for a defense team to hire a lot of expert witnesses? Kind of like a mechanic recommending a bunch of extra stuff for your car. No, not really. I mean, there could always be some theoretical incentive, like some illegal kickback scheme or whatever, but presumptively no, outside of some specific thing, no. Neighbor 605 says, yesterday's 8-hour stream I watched in 4 hours by playing it at 1.5 speed and skipping all the approach the judge moments. Sadly, today I'm watching.
I wish
live.
I could have done that.
Same. Eldridge Blasted says the Reeves trial feels like a filler arc in an anime. No, it feels worse than that. It feels like I accidentally turned on the Hallmark channel and my remote ran out of batteries immediately after. Matthew Carberry says, so who is Mike or Joel? Who's Tom Servo? And who's Crow in this MST 3000 law knockoff? I don't know. I'm just so tired. Courtney B, thank you for the donation. Neighbor says, prosecution, why didn't you use a furry love doll? Stephen Cannon says, this trial makes me crave some hot theater popcorn. Mayhem 41, Nick, I've been accepted to study law in the UK today. I was unsure about what career I wanted, but your streams really got me back into law. Thanks. Hey, you're welcome. Sorry.
That's a mistake.
Sorry.
Law's
go
not
get
much
it,
like these streams.
go get it. People versus Preds. Dad, stop yelling. No. The end is near. Beware. Defense attorney in middle looks like an old mini-me. Cameron Nelson. Thus, this money is for a hard F word, please. Carry on. Fish. Kyan Rennell says, thoughts on Dante Wrong's family criticizing Mommy Chu? No, Chu deserves all of the criticism she gets from both sides. All of it. Because she could have easily resolved this with a judgment notwithstanding of the verdict, or a directed verdict for not guilty earlier in the case,
or
she
corrective instruction at the trial.
Right.
She could have done that.
So then, and she feels something about it because she made that very performative statement at the sentencing hearing. And it seemed to indicate that she felt somewhat responsible for what happened. That's on her. That's on her. The end is near. Beware says Mini-Me mixed with Mr. Bean would be more accurate. Boojalicious says this is torture. Do you think Chinless and the state are just trying to run up the bill on Reeves' attorney hourly fees and break him financially? After 8 years, I don't think there's any illusion. He is already broken financially, most likely. Kyle Bogue says, please God send an asteroid towards D.A. Chinless's house tonight. Wolfgang Deo, waste of a super chat to piss off Zach Weber. See our music videos. I feel this prosecutor would benefit from wearing a bicycle helmet, but the chin strap would be obsolete. Oh. Dave Bradshaw, justice be damned. This trial will end when Curtis runs out of money. Not a good look for the court system. Bob Lagai says Reeves looks like he'd go back to NAM if it would end this discussion. Igor Ivanovov says, could the defense have somehow watched the stream? Have someone watching the stream and use the points that you're making in time? I mean, in theory, but probably not. Wolfgang Deo says, Nick, you read my super chat? I did. Neighbors, all these people at court today are unbrancad. Josh Vermillion, would all this BS from prosecution and how the judge keeps going back on her rulings be good for an appeal if found guilty? We need Borowski. And not really.
And again, it doesn't matter. I mean,
yeah, he'll be dead.
He'll be dead.
Leaf Me says, remind me about the platinum plan when I'm out of school and have a job again, Lamau. Tortheo says, if Reeves doesn't testify, can the prosecution bring it up in closing because defense promised that he would in opening?
Yeah.
Ed and Steph says, please do a survey asking if Judge Bartle is a coos. Barry Dworak says, what's a foreskin continuum? Force continuum. Got it. Okay. Thank you. Thank you for doing that to me. Joe User says, is it normal for a prosecutor to just make shit up when arguing emotion? Yes. Yes. Crusader says, pole vaulting favors women's physiques. True. Koi 540 says, if law and crime were smart, they would just mic up the court reporter's keyboard every trial to prevent you from watching their content. Cloud9 Ninja, enjoying a deliciously breaded triple-decker PB&J this afternoon because of you, Nick. Jam, salted butter, and chunky peanut butter. Oh, enjoy. That's so good. So good. Soul Fiend says, every time I hear them ask their profession, all I hear is Spartans. What is your profession? Provolone Loaf says, got hard with State Stream Special. Branca, is the Oregon coverage just you laughing for 2 hours and saying you're effed at the end? If not, refund me. Is that what it is?
No, it's actual Oregon use of force law.
Oh, shoot, I missed this earlier. OMG, it's Dana. Says, has anyone else noticed the judge stopped giving the, quote, I don't want to waste a single minute of your time speech that the jury was getting at the beginning of the trial? Even she knows this is an egregious waste of time. Jay says, just getting caught up with today's stream. Oh my God, captions during the doctor's testimony is cracking me up. Unbreaded. Senor Why Me says, Trudeau revoked the Emergency Act right now. He knows he is politically toast. Well, they got rid of their emergency, right? And now they're going to look benevolent by giving back power or ceding power back. Not applicable says, what do you do if Ron Toye isn't suking some dude? Catherine Rux says, gah, are we there yet? Is it over yet? Soon. Seagoody 564 says, Ricada Law burkas in the merch store. When? I don't know if they sell burkas. I have to check. Kyan Rennell says, watch yourself, Nick. My 80-year-old mom is 92 pounds. I can kick her ass. 200 Watt Studio says, Odyssey really loves Branca's fat jokes. X Post Fatso says, does D.A. Martin have a Fosse chin? Mandy Karavichus says, Branca might be able to pull off a better Kermit impression than you, Nick, in Kermit voice. I doubt it. Jordan Wolf says, Edgecombe sentencing is April 8th. So there's that. And I think there's just a couple chats on Odyssey, and then we can go for the day. Great US says, suggestion, crowdsource on a local's pinned comment by Nick. Branca burns to help out law nerd clips. Get them out to make the world a better place. E.g. Golden Corral, LLC from Canterbury lawsuit. You can tell who the new girl is. What? Only 1,000 calories per day. You need to step it up. Great US also says, reality reminder, the greatest woman boxer in human history lost to an amateur in Australia. Before this, leftists, aka leftards, were promoting how equality of the sexes was finally going to arrive. Crickets after she lost. Great US says, please, for the love of Mazda, pass on that program from Steve Crater to Viva Frey. So he has one less thing to be neurotic about. Let's see. You would charge him and pass on some of the money to Steven. Well, I think he already has it. I think Viva already has it. Great US says, News League of lawyer from small firm in central Minnesota attempts to mass murder his audience with mind-numbing testimony for 2 days straight. Oh, shit. For 2 days straight, some chatters from Stream have stopped chatting. Police investigating. YouTube mods still suck each other after doing Jack Murphy. Ken's Counseling Couch says, take freedom in your hands. Learn to 3D print guns. Print lowers of many kinds, or take on the FGC-9 or fuck gun control 9mm, which is 90% 3D printed, and the barrel is rifled in a 5-gallon bucket. All printable on a $200 printer. There you go. Very cool, man. Publius88 says, a woman can beat men at long-distance urination. There you go. This is not something, says, sport that favors women. Gymnastics, both mental and physical. That's pretty good. Liana says, are they trying to challenge everything they can because this shit happened 8 years ago? Yes. Jelly Mist, here's an idea. Have the prosecution point to something from their investigation that shows a silhouette photo can't be exactly what Reeves saw. Never mind a good enough reproduction. Then we can talk about excluding it based on all the investigations of the state. And then 12345 says, my name is not Jeff. Okay. Finally, Crusader Saracen says, a hero is the last thing he wants to be, but lawyer Andrew Branca will need every gun to survive this one. Branca stars and Get Hard 2. Get harder. Zap3 says, listen to the SCOTUS hearing today. What is an APA motion? Out of context, I have no idea. 200 Watt Studio says, Drexel drinking stream tonight, Nick? No, Drex will be here tomorrow. Drex will be here tomorrow, and I'm not sure I'm going to do a live stream tonight. I might do Twitch or something. Stay tuned. That's it, folks. That's the show. Andrew, thank you for being here, even though it was really, really, this has been a tough week.
Thank you, Nick. And back again in the morning.
I'll try and be on time.
All right. All right, folks. See you all then. Have a good evening. Stay safe.
See you guys later. Have a good day. Peace. Peace. Oh, wait. I clicked the wrong thing. I was trying to take a nap. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lubroy, the spirits flow as the ones who get unemployed. So pour out a glass for the team post on Twitter as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all planet folks from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. as we hear lost blaming tonight. From the wide shores of Nairn to the hills of Glenlivet, there's no one who explains the dog better than Nick. So pour out a glass for the ones who have passed to make the law